to grow outside the courthouse there in Fairfax, Virginia, as they line up overnight to get one of those coveted tickets so they can go inside the courtroom. One superfan in particular has been first in line nearly every single day just to have a chance to blow kisses at Johnny Depp. We're going to hear her story in just a second, but first, let's go live to the courthouse, and there's the SUV, Johnny Depp hanging out of the window, acknowledging the fans that are camped out there. It's been raining. Didn't stop the fans. Let's listen in to see what Johnny says to our cameraman, Austin Brady, this morning.
I hear it might rain.
Johnny Depp inside the courthouse. Now, to his fans, and that one fan that has gone above and beyond in terms of dedication, our Court TV crew caught up with her and has a look at her story and a look at what all of these fans endure each and every day just trying to get into the courtroom.
We're doing a number system to keep everything nice. It's not official, but it's for us. So everybody stays in line, and then we'll get the wristbands.
Why is it so important for you to be the first? I mean, you could be number 50 and still get in.
I wouldn't be happy. I've loved him for 36 years. I know him personally. I'm here to support him. I did a lot of sacrifice to be here. I gave up my whole year vacation. So it's important for me that he knows I'm there. He sees me when he comes in. We blow each other kisses. We smile at each other so that he knows I'm here. He knows I'm sitting behind him. That's what I want. I just want him to feel he's special. I'm here. A lot of supporters are here. He's not alone. And we're here for him.
But this is only Monday, or the Sunday before Monday. You still have a whole week ahead of you.
I've already been here for 4 weeks. So it's important for me to be here for this week. This is an important week, so I want to make sure I was here.
But you're going to have competition this week. This is a big week. We have rebuttal, we have closings, and we have potentially a verdict.
Exactly. I realize that, so I just have to put in my time, be here when I can be here, and do my best I can. It's just how it is. If I can be there, I'll be there. If I'm a little back, that's what it is.
But you're going to be here every day this week.
Of course.
And how does Johnny Depp show you that he appreciates your support?
He always, not just me, but all the fans, he's always doing this to thank us, or he'll put out a press release thanking us that the support is fantastic. Like I said, he blows me kisses, I blow him kisses, he smiles, he'll do this. So he's got lots of ways. He waves at everybody in the courtroom. So we know. He doesn't, it's the unspoken word. We know.
Yeah. Okay, so, you've got some Johnny Depp paraphernalia. You want to show me what you have?
I got two.
You got two?
I got two.
Show me.
Here's one.
Okay.
You know I always do.
And how did you get this?
This picture was taken 3 years ago at the Greek Theater in LA for a meet and greet for Hollywood vampires. This one was taken 3 years ago for Alice Cooper's Christmas Pudding, which is a charity that he does every year. Now, usually Johnny will perform, but because of the case for the last 3 years, he's been unable to attend.
Now, he may not be here for the verdict because he has previous engagements, right?
That's correct.
So are you going to go to Europe?
I wish. I'm going to Europe in July to see him with Jeff Beck. I would like to be there to watch him start filming. He's going to be playing Louis XV in July. I don't think I will, because I don't like to intercede or intrude on his privacy and his filming. I've never been to a film set. But I will go see him with Jeff Beck, and then I'll come back.
I guess knowing that you support him, how important do you think that is for Johnny?
Extremely, because he spent 6 years of his life with people bashing him, accusing him wrongly, calling him names. And he's not in there for revenge. He's there to clear his name. So that's all. He doesn't care about the money. It's a defamation case. So for him, he's already been lowered completely. He's lost work. He adored Captain Jack Sparrow. That's his creation. And now he doesn't even want to play him if they would ask him. And that's very sad. It's very sad what he's been going through. So I know it's extremely important that he knows people still love him. We care for him. We believe in him.
All right, that's Yvonne outside the courthouse, as she is every day. Melissa Redmond, as we approach the top of the hour here, let's set the stage. This is a big day for both sides. We're expecting Amber Heard's team at some point to rest its case, and then it's time for the rebuttal. What are you looking forward to most?
I think they want some distance from that last expert witness, honestly, the psychiatrist. So I think they may put up anyone, to get some distance from the testimony yesterday. But they do have to end their case strong. You never know what's going to come up in rebuttal, whether or not they'll get a chance at rebuttal is up to the judge. So you want to really count on today, if you're resting your case, it being your last opportunity to drive home your case to the jury. So you do want to end as strong as possible. So I'm not sure what witness that could be, but I would, if I'm Amber Heard's team, try to call a strong witness to end our case in chief today.
Well, there's that outside chance that their last witness is Johnny Depp, the same last witness that we expect Depp's team to use yesterday at the end of court. Elaine Bredehoff said we haven't made a decision yet on what we're going to do with Johnny Depp. We'll wait and see. We're just a few minutes away when all that will be revealed. So what are we going to do? We're going to, of course, take a break right before the top of the hour. There's a live look inside the courtroom. Johnny Depp in his seat. Amber Heard over on her side, and the courtroom is packed as always. We'll get you it live next, right after this. Stay with us. This is Court TV, your front row seat to justice.
plaintiff has used 45 hours and 24 minutes. The defendant has used 57 hours and 6 minutes, which means the plaintiff has left 15 hours and 51 minutes, and the defendant has 4 hours and 9 minutes left, okay? So that's where we're at.
Top of the hour. Welcome back to Court TV Live. Amber Heard's legal team could be just minutes away from resting their case in chief or possibly calling more witnesses. Court set to begin at any moment. In fact, the judge walking onto the bench. Let's get you in live.
Jury out just to take them back in. So when after we finish our motions and they come out, I'll let you say that, yeah, okay, let's just do it that way. All right, so based on them resting, you have a motion?
Yes, sir.
And I did receive your memo ahead of time, so I have reviewed that.
I provided it to the other side last night, so they
Okay, I have that, okay. Yes, sir?
I haven't received anything from them. I don't know whether they filed it.
I think it's just gonna be oral arguments.
Thank you.
Yes, sir.
Good morning, Your Honor. May it please the court, Ben Chu for plaintiff Johnny Depp. Mr. Depp hereby moves to strike defendant Amber Heard's counterclaims because Ms. Heard has not proven by clear and convincing evidence that Mr. Waldman made the 3 allegedly defamatory statements with actual malice.
Right, but clear and convincing is not my motion to strike standard.
Understood, Your Honor.
Okay.
And we have cited the standard in our brief.
Thank you.
Moreover, Your Honor, the court should also strike defendant's claim for immunity and attorney's fees based on Virginia's anti-SLAPP statute, as she is not entitled to immunity under the statute. Because we know that the court has carefully reviewed our motion papers, I will just hit some of the salient points.
Thank you, sir.
Thank you, Your Honor. I would mention, however, Your Honor, that because this is not included in our brief, that there is no record evidence whatsoever that Mr. Depp even saw any of the 3 statements that Mr. Waldman made prior to being served with the counterclaims in this action, which we believe is relevant to many of the legal standards. And as Your Honor is aware, Ms. Heard had signaled for the past week that she was planning to call Mr. Depp in her case in chief, and it was our anticipation that she would try to fill what we believe is a gaping hole with respect to the elements of her proof. Again, there's no record evidence whatsoever that Mr. Depp ever saw any of the 3 statements about which Ms. Heard is purportedly suing him for $100 million. As Your Honor is aware, the elements of defamation are as follows. 1, publication of 2, an actionable statement with 3, the requisite intent. See Tharp versus Sanders, 285 Virginia 476 at 2013. The requisite intent for defamation against a public figure is actual malice. That is, the statement must be made with knowledge that it was false or with reckless disregard of whether it was false or not. See Sanders v. Harris, 213 Virginia 369 at 372, a 1972 case. See also Jackson v. Hartig, 274 Virginia at 2019. Reckless disregard, as Your Honor is aware, quote, is not measured by whether a reasonably prudent person would have published or would have investigated before publishing, ellipsis. There must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of his publication, unquote. St. Amant versus Thompson, 390 U.S. Supreme Court, 727 at 731. Your Honor, the evidence shows that Ms. Heard cannot prevail on her claim because she cannot and did not establish that Mr. Waldman made the statements with actual malice. Mr. Waldman testified that he conducted extensive investigation and reasonably believed that the 3 statements he made were true. Ms. Heard presented nothing to contradict that undisputed fact. Ms. Heard has no evidence of direct liability, because obviously, Your Honor, we need to talk about direct and vicarious liability, but it bears noting that she has no evidence of direct liability and cannot prove actual malice by Mr. Waldman when making the three statements at issue. It is undisputed that Mr. Depp did not make any of the three statements at issue in Ms. Heard's counterclaim. Moreover, in order for Mr. Depp to be liable for the conduct of one of his attorneys, there must be some showing that he directed, participated, or otherwise authorized Mr. Waldman to make the statements at issue. There is no such evidence on the record that Mr. Depp directed or otherwise authorized Mr. Waldman to make the three allegedly defamatory statements at issue in the counterclaims. Indeed, there is no evidence of any communication or coordination between Mr. Depp and Mr. Waldman regarding the counterclaim statements or anything else. For this reason as well, Your Honor, Ms. Heard cannot meet her burden of proving that Mr. Waldman was acting within the scope of his employment as our agency on behalf of Mr. Depp. Again, it bears noting that there's no evidence that Mr. Depp even saw the statements by Mr. Waldman until he was served with the counterclaims well into this case. It was more than a year after Mr. Depp filed his complaint and Ms. Heard lost a series of motions to dismiss that she finally asserted her counterclaims, most of which have already been dismissed by opinion letter of this court. Whereas here there is no evidence of direct liability, Ms. Heard must rely on a theory of vicarious liability to hold Mr. Depp liable for the actions or statements, rather, of his purported agent, Mr. Waldman. Vicarious liability is by definition, quote, liability for the tort of another person, unquote. So to hold Mr. Depp liable for Mr. Waldman's statements, Ms. Heard must establish that Mr. Waldman himself committed all the elements of defamation. I know the court's familiar with this, so I'll try to run through it quickly. See Parker versus Carillon Clinic, 296 Virginia 319 at 332, a 2018 case. Quote, vicarious liability is liability for the tort of another person. It necessarily follows that a claimant cannot make out a case for vicarious liability against an employer without first proving that the employee committed a tort within the scope of his employment. See also Roughton Pontiac Corp. Versus Alston, 236 Virginia 152 at page 156. Which standard Ms. Heard has not met? And Your Honor, we cite a string citation to cases from other jurisdictions, which we obviously are not binding on the court, but we believe are influential. We presented those to the court for its review. It is Ms. Heard's burden to prove by clear and convincing evidence, or ultimately, to prove actual malice by Mr. Waldman, not Mr. Depp. And while it is well-settled law in Virginia, as Your Honor has pointed out last week, that an agent's knowledge can be imputed to a principal, and this is the Allen Realty Corp. Versus Culber case, 227 Virginia 441 at 446. Ms. Heard's counsel cannot cite any case law stating that a principal's knowledge is imputed to an agent. In other words, Mr. Waldman must have made the statements knowing that they were false or with reckless disregard as to whether they were false. And Mr. Depp's knowledge cannot be imputed to him. There is no evidence in the record that Mr. Waldman knew the counterclaim statements were false. Indeed, Mr. Waldman did not even know Mr. Depp or Ms. Heard at the time of any of the alleged incidents at issue, and thus had no personal knowledge of what transpired. And this is reflected in the trial transcript that Mr. Waldman met Mr. Depp first in October of 2016, long after the fact. Nor is there any evidence in the record that Mr. Waldman subjectively entertained any serious doubts about the falsity of the counterclaim statements. Quite the opposite. The evidence shows, and it's unrebutted, that Mr. Waldman had very reasonable grounds to believe, and he did believe, and will to his dying day, that Ms. Heard's claim of abuse were patently false. Mr. Waldman testified at length about 29 witnesses he believed disproved Ms. Heard's false claims of abuse. See the transcript at page 6008 through 6012, and I won't run through all of that. But his testimony that 2 trained police officers, Officer Science and Haddon, were called to the penthouse on May 21, 2016, and saw no signs of injury on Ms. Heard's face, as well as, quote, Ms. Heard's own witnesses who have testified in various forms at various times that there were no injuries to her face whatsoever between May 21st and May 27th, 2016, when she walked in to court with her publicist, her lawyer, her former best friend who no longer speaks with her, for a no-notice ex parte TRO. Some of the witnesses whom Mr. Waldman has cited, they include Laura Devanere, Melanie Iglesias, who, as Your Honor recalls, was Ms. Heard's makeup artist, who decided to end any professional or personal association with Ms. Heard. Samantha McMillan, Hilda Vargas, Isaac Baruch, Trinity Esparza, Cornelius Harrell, Alejandro Romero, and Brandon Patterson, just to name a few. No reasonable jury could find that Mr. Waldman acted with actual malice in making the allegedly defamatory statements. He was not present for the alleged incidents. He has no personal knowledge of any of the alleged incidents. What Mr. Waldman knows is a product of the legal work he did, the sleuthing he did on behalf of Mr. Depp. Ms. Heard cannot possibly show that Mr. Waldman acted with actual malice, and her defamation claim must fail. 2, Mr. Waldman is an independent contractor, not an employee. It is axiomatic, Your Honor, that a person who hires an independent contractor is not liable for the independent contractor's actions. See Sanchez versus Medicorp Health System, 270 Virginia, 299 at 344. An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer principal as to the way to bring about that result. See Atkinson versus Sachno, 261 Virginia, 378 at 284. That's a 2001 case. An outside lawyer retained by a client in connection with litigation is an independent contractor. See King versus Dalton, 895 F. Sup. 831, Eastern District of Virginia, 1995.
Benjamin
Where
Chu
Judge
arguing in front of the judge to throw out Amber's case, saying there's nothing there. It's procedural. We'll see what happens. We'll get a break in here, pick it up when we return. Stay with us.
app where your hard work pays off.
Welcome back to Court TV Live. If you're just joining us, Amber Heard's team has rested its case in chief. They did it outside the presence of the jury. And that immediately triggered a motion from Johnny Depp's team. And Benjamin Chu is arguing that motion and from the judge asking that Amber Heard's counterclaim be thrown out. Let's go back in where we left off.
Where Judge Ellis, a legendary jurist known by all Virginia practitioners, held that, quote, a law firm attorney working with a client is nonetheless an independent contractor and is not an employee of the client corporation. In that case, the employer was a corporation, but the same logic applies when it's an individual like Mr. Depp. That was Mr. Waldman's role. Indeed, clients hire lawyers to obtain specific results or to try to obtain specific results, but they do not control the means by which the results are accomplished. Lawyers, as Your Honor has reminded us, are subject to professional obligations to exercise independent professional judgment. We are not at the whim of our clients as much as we want to serve them. See Virginia State Bar Professional Guidelines, Rule 1:2 and 2.1. And just to quote 2.1, in representing a client, a lawyer shall exercise independent professional judgment, unquote. Mr. Waldman is, as a matter of law, an independent contractor, and Mr. Depp cannot be held responsible for any alleged tort by his attorney, particularly for statements about which he was unaware until he was sued for them. Mr. Waldman testified, and it's unrebutted, that he has his own law firm. He's not an employee of Mr. Depp. Mr. Depp or none of his loan out companies have issued him a W-2, and Mr. Waldman provides legal services to clients other than and in addition to Mr. Depp. And that's found at the transcript, page 6020 through 21. All of that is unrebutted by Ms. Heard. Mr. Waldman's statements, the third reason for which we respectfully submit the counterclaim should be stricken, is that Mr. Waldman's statements were protected opinion. And I won't run through all of that, but very briefly, taken in their proper context, the counterclaim statements are non-actionable expressions of opinion entitled to protection under the First Amendment. See Gertz versus Robert Welchink, 418 U.S. 323 at 339. That's a 1974 case from the United States Supreme Court. See also Shacker v. Buffalt, a Virginia Supreme Court case found at 290 Virginia 83, a 2015 case, noting that where, quote, all sides of the issue, as well as the rationale for the speaker's view were exposed, the assertion of deceit reasonably could be understood only as the speaker's personal conclusion, unquote, and finding an accusation of deceit to be opinion. In context, Your Honor, any reporter or any reasonable reader would understand and expect a lawyer associated with Mr. Depp, as Mr. Waldman was, to challenge Ms. Heard's version of the inherently controversial events of the parties' marriage. Just as Ms. Heard's lawyers were quoted challenging Mr. Depp, and Your Honor will remember the context of these quotes that were in a British tabloid where Mr. Waldman's statements were buried well into article in which both points of view were clearly expressed. And Mr. Waldman was clearly identified not as an independent expert on the U.S. Constitution, but as one of Mr. Depp's attorneys. C. Chavez, 230 Virginia 112 at page 119, quote, the most unsophisticated recipient of such a claim, i.e. any reader of the British tabloid, made by a competitor against another could only regard it as a relative statement of opinion grounded upon the speaker's obvious bias, unquote. Mr. Waldman has never did anything to hide his support and belief in Mr. Depp. Finally, Your Honor, and for the rest, ultimately, Mr. Waldman's statements reflect the existence of two competing narratives and are merely his subjective view about events that he never claims to have witnessed, and there was no doubt about that. Turning to the second part of the argument, which will be more abridged, Ms. Heard is not entitled to anti-SLAPP immunity. As a threshold matter, Virginia Code Section 8.01-223.2, which is, as Your Honor well knows, is the Virginia anti-SLAPP statute amended most recently in 2019, provides in relevant part, quote, the immunity provided by this section shall not apply to any statements made with actual or constructive knowledge that they are false or with reckless disregard for whether they are false. Here, in addition to Mr. Depp's testimony, several witnesses have testified that A, they never witnessed Mr. Depp abuse Ms. Heard, and B, that they observed Ms. Heard without any injuries, marks, bruising, swelling, etc., during periods when Ms. Heard claimed to have injuries, marks, bruises, etc. Such witnesses include, but are not limited to, Isaac Baruch, Kate James, Dr. David Kipper, Nurse Debbie Lloyd, Officer Sines and Haddon, Officer William Gatlin, and former U.S. Marine Starling Jenkins. Ms. Heard's request for anti-SLAPP immunity should be stricken, and even if there were disputed facts as to that, the anti-SLAPP immunity does not apply because the defamatory implication of Ms. Heard's statements are not solely relating to a matter of public concern as is required under the statute. As has become quite clear, Your Honor, Mr. Depp is not suing about any of the public policy commentary made by the ACLU when it drafted the op-ed, and Ms. Heard put her name to it. What he is suing about here are the three statements that were directed at him. He has no issue with women's rights. He supports women's rights. In fact, he was the one, Your Honor, as Your Honor knows, who made that first $100,000 contribution to the ACLU, and he made it also to the CHLO.
Your Honor, at this point, I'm going to object. Mr. Chu has largely just read his brief and confined his arguments to those directed in the motion, but like we saw with the last motion to strike, he's now directing his arguments to something other than what's at issue here, and I would object because I think making an argument not to you but to the cameras, it's disrespectful to the court and to everyone's time, and it also threatens to undermine the integrity of this process and risk the jury being influenced by outside factors.
Well, it's his argument. I'll allow him to do his
Thank you.
Thank you.
Thank you, Your Honor.
All right, let's get a break in here. Benjamin Chu will continue his argument right after the break.
at SmileDirectClub.com.
Back to the court we go. Benjamin Chew delivering his motion to the judge to throw out Amber Heard's counterclaim.
As I was trying to say, what Mr. Depp is suing about are the three statements. And it's very clear, despite the pious opening statement that about the First Amendment, that with the testimony of Terrence Doherty and the emails that were admitted as exhibits, that the ACLU and Ms. Heard were conspiring to make it very clear that those three statements were related to Mr. Depp, because otherwise nobody had any interest in the article. And it's crystal clear from that. They wanted to time this thing with the release of Aquaman, which was her first film of any significance in terms of popularity, and to do that. That's very clear. So the charade that this had something to do with public policy is risible, and that is not why the anti-SLAPP protections were enacted. They were enacted to protect the rest of the article, not what Mr. Depp is suing about. As generally analyzed by the courts, a matter of public concern is one which relates to, quote, a matter of political, social, or other concern to the community, unquote, as opposed to a matter of only, quote, personal interest, unquote. That's Connick versus Myers, 461 U.S. 138 at page 146. Instead, the defamatory implication at issue in each of the three statements at bar relate to the personal grievances between Mr. Depp and Ms. Heard, which does not rise to the level of a matter of public concern with broader implications for society beyond the two litigants in this action any more than Mr. Waldman's statements. I mean, adding the gloss of public policy might immunize the statements that relate to public policy, but those are not at issue here. Mr. Depp agrees with those statements. We're talking about the three statements that they very intentionally and very cleverly put in to make it clear the implication that it was about Mr. Depp. They had lawyers from the ACLU working around the clock with Eric George to be as clever about this as possible. And Your Honor remembers the testimony of Mr. Doherty about the consternation at the ACLU when they realized that USA Today and everybody else who read the article knew darn well that this was about Mr. Depp. This cannot be protected by the anti-SLAPP statute. It is a cynical runaround. And I think now that we have the undisputed evidence from the ACLU in the form of the testimony of Terrence Doherty, who is not only their corporate representative, he was their general counsel. He is a brainiac lawyer. They knew exactly what they were doing, Your Honor. And he referred to testimony of a woman at the ACLU who said she had nightmares about Ms. Heard, and he expressed no concern about that. Now, that was either because they knew about that was either a reference to this game they were playing with the op-ed or the conspiracy they had to cover up her failure to make the donations. The donations became pledges, but we have evidence that she refused to sign the pledge card. So she's caught either way. Simply stated, Your Honor, Mr. Depp is not suing Ms. Heard for making statements about society in general. I think that's very clear from the record evidence. Mr. Depp is suing her for publicly naming him as an abuser by implication and forever tarnishing his good name, an act that, coming from an ex-spouse, is fundamentally personal in nature. For that reason as well, Your Honor, Virginia's anti-SLAPP statute is not applicable. And based on the foregoing, Your Honor, Mr. Depp respectfully submits that the court should grant plaintiff's motion to strike the counterclaims and also strike her claim that she is immune under the anti-SLAPP statute. Thank you very much, Your Honor.
Thank you, sir. Yes, sir.
Thank you, Your Honor. As Your Honor knows, the trial court is required to accept as true all the evidence favorable to Amber at this point, as well as any reasonable inference a jury might draw therefrom, which would sustain the counterclaim. That's the correct standard here. I'll address the actual malice argument first, the agency argument. Your Honor, there's plenty of evidence in the record from which the jury could determine that Mr. Waldman was Mr. Depp's agent. He made those statements. The statements referred to him as Mr. Depp's attorney. As Your Honor ruled on Friday with respect to the jury instruction conference, an attorney is an agent of his client. Mr. Waldman testified that he's been Mr. Depp's attorney since 2016. He freely admitted speaking to the press on Mr. Depp's behalf, and he refused to answer question after question about that agency, so we can't use that as a sword now. Mr. Chu puts a lot of emphasis on the fact that Mr. Depp allegedly didn't see the comments that were made that are the subject of the counterclaim, but as Your Honor well knows, whether he saw them or not is not the standard for agency. There's also evidence that Mr. Depp met with the Daily Mail with Mr. Waldman prior to the defamatory statements being made and released. I believe that was in February of 2020, just 2 months prior. Mr. Waldman also concocted a story that Amber was being investigated for perjury by filing a perjury complaint against her with the LAPD. He disregarded any evidence that he didn't believe would fit in his narrative, that would fit in this story that he was speaking about on behalf of Mr. Depp. And after Mr. Depp lost the UK proceeding, after Mr. Depp was ruled to be a wife beater by the court in the UK proceeding, the court there found him to be a wife beater. Mr. Waldman then got an overseas tabloid to run a story claiming that Amber was being investigated for perjury, which simply wasn't true. He walked into the LAPD, filed a complaint for perjury against Ms. Heard, found a media outlet that doesn't follow the two-source rule, and then he had let the world believe that the LAPD was investigating Ms. Heard for perjury. That's a shameful and a sickening example, Your Honor, of the lengths that Mr. Depp, through his agent, Mr. Waldman, would go to smear and to defame Amber Heard, and that continued in the 3 statements in the counterclaim. Your Honor has heard evidence, I won't go through all the evidence, but Your Honor's heard evidence from Ron Schnell, who's traced the negative hashtags toward Amber Heard online associated with those defamatory statements and noted the staggeringly high number of them that were associated with Mr. Waldman. Under the principles of the agent-principal relationship in Virginia, Your Honor, when Mr. Waldman made those statements, he was standing in the shoes of Mr. Depp. They are one and the same for the purposes of those statements. As Your Honor discussed at length on Friday, Mr. Waldman made these statements with actual malice. There's plenty of evidence from which the jury could infer that, and his own, both from the actual malice from Mr. Depp and Mr. Waldman's own reckless disregard of facts that didn't support Mr. Depp, and his attempt to manufacture false evidence that did. As Your Honor found in the hearing, I believe it was on March 24th, after Your Honor denied Mr. Depp's motion for summary judgment, Your Honor said, as to malice, a fact finder could reasonably conclude that Mr. Waldman made the statements with malice because Mr. Waldman has no personal knowledge of the party's marriage and still made the statements at issue. Nothing in this case has changed that. If anything, the evidence has only made it more clear that that is an inference that the jury can and we believe will find. So, Your Honor, there's no basis to grant a motion to strike on this agency argument, on the actual malice argument. The evidence shows that not only was Mr. Waldman Mr. Depp's agent, but that the two of them conspired to falsely accuse Amber of creating a hoax and falsify evidence that they believed supported their theory and what they wanted to achieve. As Your Honor well knows too, I won't go through all the law, but both agency and malice can be inferred through circumstantial evidence. There's plenty of evidence in the record from which the jury could infer those. Moving on, Your Honor, to the independent contractor, the court's already rejected this argument, ruled that an attorney-client have a principal-agent relationship, and as Your Honor said on Friday, there's no evidence in this case of anything otherwise. As to the argument that the counterclaim statements are statements of opinion, the court has already found twice that they are not statements of opinion, both on January 4th, 2021, in its opinion letter denying Mr. Depp's demur as to the counterclaim statements, and at the motion for summary judgment hearing in March of this year. As to the anti-SLAPP argument, the court again has already ruled at the March 24th, 2021 opinion that the statements are as a matter of law regarding matters of public opinion. The court has already ruled that. Therefore, the only remaining issue for anti-SLAPP is whether the intent element of immunity is met. As we discussed on Friday, the intent element of immunity is substantially the same as the actual malice standard, which the evidence in this case easily allows a jury to find in favor of Ms. Heard on that. I won't go through the litany of evidence that supports that Mr. Depp is an abuser here, but I'll touch on a few things that relate to Mr. Chu's argument. One, Mr. Chu was totally misrepresenting Mr. Doherty's testimony. There's not a single piece of evidence, Your Honor, in this case suggesting that Ms. Heard and the ACLU were somehow conspiring to achieve a defamatory implication to Mr. Depp. That's simply not what Mr. Doherty said. Mr. Chu's feel free to argue that to the jury, but that's not what his testimony reflects. Your Honor, there's also plenty of evidence that's been adduced both in Mr. Depp's claim and in Ms. Heard's counterclaim that show that absolutely that the counterclaim statements are 100% false. There was no hoax perpetrated. Mr. Depp is an abuser who abused Ms. Heard. She did not conspire with her friends to create a hoax. She did not create a hoax herself. And just very briefly, some of the evidence that's come up since the last motion to strike, Your Honor, that Mr. Chu conveniently disregards in his brief are the testimony of Rocky Pennington, the testimony of Josh Drew, the testimony of Elizabeth Mars, all of whom completely corroborate Ms. Heard's account of the events of May 21st, 2016. The testimony of Melanie Iglesias, who testified that she covered Ms. Heard's bruises with makeup right after the December 15th incident, that provided ample testimony to support that Ms. Heard often would cover her bruises that were caused by the plaintiff, in this case, by Mr. Depp, with makeup. He ignores the evidence of Christy Sexton. He ignores the evidence of Io Tillett Wright. He ignores the evidence of Whitney Enriquez. All of these witnesses and others have testified extensively about Mr. Depp's abusive behavior toward Ms. Heard. Physical abuse, emotional abuse, psychological abuse, verbal abuse, Your Honor. Mr. Depp's own writings, recordings, pictures, and videos confirm that. The list goes on. There's abundant evidence in the record, Your Honor, from which the jury could, and again, we believe will find that Ms. Heard is not liable for defamation to Mr. Depp, and therefore, by definition, she has not acted with actual malice, and based on the court's rulings on March 24th, 2021, she would be entitled to anti-SLAPP immunity, which would permit her to ask the court to award attorney's fees against Mr. Depp. So with that, Your Honor, I'm happy to answer any questions the court has.
That's
but
fine.
that
Thank you,
covers
sir.
it. Thank you.
All right. Yes, sir.
There's Ben Rottenborn. He's saying no. There's more than enough here to move forward. Let's get a break in here and see if Benjamin Chu has something to say as a rebuttal, and then we'll get the judge's ruling. back. Both sides have argued this motion from Johnny Depp's team to throw out Amber Heard's counterclaim after they rested. If you just joined us, the Amber Heard's team has rested their case in chief. Let's see what the judge decides.
All right, in this matter, I've reviewed all the defendant's evidence as to her counterclaim, and I've considered the arguments of her counsel and plaintiff's counsel. First, to address a few issues that I believe are outside the motion to strike, and that's as to the slap defense. The slap defense is just that, it's a defense, so it's really not considered in a motion to strike. Having said that, we went down that legal road on Friday as far as the slap defense goes, as far as the jury instructions. In this particular case, if the plaintiff prevails, it must be with actual malice. Therefore, if it's with actual malice, immunity does not apply under that statute. So we will deal with that with jury instructions, and we have. As to independent contractor, again, I think it's outside the motion to strike. However, Mr. Waldman was plaintiff's attorney since 2016. Before the initiation of litigation, there is evidence that Mr. Waldman had a certain role during the prior divorce proceedings in the UK case. Additionally, there is evidence that shows his legal representation was broader than just a limited litigation, as outlined in all the cases presenting an attorney as an independent contractor. So the only evidence in this case to this point is that Mr. Waldman was an agent to Mr. Depp, and that is the basis to weigh the motion to strike. As far as the opinions argument, again, I think that is outside the motion to strike. The opinions argument, the court has already ruled on this matter as to the three statements that are at issue in the counterclaim, ruled that they were not opinion at the demur and at summary judgment. So that argument will not be part of the motion to strike. So when assessing a motion to strike, the court accepts the favorable evidence adduced as true towards the non-moving party. The court cannot reject any inference from the evidence favorable to the non-moving party unless it would defy logic and common sense. When there is any doubt and question, the court should overrule a motion to strike. Agency may be inferred from the conduct of the parties and from surrounding facts and circumstances. When there is no direct evidence, circumstances may and usually are relied upon to determine whether an agency relationship exists. A principal is liable for the tortious acts of his agent if the agent was performing his principal's business and acting within the scope of his agency. If an agent's tortious act arises from their agency relationship is enacted in part to service the principal can be held liable for the tort. Here, the alleged tort is defamation. Besides demonstrating the agency relationship, the defendant must prove Mr. Waldman published an actionable statement, meaning a statement that is both false and defamatory with the requisite intent. As to agency, Mr. Waldman was plaintiff's attorney at the time of the alleged defamatory statements were made. Mr. Waldman does not deny this, and neither does the plaintiff. Moreover, Mr. Waldman made the allegedly defamatory statements about the defendant during the proceedings of this action and interacted with the defendant once the statements were made while still representing the plaintiff. Taking the surrounding circumstances as a whole, an agency relationship can be inferred, and thus a scintilla of evidence regarding agency must be turned over to the jury. In addition, the jury may infer that Mr. Waldman made these specific statements to a third party to serve as plaintiff by portraying defendant as an opposing litigant in a negative light. It is not disputed that Mr. Waldman published statements and that there is a question as to whether statements are false, and both parties disagree and have presented conflicting evidence as such. As to actual malice, Mr. Waldman made the counterclaim statements after he met with his client. In addition, there is evidence the plaintiff was with Mr. Waldman at a meeting in February 2020 with the Daily Mail online. Further, defendant claimed that she met with Mr. Waldman where he threw the paper containing the counterclaim statements within them. Consequently, there is more than a scintilla of evidence that a reasonable juror may infer Mr. Waldman made the counterclaim statements while realizing they were false or with a reckless disregard for their truth. It is not my role to measure the veracity or weight of the evidence. The Fourth Circuit and the Virginia Supreme Court have made it crystal clear that actual malice is a question for the fact finder. So therefore, the plaintiff's motion to strike is denied. Okay? Thank you. Is there any other preliminary matters before the jury?
Yes, Your Honor.
Okay.
All right, there's the judge's ruling denied. That's expected. It's usually a home run. It's a grand slam if you can get a judge to throw out a claim mid-trial after one of the parties has finished his case, but obviously putting it on the record. Let's bring back in Melissa Redbin. And Melissa, this is Hail Mary of sorts. You do it every time, and we see it every time on court TV. Once one side has finished the case in chief, the other asks for the case to be thrown out. Your thoughts on the argument? So interesting that Ben Rottenborn accused Benjamin Chew of using the cameras to basically throw out their side of the story, and then he gets up and does the exact same thing.
Right. Yeah, basically accusing Ben Chew of giving his closing arguments and inflaming the jury, who of course isn't present in the courtroom, and then gets up and does the same thing. And I think lawyers have this inherent need to respond, to argue, to debate. So if he's going to get up and make the, allege these facts, then I have to get up and allege the counterfacts, and that's just part of our nature. But I do think the ruling is expected. It's a very high burden to survive or to grant a motion to strike. Generally, most things judges are going to want to defer to the jury, and most things, as mentioned in her ruling, are going to be questions of fact for the jury, the actual fact finders to decide. So, of course, it's not surprising that she would deny the Depp team's motion to strike Amber's counterclaim.
Yeah, absolutely. And right now, an extended sidebar is going on inside the courtroom. The jury has not been in the courtroom at all today. They're dealing with this motion, and we're expecting the jury to come in. And when they do, the jury will hear formally Amber Heard's team rest its case. But they have done that. They've rested their case in chief. They have 4 hours left. Clearly a strategic decision to just wait and see what Johnny Depp's rebuttal entails, and then use the 4 hours, if they so choose, on the back end and getting essentially the last word. Your thoughts on that strategy?
I'm surprised that they didn't call at least one more witness to wrap up their case and have that strong ending that you want in front of the jury. But it does make sense for them not to call Johnny Depp, for example, if he's on his own witness list to be called in rebuttal, they can just cross-examine him. And you do want to leave plenty of time for that cross-examination and any rebuttal you may to put up. 4 hours is actually not a lot of time when you're talking about trial practice. So I understand why they want to leave themselves a little bit of cushion in case they do need to put up a rebuttal case.
Johnny Depp's case and rebuttal case expected to start momentarily. What are you looking for here? We're going to hear from some experts, a couple doctors, and then Johnny Depp himself.
Yeah, we're going to look for any witnesses to counter Amber Heard's claim, the incidents that she specified in her case in chief, the staircase incident he may want to respond to involving Whitney, Amber's sister, any other things that he could call into question the credibility of Amber Heard and her witnesses. So you want to remind the jury that these events either did not occur or didn't occur the way that the defense side makes them allege them to have occurred.
There it is, Johnny Depp sitting alone at his table because all of his attorneys are still up at the bench for an extended sidebar as they set the path forward as Johnny Depp and his team prepares to begin their rebuttal case. Amber Heard has rested her case in chief. This is Tuesday. This case ends on Friday. It's winding down day 21 of testimony. Coming up next.
today at Grove.com.
Good morning. All right, it's my understanding that defense is resting, is that correct?
Top of the hour. Welcome back to Court TV Live. I'm Ted Rollins. Glad to have you along with us on this pivotal Tuesday as Depp v. Heard winds down. At any moment, Amber Heard's team is expected to announce in front of the jury that they've rested their case in chief. You heard the judge acknowledge that at the beginning of the court day. This is a live look inside the courtroom. They've had an extended sidebar arguing basically the path forward here for the last few days before this jury gets the case on Friday. You can see the court reporter typing away all this, always on the record. Johnny Depp's legal team will then begin their rebuttal case. Depp is expected to testify along and expects to be the last witness that this jury hears. They also have experts coming in, including his hand doctor, the one that actually worked on Johnny Depp's finger after the bottle incident, alleged bottle incident, and others, including Dr. Kimberly Collins, who's a forensic pathologist on the Johnny Depp rebuttal witness list. And then those big names, of course, including Kate Moss and Johnny Depp himself. They expect to end their case with watching along with us, law professor at the university. And there's a look at the rest of the expected witnesses. Jennifer Howell. You remember Jennifer Howell? She's a huge witness here because she was the boss and former very close friend to Whitney Enriquez, Whitney Heard. And she says that after the staircase incident, that Whitney told her a much different story about what happened. She'll be fascinating. That'll be by video deposition. And then Kate Moss. We all know Kate Moss, Johnny Depp's former girlfriend, model actress. Law professor at the University of Georgia and former prosecutor Melissa Redmond has been with us all morning, and trial attorney Jenny Elkady joins us from Columbus, Ohio. Good morning, Jenny. Good to see you. Here we go. We're getting ready now for the rebuttal case. Johnny Depp, they've got quite a list of people that they've put on for rebuttal. Let's just sort of reset. Where, Jenny, do you think this case is? Who should be feeling good in your estimation?
I think Johnny Depp's team should be feeling great right now. I mean, the main thing that we're seeing right now is the time. The time limits that plaintiff has versus defendant has is astronomical. I mean, only 4 hours for defense to be able to have their counterclaim is just not enough time from a trial's perspective at all. That's very limited time. And for Johnny, you know, he's got 18 hours. That's plenty of time for them to be able to counter whatever claims that Amber's going to have and make a rebuttal case. So I think Johnny's team is in a really good position right now.
Melissa, your thoughts as we get ready for Johnny Depp's team to begin the rebuttal case with these experts. We're expecting the experts to start things off, including this hand doctor, which could be pivotal because Amber Heard's team went to great lengths bringing on their own hand doctor to refute Johnny's bottle story that Amber threw a bottle of vodka at him, and that's what caused the severed fingertip.
Right, so they're going to focus their rebuttal on disputing the Amber Heard's expert witnesses that the incident, that Johnny Depp described could have caused the injury, even if it's not the description that he gave the doctor, just that what the orthopedic surgeon testifying on behalf of Amber Heard testified to is not accurate. That information isn't accurate. And based on his observation, had the events unfolded the way Johnny Depp described, that injury could have been consistent with what he saw. And also any other evidence that Amber Heard's experts testified to, that's what they're going to focus their rebuttal case on, basically challenging the credibility of her entire case and reminding the jury that if she can't be deemed to be credible about one thing, then she can't be believed about the incidents that she's alleging Johnny Depp committed against her, and that he should win his lawsuit.
Jenny, if you think about it, putting Johnny Depp on as your final witness, it says something about their confidence, does it not? If you had a client that you're not quite sure about his story or his ability to tell his story, his truthfulness, probably the last person you're going to want to put on last, right? You're happy you already got through it. What does it say to you that they're teeing it up and rubbing their hands together again. Ooh, we're going to finish with Johnny.
I think it's really interesting, honestly, because I think they keep going back and forth. But at the end of the day, something that we know about Johnny is that he takes a while to get through his testimony. He really thinks out what he's going to say because he's very careful with the words that he chooses. He's smart about it. So it's going to waste a lot of time, I think, if they throw him up there. But if they have a reason to put him up there, there's got to be something, I guess, that they have up their sleeves that it's like, this is going to be the grand finale, the thing that closes the case. That's it. Like, we win.
And Melissa, it may just be that they want the jury to have Johnny's words be the final words, and because they believe in his veracity and his ability to tell his version of events. And at the end of the day, that's what this is about, isn't it? The question the jury needs to answer is, who's lying? One of these two is lying.
Mm-hmm. Yeah, who do we believe? And being the last voice that the jury hears is the advantage of being the plaintiff. Like, you get the last word, and it's, they may take advantage of that opportunity. I would agree. I don't know how much more they can get out of him. He is a little bit long-winded, but they have plenty of time. So why not? If they have the time, if there's something important details that they can draw out that the jury hasn't heard already, then yeah, why not go ahead and put him up on the stand again? Obviously, the public likes them. We don't know how the jury has responded to him in his testimony, so that'll be interesting to see.
All right, sidebar just broke up. They're going to call for the jury. That means the rebuttal case will begin next. Stay with us. We'll get a break in now.
Sling. Try us today.
Okay, welcome back. Jury is back in the courtroom, and Amber Heard's team is about to rest its case in chief formally in front of the jury. Let's go in.
All right, your next witness.
Your Honor, on behalf of defendant and counterclaimant Amber Heard, we rest.
All right, thank you. All right, rebuttal evidence?
Yes, Your Honor, Mr. Depp calls Walter Hamada of Warner Brothers.
All right, Mr. Hamada.
Your Honor, just to clarify, this is by deposition, so we may need that.
Okay, well, okay.
I apologize, I should have provided notice.
That's all right.
Thank you, Your Honor.
If we could get the TV up.
All right, Johnny Depp's rebuttal case getting underway. Their first witness, an executive from Warner Brothers Studios, Walter Hamada, would be familiar with Amber Heard's contracts at Warner Brothers, including Aquaman. We'll see where this goes. This is a video deposition, as you heard Benjamin Chu say, meaning that this was taken already. Let's go in live and see what he has to say.
Hamada, what do you work for Warner Brothers Entertainment, Inc.?
Yes, I do.
In what capacity?
My title is President of DC-based film productions for Warner Brothers.
What, if anything, you did to prepare to testify for Warner Brothers as to topics 2 through 18?
I did not do anything to prepare for this, other than the meeting that I had with the attorneys.
Did Warner Brothers have a contract with Amber Heard to perform in Aquaman 2?
Yes, there was we had an option agreement for her for Aquaman 2.
Do you know what it is?
It looks like a standard contract between an actor and the studio.
And which actor was involved in this? Which actor was a party to this contract?
Amber Heard. It's a contract for Amber Heard for the role of Mara in Aquaman and its sequels.
Which studio contracted with Amber Heard?
Warner Brothers.
When did you come to be the president of DC?
At the beginning of 2018.
Mr. Hamada, was Ms. Heard ever released by Warner Brothers from the Aquaman 2 contract, or what you call the option agreement?
No.
Was she released from her Aquaman 2 contract on or about February 22, 2021?
No.
Was Ms. Heard ever rehired for Aquaman 2 by Warner Brothers?
No.
Did Ms. Heard receive a pay increase for Aquaman 2?
No.
Why not?
As a rule, as a company, we go through a lot of trouble when we make our deals with our actors, where we get options on them for subsequent movies. And I think traditionally, prior to me joining the company, every option was renegotiated. And one of the things that we were trying to put a rein in on was not renegotiating every deal, with the understanding that people come in and make these deals and they have an understanding that there will be options and that there is a deal in place. And it was a big part of our philosophy that we were going to hold people to their options moving forward.
But did Warner Brothers at any point in time reduce Ms. Heard's role in Aquaman 2?
The role in the film that the size of the role in the film that she has was determined in the early development of the script, which would have happened in 2018, I would say. So and from there, beyond normal development, the role sort of, the character's involvement in the story was sort of what it was from the beginning.
Was her role ever reduced for any reason?
No, I mean, again, from the early stages of the development of the script, the movie was built around the character of Arthur and the character of Orm, Arthur being Jason Momoa and Orm being Patrick Wilson. So they were always the two co-leads of the movie.
Did Warner Brothers ever plan to portray Ms. Heard as the co-lead in Aquaman 2?
No, the movie was always pitched as a buddy comedy between Jason Momoa and Patrick Wilson.
Was Ms. Heard cast in Aquaman?
Yes, she was.
Was Ms. Heard cast in Aquaman 2?
Yes, she was.
Was Ms. Heard paid for her services in Aquaman 1?
Yes.
Was Ms. Heard paid for her services in Aquaman 2?
Yes.
Was her compensation for Aquaman 2 affected in any way by anything said by Johnny Depp?
No.
Was her compensation for Aquaman 2 affected by anything said by Adam Waldman?
No.
Was her compensation for Aquaman 2 affected by anything said by anybody representing Johnny Depp?
No.
Was there any delay in Warner Brothers exercising the option to cast Ms. Heard in Aquaman 2?
Yes, there was.
How long a delay was there?
I don't know, probably weeks.
What was the cause of the delay?
There were conversations about potentially recasting.
Who was the producer?
Peter Safran.
Who was the director?
James Wan.
Did Warner Brothers believe that those concerns were legitimate?
Yeah, I mean, I had no reason not to believe the director and the producer of the movie.
And you are testifying today as a representative of Warner, correct?
Yes, I am.
What, if any, creative concerns did Warner Brothers have about casting Amber Heard as Mira in Aquaman 2?
It was the concerns that were brought up at the wrap of the first movie, production of the first movie, which is the issue of chemistry. Did the two have chemistry? I think editorially they were able to make that relationship work in the first movie, but there was a concern that it took a lot of effort to get there. And would we be better off recasting, finding someone who had better, more natural chemistry with Jason Momoa and move forward that way?
Did Warner Brothers take any steps affirmatively to audition other actresses for the role of Mira in Aquaman 2?
No, we did not.
Other than the creative concerns and concerns about chemistry you testified about, was there any other reason Warner Brothers delayed in picking up Ms. Heard's option for Aquaman 2?
No, it was all concerns about whether she was the right bit of casting for the movie.
What role, if any, did Ms. Heard's dispute with Johnny Depp have in Warner Brothers' delay picking up Ms. Heard's option for Aquaman 2?
There was none from our end.
At any point in time, was Warner Brothers considering paying Ms. Heard more money for Aquaman 2 than is set forth in the option contract you previously identified?
No, as I said, we were determined to hold our actors to their option agreements.
Would Warner Brothers have paid Ms. Heard more money on Aquaman 2 if it had picked up her option earlier?
No.
At any time from the beginning of history through today, did Warner Brothers ever release Ms. Heard from the Aquaman 2 contract?
No.
At any point in time from the beginning of history to today, did Warner Brothers rehire Ms. Heard for Aquaman 2?
No, because we just picked up her option.
And when is the last time you spoke with Rob Cohen relating in any manner to whether to exercise the option on Amber Heard for Aquaman 2?
No, it would have been the same time that I was having those conversations with Peter Safran.
So
in 2020.
Did you speak with Zack Snyder at all relating to whether to exercise the option for Amber Heard on Aquaman 2?
No, I've not had any conversations with Zack Snyder.
Did you speak at all with Jason Momoa in preparation for your deposition today?
No.
Have you ever spoken with Jason Momoa about any issues relating to chemistry between he and Amber Heard?
Yes.
When did you speak with Jason Momoa about chemistry issues between he and Amber Heard?
That would have been in that same time period where we were prior to green light of the movie.
Now, you were asked some questions about scripts. Did you review any of the drafts of the script for Aquaman 2?
Yes.
When?
I part of my role is I read all the drafts of the scripts as they come in.
When was the first script for Aquaman 2?
Oh, boy. I cannot tell you. Probably in 2018, the latter part of 2018 would be my guess.
And how many versions of the script had been written by the beginning of 2021 for Aquaman 2?
Oh, there were probably half dozen drafts of the script. Brought up.
All right, what, if anything, did Rob Cohen say to you about chemistry? What specifically about the chemistry between Amber Heard and Jason Momoa?
Just the fact that they didn't really have a lot of chemistry together. The reality is it's not uncommon on movies for two leads to not have chemistry, and that it's sort of movie magic and editorial, the ability to sort of put performances together, and with the magic of, a great score and how you put the pieces together, you can fabricate sort of that chemistry. And so I think at the end of the day, I think if you watch the movie, they look like they had great chemistry. But I just know that through the course of the post-production that it took a lot of effort to get there. Sometimes you don't. Sometimes it's very easy. You just put the, characters on the screen together and they work. And sometimes it's harder. And so...
Can you give me anything more specific about what it was with Amber Heard and Jason Momoa that was difficult for the chemistry?
No, because it's like what makes a movie star. Like you know it when you see it, and the chemistry wasn't there.
Now, you've used the term fabricated a number of times. What did you do to fabricate the chemistry between Amber Heard and Jason Momoa?
Well, those are just, it's editorial. A good editor and a good filmmaker can pick the right takes, can pick the right moments, and put scenes together. Again, score is a big, the music in a scene makes a big difference. It can make a happy scene feel sadder or a sad scene feel happier. And so it was sort of it's just the magic of post-production, editing, sound design, music, etc.
And what do you mean by fabricating, though? I mean, were they literally falsifying, or were they just picking the best music? Let me just finish my question. Were they picking the best music and picking the best looks because that's their job and that's what you do on every scene?
That is what we do in post-production. That's what filmmakers do. This is, on any production, you're doing that. You're putting performances together. Sometimes it's easier than others. This one was more difficult because of the lack of chemistry between the two. But they were able to, James Wan and the editor were able to get it to a place where the end result actually works. And it's great.
And in fact, that's the job of every filmmaker, right? Is to put all the combinations together to make the most successful production.
Absolutely.
I'll tell you what has been marked as exhibit number 5. It's ALH 18247. And this is a text message exchange between James Wan and Amber Heard. And you mentioned James Wan was the director of Aquaman 2, is that correct? And Aquaman, the first one, correct?
That's correct.
All right. And James is texting to Amber on August 25, 2018. You rated really high with the audience, exclamation mark, exclamation mark. Do you see that?
Yes.
This is August 25, 2018. What's going on August 25, 2018 that would cause the director to send a text message to Amber saying...
That'd be a test screening. So during our post-production of movie, we test the movie with an audience, and the audience tells us what they liked and what they didn't like. And so that's what he's referring to there.
And they really liked Amber Heard, correct?
Yes, she did. She tested well.
It hit $1 billion, is that correct?
Yeah.
And more specifically, did you play any role in the determination to communicate to Amber's representatives that Warner Brothers was considering not exercising her option?
Yeah, probably in the sense of we had the conversations, and I believe, if I recall, we had, that's where Peter Safran offered to reach out to the agent and express which direction we were leaning.
Have you seen any document that says there was any chemistry issues between Amber Heard and Jason Momoa in Aquaman 1?
Documents? No, I mean, those were all conversations.
But if Jason came back and James Wan came back, you were guaranteeing that Amber Heard would play Mira, correct?
That's correct.
Okay. And Jason Momoa was able to negotiate a different compensation structure, was he not, for Aquaman 2?
That's true. He did renegotiate.
Now, Aquaman was the highest grossing DC film ever for Warner Brothers, was it not?
Yes, it was.
And what, if any, issues did you have with Amber Heard in Aquaman 2?
My understanding is actually the production went very smoothly.
All right, thank you. Your next witness.
Your Honor, we call Dr. Culber next, but I know we have a preliminary matter that we need to deal with briefly, if we may approach.
Sure.
Okay. Next witness is going to be the hand doctor that saw Johnny Depp and worked on his hand. We'll have that right after this. They're at Sidebar. More live testimony. Day 21. Johnny Depp versus Amber Heard rolls on next on Court TV. back to Court TV Live. They're still at the sidebars, a long sidebar here. The jury is in the courtroom. They've already heard from one witness, Walter Hamada, who's at Warner Brothers. That's a live look inside the courtroom. Melissa Redmond and Jenny Alcati are still with us. Jenny, do you on this first one, what Walter Hamada, Warner Brothers, basically completely refuted the idea that Amber Heard lost her opportunity with Aquaman and also lost an opportunity to renegotiate a higher contract with Aquaman that we saw from their expert yesterday. Your thoughts on that witness?
I think he's a great witness, and I see that they just left sidebar, but I think he was a really good witness with being unbiased. I think he showed that it wasn't due to anything of any party's decision as to why she didn't get this role. It was just something that was a mutual issue that happened. They didn't have chemistry, and that's that. It's nothing that, you know, one party did that the other did, or there was media surrounding it. It's just, it was difficult for the producers to go through with the movie since there was no chemistry.
Yeah. The sidebar has triggered a mid-morning break, meaning that the sidebar issues were not resolved and it was getting a little bit long. So let's listen in.
All right. We'll go ahead and take a break. Let's make it 10:50 to give them time to look at everything, okay?
Thank you, Ryan.
Thank you.
All right.
All right, clearly there, Melissa, the Heard team has not seen all of the discovery pertaining to this next witness, which is the doctor who worked on Johnny Depp's finger, and he will be rebutting the testimony from their expert witness. And whenever you see one of these breaks to give a party some time to look at material, that means not everybody's on the same page, and that's why the break. Very important that everybody knows what's coming, though. Your thoughts on the importance of this next witness? Because we heard some compelling testimony from the doctor yesterday saying there's no way this bottle story is right.
Oh, it is very important, especially when you consider how detailed Johnny Depp was in telling how that incident happened, how he demonstrated for the jury from the stand exactly how Amber Heard threw the bottle, it hit the bar, and cut his finger. So for Amber Heard to say that entire incident didn't happen, I wasn't even there, that's a major point of contention in this dispute. So if you can have the doctor that says that I looked at that injury, I treated the injury, and based on what I saw, it's entirely possible that this happened exactly the way Johnny Depp described. Is going to be huge for his case. So I'm anticipating he'll be able to do that in rebuttal.
Even though, Jenny, that at the time that he treated Johnny Depp told him a different story, saying that his hand was smashed in a sliding glass door scenario, that might be an issue, and that's definitely going to be part of the cross, because there'll be people who say, well, at the time you weren't questioning this story. If now you believe this story, we should be looking for that.
Yeah, I definitely think it's something we're going to look for, and we'll see it be brought up on cross-examination. But at the end of the day, I think he can make a really good argument for the fact that, you know, he loved Amber and he didn't want to see Amber get hurt. He wanted to do anything possible to make the relationship work. So I think on rebuttal, they will be able to show that and make that a clear indication.
Well, here's Johnny Depp talking about this and saying, well, the reason I didn't tell the truth at first was because I wanted to protect Amber.
They were worried about getting my finger clean, so they tried doing that at Malcolm's. And then the keeper said, no, we got to get to emergency room, and we got to get hold of the tip of his finger. So we went to the emergency room. The doctor asked me what happened. And I lied to him. I said that I had smashed it in these large accordion doors, that it got caught in the accordion doors.
Why would you lie about that?
I lied because I didn't want to disclose that it was what it was. I didn't want to disclose that it had been. I didn't want to disclose that it had been misheard, that had thrown a vodka bottle at me, and then took my finger off. I didn't want to get her in trouble. I didn't want to. I tried to just keep things as copacetic and as easy as possible for everyone. I did not want to put her name in that mix.
Melissa Redmond, that's makes sense, right? That makes sense with, I mean, who would want their that incident to be broadcast everywhere? And we're talking about two notable public figures. You don't know if the nurse or somehow that gets out. It's a game changer. So that makes sense, doesn't it?
It makes absolute sense, especially when you're talking about incidents of intimate partner violence. They are intimate, right? Generally, no one is aware of what's going on. So we lie about the injuries and how they are sustained to emergency room doctors, recover of our bruises with makeup, because generally you don't want anyone to know what's happening. And so we've seen that on both sides of this case. And I think a doctor, an emergency room doctor especially, is very familiar with people who have been abused, people who have been injured as a result of abuse by their partners, aren't necessarily truthful as to how that injury occurred. They don't want the person to be arrested. They don't want anyone to know. And that is very common in abusive relationships. So I don't imagine that the doctor will have any trouble testifying to that fact.
All right, let's do this. Let's get a commercial break in here. The jury has been told 15 minutes to allow Amber Heard's team to go over some material that was just given to them at the conclusion of that sidebar. The next witness for Johnny Depp, his second witness in the rebuttal case that he's putting on, will be Dr. Culber, the individual that examined him and worked on his finger after that incident. Back after this. Welcome back. Court is on a short break in the defamation trial between Johnny Depp and Amber Heard. It is day 21 of testimony, and this is the final week. Depp's team is now presenting its rebuttal case after Amber Heard's team rested their case-in-chief this morning. At the heart of this trial, accusations of physical violence, with both sides saying the other was responsible for the abuse. But while Depp appears to be winning in the court of public opinion, Heard just needs the jury to believe one of the alleged incidents as she described it. Court TV's Chanley Painter takes a look back now at some of the pair's more explosive fights and each one's story.
I was hitting you. I was not punching you. Babe, you're not punched.
Don't tell me what it feels like to be punched.
I'm not sitting here bitching about it, am I? You are. That's the difference between me and you. You're a baby.
In this defamation trial, both Johnny Depp and Amber Heard voiced their claims of physical violence that occurred throughout their tumultuous 15-month marriage.
It was a very violent, chaotic, at times very loving, emotional relationship. Unfortunately, the violence became almost normal, especially towards the end.
Miss Heard, in her frustration and in her rage and her anger, she would strike out. It could begin with a slap. It could begin with a shove. It could begin with, throwing a TV remote at my head.
A lot has been alleged in their physical confrontations with each other, like a slap.
And he just whacks me in the face. I suspected I had a broken nose.
A kick.
I feel this boot in my back. He just kicked me.
A punch.
Bam. And then I just said, is that what you wanted?
Well, he busted my lip when he punched me. It's bleeding in this picture.
A headbutt.
And he balled up his fist, leaned back, and headbutted me square in the nose. Just searing pain.
Things thrown at each other.
She walked up to me and reached and grabbed the bottle of vodka, and then just kind of stood back and then hurled it at me.
Just pulls his arm back with the foam and throws it at my face.
And even defecation.
Fecal matter on the bed. Tried to blame it on the dogs.
According to Amber Heard, the fighting started early in the relationship.
At first it was indirect, and then it became really direct. Then the punching of the walls next to my head, which is a constant at that time in 2012. It would escalate to the point where he would push me or shove me down, and then I'd get back up.
In May 2014, a private plane ride got bumpy mid-flight.
I was looking out of the window, and he slaps my face. And his friend is in our proximity. And it didn't hurt my face. It just felt embarrassed. He just kicked me in the back. I fell to the floor. I caught myself on the floor, and I just felt like I was looking at the floor of the plane felt like a long time.
In March 2015, just a month after they were married, Johnny Depp recalls an alleged violent encounter with Amber Heard. The result, a part of his finger severed.
She threw the large bottle, and it made contact and shattered everywhere. The tip of my finger had been severed. I was looking directly at my bone sticking out. Blood was just pouring out. I don't know what a nervous breakdown feels like, but that's probably the closest that I've ever been.
Amber agrees the fight was violent, but she claims Depp was the abusive one.
I could just feel this pressure. It was like it kept hitting him. It didn't feel pain. It was just a pressure on my pubic bone.
Later that same month, another alleged attack. This one occurred near the staircase of their downtown Los Angeles penthouse.
This took place on the landing, trying to get to me, trying to hit me. And then Whitney, her sister, was there. When she was in between us, Amber snuck in she reached, got the roundhouse in and
I swung at him. In all of my relationship to date with Johnny, I hadn't landed a blow. And I, for the first time, hit him.
On May 21st, 2016, another domestic incident prompted a visit from police. Hurd claimed Depp threw a phone at her, hitting her in the face. These pictures were taken while she was at the courthouse, waiting for a restraining order.
When you filed the domestic violence temporary restraining order, how many acts of abuse did you allege at that time?
I gave the last couple, I believe. Last two incidents, maybe three.
It was enough to get a restraining order, but the jury will have to decide if it's enough to win the defamation case against Johnny Depp.
Such different stories are thanks to Chanley Painter. Both sides telling such different stories about these incidents. Each one of them will have to be discussed with this jury amongst themselves to figure out where the truth lies. Still with us, law professor at the University of Georgia and former prosecutor Melissa Redmond in Atlanta, and trial attorney Jenny Elcotti is in Columbus, Ohio. And they're still on the mid-morning break. This was a break to allow Amber Heard's team to look over some material, so the jury was sent out of the room. And that's what's going on right now, so we're not missing anything. Melissa, when you look at the complexities of these different stories, it's sort of unnerving to think that one of them or both of them are lying to this degree under oath in front of the world. Where do you think the jury is ultimately going to, what are they going to rely on at the end of the day to answer these decisions of who's telling the truth?
They're going to look at the totality of what they've heard throughout the course of the trial, both from each person themselves, Amber Heard and Johnny Depp, as well as their corroborating witnesses. I think at the end it's going to be very difficult then to reach a unanimous decision that either one of them lied about everything that happened. I think more likely what we'll see is that they find that this was a mutually abusive relationship, that Johnny Depp did perpetuate acts of violence against Amber Heard, and she did the same against him. And I think that is more consistent with the evidence that we've seen now. And a lot of times the jury will get instructed from the jury that they have to determine the credibility of each witnesses. And in making their fact-finding determination, believe the witnesses if they're able to do so. So I think it's putting them in a difficult position because you do have just very different descriptions of the same event. But you do have that evidence that obviously something happened here. They have so many bruises, so many videos, telephone conversations or recorded conversations between the two of them indicating that there was violence in this relationship, and parsing out who committed specifically what act of violence against the other, I think it's going to be a wash. And I think they're going to find that both committed acts of violence against each other.
Yeah, and Jenny, there's a lot of people online who are like, they're both disgusting and they should get 0. Is that a possibility that both walk out of here losers?
Absolutely. It's always a possibility. I think something that, to go based off of Melissa's point, another thing is that they're going to have to look at damages too, right? They're going to have to use equations and determine whether or not, how much money do each actually deserve based off of the defamation claim. They very well could say that, both lied, that's it, let's just each give them $1 and call it a day. Or they can maybe say, maybe Johnny's entitled to $15,000. Maybe Amber's entitled to $20,000 or more. I'm just making up numbers. But basically, it's up to them to decide, how much money do they deserve. So they very well could do whatever they want, honestly, whatever they believe.
Yeah, you're making up numbers. Sound like the experts have been doing in this case, making up some numbers. At the end of the day, if indeed the jury doesn't believe, like a lot of people out in the general public, that either one of them is completely truthful, Johnny Depp wins, doesn't he? Well, listen, because before this trial started, he was a wife beater that we can't employ if we're Hollywood. We're going to be, he's off. You can't touch Johnny Depp because he's a wife beater. Has he won then?
Oh, yes. And if you think about it, it's unlikely that Johnny Depp actually brought this suit for monetary damages. He brought the suit to get his story out, to get his version of events out, to change the narrative surrounding his character. And he has absolutely done that in the court of public opinion. Again, we don't know how the jury is interpreting the testimony and the body language and the energy being given by the witnesses testifying there in court. We hope that they're not subject to all of the social media posts that we're seeing. But as far as how he's viewed in the public, he's winning.
Yeah. Again, jury's still out on that mid-morning break. We want to thank Melissa Redmond and Jenny Alcotti. Julie Grant's going to pick up our coverage. Top of the hour. Good morning, Julie.
Ted, good morning to you. Great to see you. So we understand that the jury is back from their mid-morning break, and they're going to be hearing from that doctor who examined Johnny Depp's hand. You know, the whole dispute about whether it was from the vodka bottle or a self-inflicted wound. He's going to rebut what we heard on Monday. We'll be right back with more Court TV Live right after this.
6363.
Good morning. All right, it's my understanding that defense is resting. Is that correct?
This is Court TV Live, your front row seat to justice. I'm your midday host, Julie Grant. We are watching the dueling defamation trial between ex-spouses Johnny Depp and Amber Heard heading to the final stretch. Amber Heard's legal team resting its case in chief this morning. The former spouses are in court for this defamation trial where they're suing the other for millions of dollars. Both of them alleging physical abuse. Amber Heard is alleging sexual violence during their short 15-month-long marriage. Now, following Heard's team resting their case in chief, the Depp team requested, of course, a motion to strike Amber Heard's counterclaim. This is standard in every legal case. Attorneys have to do it. We see motions for directed verdict, motions for judgment of acquittal. In every criminal trial, we bring you here, and that was what happened in this civil case. Of course, after listening to the arguments from both sides, Her Honor denied that motion. The case is moving forward. She found there's plenty of evidence for the jury to decide these questions at issue. Now, right now, Johnny Depp's team is presenting the rebuttal. So after each side got to present their case and Amber Heard presented her defense, Johnny Depp now can do his rebuttal, right? And then Amber Heard's team will have an opportunity for Sir rebuttal. So after that morning break, the next witness the jury's to hear from is Dr. David Culber. He is a plastics doctor. He's a hand surgeon. He's the one that examined Johnny Depp's hand. Let's go in together now.
I don't want to put a circumferential on it because of swelling after surgery. So, I believe in Mr. Depp's case, it was like the two fingers. I think the third finger was the one that was operated on. So these two fingers, the third and fourth finger, are together. And it's a splint with plaster on the top and on the bottom that goes around the hand to protect it.
How mobile was Mr. Depp's hand when it was in that cast?
Well, he couldn't move his third and fourth fingers because of the bulkiness of the splint. Typically, post-operatively, it's a more bulkier splint right after the surgery. So it's not very, it gets in the way.
Could Mr. Depp grab someone with that cast on his hand?
He could attempt to grab someone. I don't know how successful he would be. He had his index finger free and his thumb free, but the other fingers were probably not being able to move.
How long was the pin in Mr. Depp's finger?
About 11 or 12 days.
And how was the pin removed?
It was removed under local anesthesia in my office.
How long did you ultimately treat Mr. Depp for his hand injury?
For several months.
And why was that?
It was a bad injury. It required a few more little office procedures to clean up the tissue. He had an infection as a result of the injury, so he had to be on antibiotics for some time until it finally completely healed.
Do you recall when the infection developed?
It was a few weeks after the surgery, and that's when I took out the pin.
When was the last time that you saw Mr. Depp?
Sometime in 2015. I don't recall when.
And when was the last time that you spoke to Mr. Depp?
The same. Around 2015.
All right. Thank you, Dr. Culber.
All right, cross-examination.
Good morning, Dr. Culber. So you said that this plaster splint was put on after surgery on March 20th, 2015?
Yes.
And a plaster
yeah.
A plaster splint, is that sometimes called half a cast?
Sometimes it's called half a cast or a soft cast, something like that, yeah.
And it's made of plaster of Paris, right?
Correct.
And plaster of Paris hardens like a cast does, correct?
Yes.
So other than the fact that it's a little smaller than a cast that goes around your whole hand, it's just as hard as a cast that would be put on a broken arm or a broken hand, correct?
Well, it's softer on the side so the fingers can expand for swelling. So it's not fully, the plaster appears circumferential around everything. So there are areas that are softer to allow for swelling.
But the parts that are covered with plaster of Paris are just as hard as any other cast, correct?
Correct.
And regardless of whether Mr. Depp could have grabbed someone with the hand with the cast on, he could have grabbed someone with the hand without the cast on, correct?
Correct.
Michelle, can you pull up Exhibit 400, please? This has been admitted, Your Honor.
All right.
Permission to publish?
Yes, yes, sir.
Dr. Culber, I'm just going to ask Michelle here to just scroll through these pictures, and I'd ask you to take a look at them.
Your Honor, I'm going to object for lack of foundation for these photographs.
They're already in evidence.
With respect to the questions to the witness.
They're in evidence. Thank you.
Michelle, if you could go back up to that, stop right there. Is there anything about the cast that was put on Mr. Depp's hand on March 20th, 2015 that would have prevented him from doing this damage to Ms. Heard's closet on March 23rd, 2015?
Objection calls for speculation.
Overruled.
I mean, he had his other hand available, so.
No further questions. Thank you.
All right, redirect.
Dr. Culber, how many fingers were in the plaster portion of Mr. Depp's cast?
I believe 2 or 3, at least 2 were, and the third one and the fourth one.
And why did you call it a soft cast?
Because it's not fully, plaster doesn't go around the entire hand because you allow for swelling. So there's plaster to protect the fracture. So there's a little plaster on it, but it's on the top and the bottom, but it's not completely circumferential. So there's soft spots to it.
And where are those soft spots located again?
Usually we'd put a piece of plaster underneath the fingers and on top, and then the sides of the fingers, it's soft so that the fingers can swell after the surgery.
Could Mr. Depp have hit someone with the hand that had the cast on it?
He could have hit someone with it. It probably would have injured, damaged the cast.
Did you ever notice any damage to Mr. Depp's cast when you treated him after the surgery?
I don't recall. But nothing that comes to mind.
Could Mr. Depp form a fist with the cast on?
No.
No further questions. Thank you, Dr. Culber.
All right, thank you, sir. That completes your testimony. Thank you. All right, your next witness.
Plaintiff calls Richard Marks, Your Honor.
All right, Mr. Marks. Sir, just a reminder that you're... Move it. Hold on, one minute. Just give us a second. I'm on TV. No, sir, you've already... Just a reminder that you're still under oath, okay, sir?
All right, we are going to hit the pause button before that next witness takes the stand, so you won't miss any of his testimony. We saw him before testify in this case. Richard Marks, he is an entertainment lawyer. They're going to tap into his expertise in that area and obviously rebut something that the Heard team introduced in its case. We'll be right back with more Court TV Live after this.
Free at SmileDirectClub.com.
Welcome back to Court TV Live, your front row seat to justice. I'm your midday host, Julie Grant. We are watching the final stretch of the dueling defamation trial of Johnny Depp and Amber Heard. So here's where we are right now. Amber Heard's team rested its case in chief. Now it's time for the Depp team to have an opportunity for their rebuttal case. They've just called their next witness. He is an entertainment lawyer. His name is Richard Marks. Let's go in together now.
Welcome back, Mr. Marks. You've testified in this case previously, but would you just briefly remind the jury who you are?
I'm Richard Marks, and I'm a full-time entertainment transactional attorney. I make deals every day for productions and for individuals. I'm in the trenches negotiating and then making sure the contracts reflect the deals. And I'm very much distinguished from the other side's expert, who is not an attorney, who's not in the trenches making deals, is not in that day-to-day process.
And are you familiar with the testimony of Catherine Arnold in this matter?
Yes.
Have you been asked to analyze that testimony and provide opinions in response?
Yes.
And generally, what are those opinions?
Well, my opinions are that she's very slick and smooth, but she's not an expert in deal making. Her assessment of damages is built on nothing, and it's wildly speculative.
Are you familiar with Ms. Arnold's opinion that it's customary for an actor to renegotiate the fee for a subsequent picture option in a multi-picture contract when a film is successful?
Yes, I heard that opinion.
And are you also familiar with her testimony that under those circumstances, an actor will renegotiate a 50 to 100% increase in their salary for the next optional film?
Yes, I heard her say that.
Do you agree with those opinions?
Absolutely not.
Why not, sir?
Well, what we're dealing with in this case is a test option agreement. And that's an agreement, it's a multi-picture agreement, and it's the nightmare for people like me. The test is going to take place, let's say, for 10 actors the next morning at 9, and you have to fully negotiate a contract that might cover 4 movies and have it signed before they're allowed to test, so that if they're chosen for the part, we have the full contract. There's no renegotiation. So you've got a contract for a multi-picture deal. It's usually a franchise, and you negotiate the first movie. And normally, if they get the part, they're the chosen one, they're the stars born moment, if you will. They get the part. Normally, their salary is inflated from their normal salary, because now they're going to play a character that could go on for 4 movies. In this case, Ms. Heard's first salary when she got the part was $450,000. If Warner Brothers and DC Comics decided to make a next movie, they could recast her. They had no obligation. All they had was an option. But if they did cast her up front, that they had agreed to more than double her salary, like 2.25 times to get to the $1 million. These are large bumps, if you will. If an actor is on a series, say, they go, and they have 5 options. They go up in increments of 5%, 10%, 20%, not these multiples that you see in a test option agreement. And that's one of the reasons that they aren't renegotiated normally. They are in some instances, but not normally.
What's the significance of the test part in a test option agreement?
The test significance is that an established actor usually wouldn't test. They'd be offered the role. Ms. Heard was in a group of actors that needed to be tested to see if the studio wanted to hire them. And then if they hired them, they would be locked up for potentially 4 movies at very lucrative increases, because after Aquaman 1, she gets to $1 million. Aquaman 2, she gets to $2 million. And Aquaman 3, you get to $4 million. These are unheard of bumps if you're going on a normal career and trying to increase your salary by increments.
In your experience, what is customary for negotiations of multi-picture deals?
Well, I think what happened in this case was customary for negotiation of multi-picture deals. And by that, I mean that you assume success. The reason you go from the first Justice League movie where Miss Heard played Mira the first time, the reason you more than double her salary is you assume success. So you've already built in the bonus that Miss Arnold was referring to, a renegotiation, if you will, for the third movie. Instead of doubling her salary, Miss Arnold said it would only be fair to quadruple her salary. And that's just not the way these idiosyncratic contracts work. They're a very small portion of the contracts we deal with.
Are you familiar with Ms. Arnold's opinion that Ms. Heard's salary for Aquaman 2 could have been renegotiated to around $4 million?
I am.
Do you agree with that opinion?
No.
Why not?
Well, as I've said, that would now be after a healthy first payday. It's more than doubled, and now it would be quadrupled. That's not the way it happens. Walter Hamada, who is the president of that part of the studio, said it doesn't happen. They're not going to do it. Ms. Arnold, for some substance, says, well, Jason Momoa got to do it, but she doesn't give us any of the details. We know that Jason Momoa was in a movie before the Justice League. He played Aquaman in a movie not with Miss Mira in that movie. So he had a history before the first movie with Amber Heard. He played Aquaman. We don't know what his contract, the state of it was when you got to Aquaman 2, and she says, unsupported, that he renegotiated. We're not sure what he renegotiated to. But I can say that at the end of the option period, when you've only got one option left, and you want that star in more movies, you may renegotiate, but it's not a gratuity. It's, we'll give you more for the last option if you'll give us 3 more options. It's a give and take. And unfortunately, Ms. Arnold didn't give us any of that background or those building blocks. And then I think yesterday she said, and the other actors renegotiated. And again, we don't know their salary history. We don't know their contracts. We don't know anything except she's asking you just to believe her as what I refer to as a professional expert.
Are you aware that Ms. Arnold's opined that, but for the alleged defamatory statements by Mr. Waldman, Ms. Heard would have earned $45 million in the last 18 months and then the next 3 to 5 years?
Yes, I am.
I'd like to address some of the components of that one by one with you, Mr. Marks. Are you familiar with her testimony that Ms. Heard would continue to make films for approximately $4 million each following Aquaman 2?
Yes.
Do you agree with that testimony?
No.
Why not?
Well, again, in Aquaman 2, Amber Heard has already had this huge increase. She worked on Aquaman 2 for $2 million. What Ms. Arnold is saying is, oh, she should have worked on it for $4 million, which I disagree with, and I think there is reasons to negotiate. They weren't here in this case. So the $4 million I have a disagreement with. But even if it was at $4 million, or if it was at $2 million, the 4 or 5 movies that Ms. Heard might get might be independent movies. They might be standalone studio movies. They might be passion projects. Every actor has a quiver full of quotes, and their highest quote is for the superhero fantasy journey. Their lowest quote might be for the independent passion project, where they'll defer their salary and almost take nothing to work, just SAG minimum. To assume that she'd get 4 or 5 more movies at this, her last fantasy quote, would be to assume that those are also those type of movies, playing another character. And Ms. Arnold says that Ms. Heard's breakout moment, her Star is Born moment, is Christmas 2018. If that's true, and I don't think it's true, those moments don't normally happen to supporting cast, but if it's true, as a deal maker, you would expect, if you represented producers, production companies, to flock in, to take advantage of this hot star and to sign them up. And we have, from Christmas 2018 to spring 20, where there is none of this activity. The Star is Born phenomena didn't happen. Ms. Heard starred in one series of 8 episodes, and she earned a healthy fee, $200,000 an episode. But that's 5 times less than the million Miss Arnold is tossing out, supposedly based on Jason Momoa's quote. She doesn't prove it or give us facts. And Jason Momoa is not a comparable actor. He's been in a series where they shot 78 episodes, 44 episodes, 21 episodes. He played Conan the Barbarian. He was in Game of Thrones. It's not a
Objection, Your Honor.
comparable.
I'm unresponsive to.
All right, I'll sustain the objection. Next question.
Mr. Marks, we'll get to some of those issues in a moment, but I want to take you back for a second. I believe you testified a few minutes ago that your understanding is that the last option in a multi-picture deal might be renegotiated under some circumstances. Do you have an understanding of whether Aquaman 2 was the last option in Ms. Heard's contract with Warner Brothers?
Oh, no. Aquaman 2 has not even been released, and Warner Brothers has a 4th option for Aquaman 3 or another movie where Mira appears, that character, and they've agreed to double the salary again. So it's in success, and that assumes that they recast and that they make the movie.
Are you aware of Ms. Arnold's testimony that Ms. Heard would have made several $1 million on endorsement deals, such as the one she had with L'Oreal?
I'm aware of that testimony.
Do you agree with that opinion?
No.
Why not?
Again, this is a business of personalities. We didn't, after the breakout moment that Ms. Arnold talked about, Christmas 2018, we didn't see endorsement deals flocking to Ms. Heard during that 16-month period before Adam Waldman made a few statements in the London Daily Mail, I believe it was. We didn't see those endorsements coming to her. We didn't, what Ms. Arnold shows you is these non-comparable actors, they had endorsement deals. But she doesn't show you, when she describes the breakout moment and why she's comparing Amber Heard to these, what I call uncomparable actors, but she's making the comparison. She's saying, well, they had all these deals, why wouldn't she? But for the statements that happened 16 months later, and I guess my primary question is what happened in the 16 months, even if you believe 3 statements in the Daily Mail are the stake through the heart of this Stars Born moment.
Do you have an opinion about Ms. Arnold's testimony that Ms. Heard would have made $1 million an episode in a couple of streaming series following her A Star is Born moment?
Yes, I heard it. I have an opinion.
What's your opinion?
Well, after Aquaman 1, this is a major coup. Amber Heard got that role. She tested for it. She could have been the other 19 actresses or 10 or whoever else tested, didn't get it. She got the role, and she got her salary doubled for Aquaman 1 to $1 million. Now, Ms. Arnold wants you to believe that that $1 million would translate into, she'd get that for each episode of a series. We know what she got for a series. She got a series in that period after Christmas 2018, before spring of 2020. She got a series. It was 8 episodes, and it was $200,000 an episode. And Miss Arnold is from somewhere in a glib way saying she got a couple series and $1 million each. And I can tell you, as someone in the trenches, rarely does an actor get $1 million for a series episode. And again, in those 16 months, there were no offers for series at $1 million an episode. In fact, her only series is the 200,000. And if you look at her resume, the series that Miss Heard were in, I think the longest one ran 8 episodes. Jason Momoa, if you were to believe Miss Arnold, and somehow Jason Momoa's agent broke their confidentiality in the agreement, and he had a series at $1 million an episode, if you're to believe that, Jason Momoa has had a series with 78 episodes, with 44 episodes, with 21 episodes, with 18 episodes, with 21 episodes. He was in, again, there's not a comparableness there.
We spoke a few.
That was quite a long answer. We call that in law a narrative. I saw Elaine Bredehoft on the Heard side shaking her head. Object, disrupt it. We gotta object and take a break right now. We are not going to have you miss any of this. We're hitting the pause button, so we'll pick it up right where we are leaving off. Thank you for being with us here on Court TV Live, your front row seat to justice.
on 5.
Can't let Orm find this.
Hey, wait!
What?
Should we have written it down first?
I memorized it. Didn't you?
Huh. Oh, yeah, totally.
What did you just say?
Something, tried it.
All right, that was a little clip of Amber Heard acting in the movie Aquaman. That is what's being discussed right now from the witness on the stand, attorney Richard Marks. Let's go back in where we left off.
We spoke a few minutes ago about the test option agreement. What's the significance of the option part of that agreement?
The option part of the agreement gives the employer, the studio, the option. They don't have to do anything. They have an option to either employ you at a very healthy salary to play this role or not. They can recast the superhero role. You just have to think of how many actors have played Batman or Superman. They can do what they want. And indeed, since there's no contract, they only have a choice to exercise their option or not. They might say, we're not exercising unless you reduce your compensation. Who knows what the negotiation would be, but it's not a contract until the studio exercises the option, and they don't have to.
What's the alternative to an option agreement?
Well, the alternative is most agreements in Hollywood, you're hired to play the role. Or once you exercise the option, then it becomes, for that picture, an agreement like others in Hollywood. You are now hired to play that role. So most contracts are guaranteed, you're hired to play the role. In an option agreement, once they exercise the option, for that movie, it becomes a guaranteed contract.
Are you aware that Ms. Arnold testified that Ms. Heard was released from her Aquaman 2 contract and then subsequently rehired?
I heard that testimony.
Is that consistent with your experience of the film industry in connection with these multi-option contracts?
No.
Why not?
Again, studios don't do things they don't have to do. As we heard Mr. Hamada, the president of the studio, say, you either exercise your option or you don't. They exercise their option. He denied releasing and then rehiring. And in my experience, in almost 5 decades in the business, doing this type of work, not talking about it, not consulting. I mean, I have, I heard Ms. Arnold say she'd been an expert 100 times. I'm a transactional lawyer. I do this occasionally. Basically, it's not a contract till they option it, and they pick up their option, and at that point, it's a guaranteed contract, and then different rules apply to it.
In your experience in the industry, do studios typically comment on those types of actions that they're taking with respect to options?
No, just like Mr. Hamada said, they don't need to comment on it. They either exercise the option or they don't. In Hollywood, silence is the default. You play no card before it's time. And the cards there were exercise the option or not. And I was surprised by Mr. Hamada under oath, basically saying that there was this discussion of chemistry. That
objection, Your Honor, hearsay.
I think it was an in-court statement this morning, I believe, Your Honor. That's fine.
It's the same hearsay that you were. It's hearsay like yesterday. I mean, it's hearsay.
I'll overrule the objection. Go ahead.
Thank you.
I didn't hear.
Go ahead, sir.
Overruled. You can continue, Mr. Marks.
I was surprised to hear Mr. Amata say that they talked about chemistry. That would normally be behind closed doors because it can't help your relationship with the actor. You're either going to exercise or not. And that was quite a bit of candor from someone at his level. And so, therefore, I take it at face value. I think he felt that he was under oath and he was telling the truth, but it wouldn't
Objection,
be...
Your Honor, is...
I'll sustain the objection.
Mr. Marks, are there circumstances where a studio would be more likely to say something about not using an actor again in a franchise?
Yes.
What are those circumstances?
Once they've exercised the option, once the contract is guaranteed, the studio still has the right to pay the actor, but not play them, pay or play them. And that is a rare condition because you've hired the actor, you've got to pay them, but you say, go home, we're recasting. In that situation, after you've exercised the option and the contract is guaranteed, if you pay off the actor, that's normally commented on. That becomes a bit of information because it's not normal.
Is that circumstance different from Ms. Heard's contract with Warner Brothers for the Aquaman movies?
Oh, yeah. Ms. Heard's contract, again, it was just an option. Either we exercise it or we don't. And if we exercise it, she's in the film. If we don't, she's not. Until we exercise it, we have our right to recast or not make the movie. And even after we exercise it, we'd still have a right to recast and not make the movie. We just have to pay her salary.
And we have to take a break right now. We're going to hit the pause button. We'll get you right back into the courtroom after this. This is Court TV Live, your front row seat to justice. I'm Julie Grant. Let's go back to Virginia together now and hear more testimony from a man who works in the entertainment law field. He's being called on rebuttal. He testified previously during the Depp case in chief. His name is attorney Richard Marks.
Do you understand that Ms. Arnold compares Ms. Heard's career trajectory with that of other actors, including Jason Momoa, Gal Gadot, Zendaya, Ana de Armas, and Chris Pine?
I heard that.
And what's your opinion of those actors as comparables for Ms. Heard?
Even Ms. Heard's agent, Jessica Kay, said that 4 of those actors weren't
Objection, Your Honor,
comparable.
hearsay.
I believe same response, Your Honor, that it was in testimony that was played in court earlier this week.
I mean, that's not what she testified to. I mean, he's characterizing testimony that was from days ago, and I don't even think she testified to that, Your Honor.
Or you can cross-examine, overrule.
Overruled. You may continue, Mr. Marks.
Again, they are not comparable. Jason Momoa was Aquaman. Chris Pine was Captain Kirk. Gal Gadot was Wonder Woman. Zendaya has been working on Disney Channel since she was 13. She's in all the Spider-Man movies. She goes by one name. Ana de Armas, when she was in a movie that they call, her breakout, it was as a nude poster. She's been an ensemble piece, Knives Out. These are not comparables. Now, Ms. Arnold stuck to Jason Momoa, who's the most non-comparable because of his history and his career, but she didn't give us the advantage of telling us what his contracts were, what he renegotiated to, what he earned. She didn't give us any of those building blocks. She just she set him up as a comparable and then said what Ms. Heard should earn, but she never gave us the salary of Jason Momoa or the other comparables. And she built like this house of cards on nothing. She showed us with her words, the beautiful clothing that the emperor was wearing. But we could see, if you know the business,
Objection, Your Honor.
that he wasn't.
Beyond the scope of the question.
All right, I'll sustain the objection. Next question.
Okay. You were just speaking about Mr. Momoa as a comparable. Are you aware that Ms. Arnold compares Ms. Heard to Mr. Momoa as an actor with equivalent franchise experience who was able to renegotiate his salary for significant increases in bonus?
Yes.
What's your response to that opinion?
Again, he didn't have comparable franchise experience to Miss Heard. He was Conan the Barbarian. He played Aquaman in a movie that Amber Heard was not in. He played Aquaman, not a supporting character like Mira. It's just not comparable. And you can say the words, but I saw nothing from Miss Arnold to back it up, something to build on, which, if she was a negotiator in the trench, the studio negotiator would say, okay, so show us. Where's the comps? Let's talk numbers, because ultimately that's where we have to get to, not just because you say it's so. We just don't believe you. You've got to show us.
In your experience in the industry, what factors influence the negotiation of the terms of a film agreement with an actor?
Well, first it depends on the film. If the film is $1 million movie and everybody's deferring their salaries, that's one thing. If it's a superhero movie, that's another. But for deal makers and negotiators, the best predictor of what the deal should be is past earnings, precedent, comps. You also look at the budget of the movie, what it can bear, because if Jason Momoa's comp is $10 million, but the budget's $10 million, obviously he has another price for that movie. But the best predictor of future earnings is past earnings.
All right, we're going to hit the pause button right there as we're nearing the top of the hour. We need to hit a break. Before that, I'm going to bring in my guest for some legal analysis. She's a trial attorney practicing in Columbus, Ohio. Jenny Elcotti is joining us today. Hi there, Jenny. Thanks for being with us. Tell me, as you're hearing these amounts of money, and we know they've got to talk about, because civil work is all about the damages, as we know, these are very large amounts of money. Do you think this could potentially be off-putting to this jury hearing this case in Virginia?
I think it could be. I mean, at the end of the day, that's the problem. I mean, we're trying to decipher damages is so difficult. It's so difficult for anybody. I'm going to be honest. It's difficult for me sometimes to determine like how much, you know, you need to figure out with calculations. It's not an easy task to do. So for the jury to also have to make these determinations, it's difficult. So it might be off-putting, but I think at the end of the day, they are, Johnny Depp's counsel is doing a good job at laying that foundation, laying that groundwork that, you know, she is not entitled to this amount of money for the Aquaman movie.
I have to say, counsel is asking all the right questions right now, and this witness is great. I mean, you can tell this is not his first rodeo. He's done this before. We know he's done it in this trial before. And I'm looking at one point, I was watching a video, our camera was focused in on the Heard team sitting at counsel table, and Elaine Bredhoff was shaking her head, and I'm sitting here, you know, staring at the TV going, well, object if there's something wrong with it. Were you thinking the same thing, Jenny?
I was absolutely thinking the same thing. There were numerous questions that were being asked, and his testimony was going way above what was the question being asked. And, you know, if it was Camille, she would have shot that down so fast. But this was, you know, their counsel just is letting it go, which is so shocking to me. I would object even if it gets, even if it's sustained or overruled. It doesn't matter. You should still object if it's beyond the scope of what the question is.
Absolutely, Jenny. You know, and sometimes just to disrupt the flow. I've done it sometimes just to disrupt the flow. And there, I mean, he was giving these narratives, which is improper. And you could say objection, narrative, you know, and the judge can say, okay, ask another question. Let's reframe. And then it kind of stops that momentum. But they're just, you know, sitting there and she's shaking her head. I'm like, well, do something about it. Come on. Be an advocate. All right. So we have just a couple of seconds left here. Jenny, you know, I heard you talking earlier with Ted about the time frame. This is kind of concerning. I have never seen a judge put a time limit on a case like this where they're actually counting the minutes. Have you?
I've never seen that happen before. You know, I've had a 6-week-long trial for a hernia mesh trial. You know, I sat in with my boss on it. But and after that 6-week-long trial, the judge did turn around and say, you know what, let's make the next bellwether trial 3 weeks. So I've seen things like that. I've never seen it down to the minutes. That to me is just insane.
Yeah, no, absolutely. Jenny Elcotti, thank you so much for coming on the program today. We'll look forward to seeing you again soon. And thank you to you at home for being with us. We're going to squeeze in a break. We'll be right back with more Court TV Live after this.
800-371-4204. 800-371-4204.
So glad you are with us on this Tuesday afternoon. I'm Julie Grant, your midday host. We are watching the dueling defamation trial enter its final stretch in Fairfax County, Virginia. Where we are in the case right now is in the rebuttal portion. So this is where Johnny Depp's team gets to present evidence to rebut what Amber Heard's team presented. I've got some great questions about this on Twitter. So what happens is they call the witnesses and then the Heard team can cross-examine them. Then the Heard team will have time for rebuttal, which is the response to the Depp rebuttal. So it's all the back and forth, kind of like a ping pong match or something. So where we left off in the last hour was with a man named Richard Marx on the stand. He is not the famous singer-songwriter Richard Marx. He is an entertainment lawyer, and he is giving some testimony that goes to the damages, the money. We're hearing about these large amounts of money at issue. Remember, Amber Heard's asking for $100 million. So what he's saying about Aquaman is to refute that. So we're going to pick up now where we left off.
And I didn't see any Ms. Arnold talk about past earnings at all, except the earnings in this rarefied superhero four-picture deal where instead of incremental increases, which you normally see, it was multiples increases. And then when you get on a series, the big renegotiation was when the network has no more options. Until then, the actors on the series get 5, 10, 15 small percentage raises. They don't get multiples. They get the multiples if it's a success and the studio wants to continue making the series and they want to keep these characters. That's when the renegotiation happens. Here, even if we believe Ms. Arnold, after Aquaman 2, there was still an option waiting at a big price, double the previous payday.
What's the significance of the timing of the Waldman statements to the opportunities Ms. Arnold claims Ms. Heard lost?
Well, the argument, as I understand it, is that Ms. Arnold says that Ms. Heard lost all these opportunities because of those losses were caused by Adam Waldman's statements 16 months later. So I think the timing.
Sure.
All right, so we're seeing the attorneys approach the bench to hash this out outside of the hearing of the jury. And as we're looking at the gallery, we see it is packed yet again. Day after day, you see all of those fans, the great majority of them there to support Johnny Depp in the courtroom. They wait overnight, they camp out to get the wristbands. Let's listen in together now.
Mr. Marks, what's your overall assessment of Ms. Arnold's opinions in this case?
My overall assessment of her opinions is that they're not worth the paper they're not written on. She knows something about our business, but not about negotiating deals. She may have gotten someone at the Endeavor office to breach confidentiality, but she never laid out the building blocks.
Excuse me, just an objection. You have to stop talking, Mr. Marks. Thank you. Beyond the scope.
Yeah, Mr. Marks, can you just limit your testimony to your opinion about Ms. Arnold's opinions, please?
My opinion, as someone who's made deals as a deal maker for almost 50 years, is that she calls herself an expert, but she's not. She doesn't have the background. She doesn't have the day-to-day knowledge. And her testimony that I heard did not back up her bottom line. If you want to get those figures, you have to show why they're deserved. And again, she was constructing a Jenga without the bottom pieces. It does not hold up under scrutiny by someone who makes deals.
No further questions.
All right, cross-examination.
Good morning, Mr. Marks.
Good morning.
So you agree that studios use comps to negotiate deals, correct, with actors?
Sometimes they do.
And you have an issue with the comps that Ms. Arnold used, correct? As you testified to.
I have an issue with the comps that she says she used that she didn't disclose.
The comps being the actors that you just talked about. She did disclose, she disclosed the actors.
She disclosed the actors and budget figures from their movies. She never disclosed their salaries and salary history as comps.
You're not offering a different set of comparators that should be used, correct?
I'm saying if you are going to...
That's not my question. Are you offering a different set of comparators than what Ms. Arnold used?
I'm not here offering comparators. I'm saying what she offered are not comparators.
That was my question. You're not offering comparators, correct?
No, I would say that Ms. Heard's comparisons are where you look.
That was my question. Could you motion to strike after the...
All right, we'll strike after that. Just answer the questions, Mr. Marks. Thank you.
Now, you're a deal maker, correct?
Yes.
What actors have you negotiated for in superhero movies?
Well, recently I've negotiated for Chris Pratt in a superhero series for Amazon. I've negotiated a deal for Michael Douglas, not in a superhero movie, but a historical movie. I've negotiated recently a deal for Paul Rudd and Will Ferrell on an Apple series. Billy Crudup on an Apple series. Those are the recent talent deals.
What actors have you negotiated for in a superhero movie?
As I sit here now, I can't remember a superhero movie that I've negotiated. I've certainly negotiated over my career franchise movies and fantasy movies.
Your Honor, so it's no, you haven't negotiated with for any actors for superhero movies, correct?
So you would define like, I don't know, Jungle Book isn't a superhero movie. It's more of a fantasy.
Okay, so no, correct. Your answer is no.
All right. So as I sit here, I can't think of a Marvel type superhero movie that I've negotiated. Although I know there's one or two in there.
Now, you testified and you agree that Mr. Momoa negotiated his multi-picture contract for Aquaman 2, correct?
I heard Mr. Hamada say there was a renegotiation, but no facts were pro-offered, such as he didn't have an option. His options were out. What he was earning and what he renegotiated to, and he is Aquaman man. So yes, I did hear there was a renegotiation.
And you understand that his salary went from $3 to $4 million to $15 million.
If you tell me that, I haven't seen his contract and I haven't heard any testimony under oath that that's where the leap was.
Now, Ms. Heard's contract.
Did he get more? Did they get more options for when they made that leap? Did they get more options?
Ms. Heard's contract was a talent option contract, correct?
Yes.
Okay. And you agree that for if there's an Aquaman 3, Ms. Heard would have an option to receive $4 million, correct, for the movie?
Well, actually, you would language it. Warner Brothers would have the option to engage her.
And if they engaged her, she would receive $4 million, correct?
She doesn't have the option to refuse. they have the option to engage her.
And she would receive $4 million, correct?
Yes, $4 million.
Would you agree that the money Amber was making on Aquaman 2 or 3 would be her market rate for future studio movies?
I would think it would be her rate for future studio superhero movies, but not necessarily studio movies that aren't superheroes. That could be standalone. That could be other type of studio movies.
But for studio superhero movies, it would be $4 million, correct?
If I was Ms. Heard's agent, that's where I would start.
Okay.
Assuming everything was equal, the budget of the superhero movie, that she was in the ensemble. There's a lot of ifs to look at, but all things being equal.
You agree that Aquaman was a breakthrough role for Ms. Heard, wasn't it?
It's the first movie of that ilk that she makes, but she is not Aquaman. She is Mira.
But it was a breakthrough movie for Ms. Heard, correct?
For her, it's a breakthrough movie to be in that film and in the ensemble. Absolutely.
And she was the female star of that movie, correct?
I believe so.
You would agree that for all of the actors Ms. Arnold listed as comparables, their career trajectory went up after their breakthrough, correct?
She didn't give us the raw materials to look at, but I'll take your word that all those unrelated actors in unrelated films, except for Jason Momoa, they went up. As did Miss Arnold's when she went from 1 to 2.
In your experience, can you identify an actor or an actress who's not been able to get a new studio movie after a breakthrough performance in a superhero movie?
As I sit here now, I haven't been asked to opine on that, but there are lots of supporting characters in movies that don't appear in the next movie.
But a female star in a breakthrough movie in a superhero movie, can you identify any actress who's not gotten another studio movie after that?
Well, after Miss Heard's breakthrough in 2018, she did get Aquaman 2.
Aquaman 2 was already, she already had the option for Aquaman 2,
all right,
correct?
so she did. Miss Heard did not get any movies after 2018, long before the Adam Waldman statements.
Other than Miss Heard, can you identify any actor or actress who's not gotten another studio movie after their breakthrough in a superhero movie?
As I sit here now, I haven't been asked to research that, and I can't. That would be a normal thing.
And you're not providing an alternative number for Miss Heard's damages, correct? For the jury.
Correct. I'm not providing an alternative number. I think, she's been more than adequately paid.
I'd move to strike after no, I've not been provided another number. That's all. I mean, my question was you're not providing another number.
I think it's in fairness and the full answer of the question, Your Honor.
It was a yes or no question. He said his answer was no.
I'm not going to strike it.
Okay.
Oh, I was just sending out a tweet that this attorney should have known better than to ask an open-ended question, and he didn't do it just once. He did it multiple times, and this witness, who is like a professional witness, he's a lawyer, is running away with every answer, as he should, and that's the fault of the advocate. You've got to control your witness on cross. All right, we'll be right back with more Court TV Live after this. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. So we are seeing the cross-examination of one of the rebuttal witnesses called by the Depp team, attorney Richard Marks. Let's go in where we left off.
All right, no further questions.
All right, redirect.
Mr. Marks, in response to some questions from Mr. Lederhaft, you were discussing some franchise and fantasy movie agreements that you've negotiated with actors. Could you just describe some of those for us?
I've had such a long career that I mainly forget what I've done, but I negotiated all the contracts for Pinocchio, if you will, that was produced, Is Coming to America, the original, is that a fantasy movie? The Golden Child, is that a fantasy movie? And by the way, I may have negotiated contracts and ultimately the film wasn't made, but as I sit here now, those are the only ones that come to pass. If I was looking at my resume or going through my files, I might think of others, but there isn't a deal that I haven't made.
And I think you also testified in response to Mr. Nadelhaft's questions that you have negotiated some deals for Chris Pratt and Paul Rudd. Do you recall that testimony?
Yes, these are for a streaming series.
Do you happen to know if both of those actors have played Marvel superheroes?
I believe they have, but don't quote me because, that's not my genre.
Okay. No further questions, Your Honor.
All right. Thank you, Mr. Marks. You can, you're free to stay in the courtroom or you can leave, okay?
Thank you very much.
Thank you. All right, your next witness.
Plaintiff calls Michael Spindler.
Michael Spindler.
Okay, while they're getting their next witness to the stand, let me bring in my guest. She is a former prosecutor, a practicing criminal defense attorney in Atlanta, Georgia, and the host of the new Diva Court podcast. Marsha Minot is on the show today. Marsha, great to have you with us. Tell me, when I was watching that cross-examination, all I kept thinking was that attorney needs to control this witness. Your thoughts, please.
Yes, cross-examination is an art, and you have to make sure that you're asking leading questions, not open-ended questions, because that gives your witness an opportunity to give a narrative that sometimes is not in your favor.
Exactly, and I saw the Heard team just sitting there not objecting to the narrative. Okay, we got the next witness in the box. Let's listen in live.
I've got over 40 years of experience.
Are you familiar with the testimony rendered by Ms. Arnold in this matter?
Yes, I am.
Do you understand that Ms. Arnold testified that Ms. Heard has suffered economic damages resulting from 3 statements made by Mr. Waldman?
Yes, I do.
Do you have an opinion of that claim?
I do.
Objection, Your Honor. May we approach?
All right.
All right, so the witness just took the stand. Apparently he was on the side of the courtroom. We couldn't even see him take the stand because of our camera positioning. And he is a forensic accountant. So obviously he's gonna offer some expertise as to the money damages. And right as he's up there, we've got a sidebar. Attorney's approaching Her Honor, showing some documents here. I'm wondering if this is some kind of an argument over what evidence might be introduced through this witness. There they are. Okay, let me bring in Marsha Minot, my guest again. So Marsha, with these money amounts, I was chatting with our guest in the last hour a little bit about this, and I'm curious your thoughts because you've tried a lot of jury trials. These are high amounts of money to most people. Maybe not for these 2 actors who live in Hollywood, but I'm wondering what kind of an effect this may have for the jury. And I may have to ask you to hold your answer because they just broke up. Let's listen in to the next question.
Now, you indicated that you had listened to Ms. Arnold, and she testified on behalf of Ms. Heard relative to economic damages. Have you formed an opinion as to the testimony and opinion rendered by Ms. Arnold?
Yes, I have.
And what's that opinion?
It is not adequately supported and it is unreasonable.
There were multiple elements to that analysis, both damages related to her film career and to endorsements. Have you analyzed both those issues?
Yes, I have.
What is your opinion of the claims that have been asserted relative to the film career and endorsements?
Okay, well, first of all, with respect to her damages calculation, there was no calculation per se. She initially looked at these comparable actors and seemed to use that as a basis for numbers. She didn't provide the underlying calculation. She didn't provide underlying support. And then it appeared as though in her testimony, she backed away a little bit from that, but she still suffers from the issues of not providing detailed calculations or support for where those numbers come from. And she still, to some extent, appears to be using some kind of comparable analysis.
All right. What is the type of analysis that you think is appropriate here?
Well, I think, and as you heard from the last witness, I think that something that is anchored in facts, taking a look at historical compensation as a basis for anticipating future compensation.
Had you looked at Ms. Heard's prior compensation?
Yes, I have. I've looked at tax returns that were provided for the period of 2013 through 2019.
Why do you want to use historical earnings?
Well, once again, you want an analysis that's anchored in fact. I don't believe that Ms. Arnold has done that in her analysis. So here we've got some actual data, we've got some historical compensation, and as the last witness mentioned, that often provides somewhat of a basis for future anticipated earnings. In addition, I believe that Ms. Arnold herself said that she had hoped to be able to look at a renegotiated salary for Aquaman 2 and then use that as a basis for future compensation, that being the new kind of base, if you will.
All right. Were there any years in particular that you focused on in your analysis as to Ms. Arnold's testimony?
In terms of the historical compensation?
Yes.
Well, for 2013 through 2019 in total, her compensation was around $10 million for all those years combined. In 2019, the last of those years, her compensation was somewhere between about $2.6 million and $3 million. Now, that's a good year. That's known as a clean year.
What do you mean by a clean year?
Well, you know, for example, 2019, you had Aquaman was released in December of 2018, and that was a successful film. So in 2019, you've got the benefit of that kind of success, and you also don't have any potential impact from the alleged defamatory Waldman statements that occurred in April of 2020. So 2019 is clean of all that.
What did you understand Ms. Arnold's methodology to be?
Her methodology initially appeared to be based on these comparable actors that she had identified, and theoretically, the compensation that they earned, although she doesn't identify what that compensation is or provide any support for it or any calculations.
What is your opinion of that methodology from an accounting perspective?
That methodology was unsound. It's just unsupported. There are no numbers, there's no data that she provided as support for that.
What methodology did you understand Ms. Arnold to adopt at trial?
Okay, well, it looked like somewhat of a mix and match approach. She used different approaches, I believe, for different elements of the damages, although it's still a little bit unclear to me, a little bit vague. But there are 4 basic components that she was looking at, and we can go through those in any order you wish.
All right. With respect to the television series portion of her analysis, what do you understand that methodology to be?
Okay.
Objection, Your Honor. May we approach?
All right.
All right, we are going to squeeze in a break as well while they're up there having that sidebar with her honor. Don't go anywhere. This is Court TV Live, your front row seat to justice. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. We are watching Depp versus Heard playing out in its final days in that courtroom in Fairfax County, Virginia. The judge has put a time limit, even down to the minute, for the parties involved in this case. And so right now, we're on Johnny Depp's rebuttal case. We're hearing from a forensic accountant. There was an objection and something the attorneys wanted to discuss at sidebar in terms of evidence and methodology that could come in before the jury in terms of those money calculations. How much is anybody owed, or is anybody owed anything? It's what the jury's going to decide. Let's go back in where we left off.
The earnings from television shows. Did you analyze what historical earning Ms. Heard had during the period that you were concerned with relative to television shows?
Well, yes. During 2019, she entered into a contract in July of 2019 to appear in a television series at $200,000 per episode.
All right. What about endorsement deals? Did you look at what she had made on endorsement deals during that period?
She did have a contract with L'Oreal at $1,625,000.
All right. With respect to her movie roles, what were her historical earnings during that period?
Well, certainly for the most recent years, you had the Warner Brothers deal, which was a 4-picture deal. The first film was $450,000. Then the first Aquaman was $1 million base fee. Then $2 million for Aquaman 2, and presuming that there was an Aquaman 3, that would have been $4 million.
Okay. Why do you look at historical earnings as part of your analysis?
Because you want your analysis to be anchored in facts. You want it to have a sound methodology, and you want to come up with a reasonable result. So if you take a look at, for example, the analysis that Ms. Arnold did, it didn't appear to be...
Let's just look at the analysis that you're doing. What you said, I think, is you wanted them anchored in facts. Why?
Because that provides a sound basis for coming up with something with reasonable certainty. There's AICPA, or American Institute of Certified Public Accountant guidance with respect to reasonable certainty. And those are the basic elements of it.
Thank you. No further questions.
All right, cross-examination.
Hello again, Mr. Spindler.
Good morning.
I'm going to ask you a few questions that may refer to the statements in Amber's counterclaim against Mr. Depp. When I refer to those statements, I'm going to refer to them as the Depp-Waldman statements. Do you agree that we can both be on the same page what I'm referring to when I say that?
That's fine. You can use your terminology.
I'm sorry, there's an objection, sir. If you hold on.
Can we approach?
Okay.
So, Mr. Spindler, when I refer to the Depp-Waldman statements, you understand me to be referring to the statements in Ms. Heard's counterclaim against Mr. Depp, correct?
I'll understand that, yes.
Now, you're here to provide a rebuttal opinion to part of Miss Arnold's testimony, correct?
Correct.
You're not providing opinion on whether Miss Heard suffered defamation by Mr. Depp, correct?
That is true.
You're not offering an opinion as to any of the underlying facts relating to whether Mr. Depp abused Amber, correct?
That's correct.
You're not offering an opinion as to the magnitude of damages that you believe Miss Heard may be entitled to if she proves defamation by Mr. Depp. You're just reviewing what Miss Arnold has said, correct?
That's correct.
And you said that you want your analysis to be accurate in the facts, right?
Anchored in facts.
Anchored in facts. You'd agree that what an actor earns in one period isn't necessarily reflective of what he or she may earn in future periods, correct?
Correct.
And that's because
there can be some variability.
An increase in the number of roles may lead to greater income, correct?
I'm sorry, could you repeat that? I was speaking, I didn't hear.
One of the reasons that what you earn in one period may not be reflective of what an actress may earn in future periods is because an increase in the number of roles may lead to greater income, correct?
The number of roles or the particular project itself, yes.
Sure, getting better roles may lead to greater income, correct?
Correct.
And the same is true for an endorsement. As an actress's profile grows, the amount of money that she may be able to earn from endorsements grows as well, correct?
It can.
So
it depends.
What Ms. Heard earned from, say, 2013 to 2019 that you testified to isn't necessarily reflective of what she might earn over the next 5 years, correct?
Not necessarily. It is a good indicator, though.
And you'd agree that from 2013 to 2019, in terms of earnings and star power, that Ms. Heard's career trajectory was on the upswing, correct?
There was a slight increase during that period of time in her earnings from 2013 through 2019.
And you'd agree that that was as a result of getting more lucrative roles, right?
Yes.
Now, you're not a causation expert, right? You're just a damages expert?
That's correct.
So you're not testifying as to whether the Depp-Waldman statements caused her to lose any roles, correct?
That's correct.
And you're not offering any opinion as to whether the Depp-Waldman statements kept her from being considered for roles that she otherwise would have been considered for, correct?
That's correct. I'm not testifying on causation issues.
And you can't speak to what opportunities may never have materialized for Amber as a result of the Depp-Waldman statements, correct?
Yeah, I've not done those calculations.
And you don't have an opinion about whether or not Ms. Heard could have renegotiated a contract for Aquaman 2, correct?
That was not part of my work.
And you don't have an opinion on the impact that additional exposure or press coverage or magazine covers or interviews would have had on Ms. Heard's career, correct?
Correct. I'm just looking at Ms. Arnold's calculations.
You've never served as an expert witness before to calculate damages based on lost roles by an actress resulting from defamation against that person, correct?
I've been involved in defamation cases, but I've not done the calculations as an expert witness and testified there too.
And there's never been an instance in which you have served as an expert witness in a case to calculate damages based on alleged defamation against an actress, correct?
Correct.
And you're not offering any expert opinion on what impact the alleged defamation by Mr. Depp has had on Ms. Heard's career, correct?
I'm sorry, one more time?
You're not offering any expert opinion on what impact the Depp-Waldman statements by Mr. Depp has had on Ms. Heard's career, correct?
Other than taking a look at Ms. Arnold's calculations.
And you're not offering any expert opinion about what impact, if any, social media coverage of this case or of Ms. Heard may have had on Ms. Heard's career, correct?
You're correct. That's other experts.
Can we approach
No
her?
further questions. Thank you.
All right.
For you.
Okay.
All right, thank you, Mr. Spindler. You can have a seat in the courtroom, or
Thank you,
you are free to
everyone.
go. Thank you. All right, your next witness.
Plaintiff calls Doug Banya, Your Honor.
Okay, before we hear from the next witness called by the Depp team, we're going to squeeze in a break. Thank you for being with us here on Court TV Live. Thank you so much for staying with us. I'm Julie Grant. Just called to the stand by the Depp team for some rebuttal is witness Doug Banya. He's a social media and internet analytics expert.
Good afternoon, Mr. Banya.
Good afternoon.
Can you briefly reintroduce yourself to the jury, please?
Yes, hi, Doug Banya. I am from Nevium Intellectual Property Consultants based in San Diego. I value intellectual property. I provide litigation support in infringement and defamation cases, as I'm doing today. And I use internet and social media analytics in both of those services.
Since you last testified in this case, the jury has heard testimony from Ronald Schnell and Catherine Arnold. Are you familiar with their testimony?
Yes.
Were you asked to analyze their testimony and provide opinions in response?
Yes, I was.
Have you formed opinions in response to the testimony of Mr. Schnell and Ms. Arnold?
I have.
Generally, what are those opinions?
Generally, Mr. Schnell provided no evidence of a correlation between the Waldman statements and the hashtags and the spikes of those hashtags on Twitter. Second, based on my internet and social media analytics investigation, I've concluded that the alleged comparable actors that Ms. Arnold came up with are not comparable with Ms. Heard. And then thirdly, Mr. Schnell and Ms. Arnold both failed to provide any evidence of a causation as it relates to the Waldman statements causing any economic harm to Ms. Heard.
Let's dig into those opinions a little bit. You're familiar with the testimony of Mr. Schnell that there are more than 2.7 million alleged negative tweets related to Ms. Heard between January 2018 and June 2021?
Yes.
And what's your understanding of how Mr. Schnell identified those particular 2.7 million tweets?
Yeah, so essentially Mr. Schnell chose hashtags that he felt were negative towards Ms. Heard. Those hashtags range from justice for Johnny Depp, Amber Heard is an abuser, Amber Turd, and the hashtag, we just don't like you, Amber. So then he used those hashtags and he searched through, using the Twitter API, searched through various tweets and then came up with any tweets that were using those hashtags.
Did you conduct an analysis of those tweets?
Yes, I was given that exact, the data that Mr. Schnell used on a hard drive. So yes, I dug into that data as well.
And what was the purpose of your analysis?
So what I'm trying to do, and what's at issue of the case today at this point is, were these tweets, did they contain the Waldman statements? That's what where we're at right now, are the Waldman statements. So I wanted to analyze those tweets to determine which ones, and if any, contain the Waldman statements.
And what's your understanding of what the Waldman statements are?
So my understanding is there's three Waldman statements that were published in the Daily Mail. The Daily Mail is a UK tabloid, and Mr. Arnold was quoted in three of those articles. And those dates were on April 8th, 2020, April 27th, 2020, and on June 24th, 2020. And my understanding that those quotes, sorry, I think I said the wrong name, but those quotes are the only remaining in this case.
Did you analyze the timing of the tweets that we were talking about as compared to the timing of the Waldman statements?
And that's exactly what I did. So I wanted to look at the Waldman statements, look at the dates that they happened, and then analyze those as compared to the Twitter data that I had.
Have you prepared a demonstrative that reflects that aspect of your analysis?
Yes.
Your Honor, may I approach?
Yes. Did you show counsel? Any objection? All right, so 1293 will just be marked for identification as demonstrative and can be published to the jury.
Mr. Banya, can you explain to the jury what this demonstrative shows?
Yes. So this shows the total hashtags and tweets that Mr. Schnell was analyzing. This is the summary data. They're tweets that are running from January 2018 to June of 2021. And again, these are related to the four hashtags that I discussed. Whenever I get an assignment such as this, when I'm dealing with a defamatory statement that's allegedly gone viral online, where there's economic damages involved and there's a lot of data involved, I like to take the data and I like to do a 30,000-foot view of the data to see what I'm looking at, to see if there's anything interesting, odd, different about the data. And the first thing that I noticed is 35% of the tweets were prior to the Waldman statements. So again, remember, my assignment is to determine if the Waldman statements are part of the tweets that Mr. Schnell analyzed. So obviously, if these tweets were prior to the Waldman statements, in no way could they have anything to do with the Waldman statements. So that was the first issue that I noticed. Then I noticed what I like to call kind of the alleged defamatory time frame. And as I discussed, that's when the Waldman statements were published. That's the date down here. You know, the first one was in the beginning of April, and the last one, which is the third one, was at the end of June. But what I found interesting is only 2% of all of the tweets happened during this Waldman statement period. So really, these are just observations. And for me, there were red flags that I made note of. And then I just continued with my analysis.
What other work have you performed in connection with forming your opinions about the purportedly negative tweets?
Yeah, so now I realize that 35% are irrelevant and 2%, only happened during this important period. I just continued to dig into the 2.79 million tweets that Mr. Schnell provided.
And Tom, can we take that one down? And Mr. Banya, have you prepared another demonstrative that depicts that analysis that you were just describing?
Yes.
All right, we have to hit the pause button before we hear more from this internet and digital analytics experts. We're going to squeeze in a break. We'll get back to Depp versus Heard on the other side. Thank you for being with us here on Court TV Live this Tuesday afternoon. I'm your midday host, Julie Grant. So we are in the final stretch of this very lengthy defamation case playing out in Virginia. Johnny Depp versus ex-wife Amber Heard. They're both suing each other. They're both alleging the other party was abusive. They're both asking for millions of dollars in damages. But this jury is who has the power. This jury is going to decide in the end whether anybody is liable and whether anybody deserves any money. So what we want to do now is go back in exactly where we left off in the last hour. The Depp team is on rebuttal, and they called somebody who has expertise in social media and digital analytics. Let's go in now where we left off. They were talking about some of those hashtags that have been problematic.
Okay, we'll just see if he has an objection. No, I'll give you time to look at it, sir. All right, plaintiffs. If you turn on the microphone, I'm sorry.
No objection as a demonstrative.
Okay. All right. Plaintiff's Exhibit 1294 will be marked for identification as a demonstrative and will be published to the jury.
Thank you, Your Honor. Mr. Banya, can you explain what this demonstrative shows?
Yes, this is showing the various spikes as it relates to the hashtags that Mr. Schnell testified about. This is actually an exhibit or a demonstrative that he used in his testimony. What this is showing are the largest spikes related to the hashtag Justice for Johnny Depp. I don't know if you remember his testimony or any of his demonstratives. The other three hashtags did spike at the same time, but a very small spike. So what I'm showing you here are the 6 top spikes in Mr. Schnell's analysis. And what's important here again is the very first spike and the largest spike again happened before the Waldman statements. So what I'm trying to figure out is what tweets were related to the Waldman statements. So this number 1 spike, which is the biggest spike, was prior to the Waldman statements, so it's irrelevant to the case. And then the second thing I noticed that was interesting here is here are the dates in gray right here. This is the time in which the Waldman statements happened. And you're going to notice, as we discussed before, only 2% of the tweets happened during that time. But I found it very interesting for such a viral event that has potentially caused such economic harm. There's no spikes in this area. And actually, you're going to see that Mr. Waldman, his statement came out here in the first April 2020 article. Then the second one came out here. And then the third one came out in June. There's actually a downward use of the spike, downward use of the hashtags. So I'm not seeing any correlation as it relates to the Waldman statements and any spikes here as it relates to the hashtags Mr. Schnell chose.
Did you analyze each of the spikes that are depicted here?
Yeah, so what I did is I looked at the 6 different spikes, and you're going to notice that each spike represents a month. So the second spike, is July of 2020, and so on to the 6th spike going to April 2021. And what I did is, I don't know if you remember in my last testimony when I went into Google search, and I'm able to go into Google search, I went in and I typed in Amber Heard. And then after you hit search, you can use the tool and you can go back in time. And I chose each 6 of these dates to go back in time to see what was the media talking about back then. What was the general public being fed as it relates to Amber Heard back during those spikes. And what I found is none of them Well, I analyzed the top 3 search results because they represent 50 to 70% of what people click on. And I realized that none of them had anything to do with the Waldman statements.
Are you aware of Mr. Schnell's testimony that the tweets using the 4 hashtags he looked at were mathematically correlated?
Yes.
What does that mean?
So what Mr. Schnell is saying, which is irrelevant to this case, is the 4 hashtags that he randomly chose, they tend to go up and down together, and that's why he had these spikes here. So the correlation there is how those 4 hashtags work or dance together going up and down. But first of all, the hashtags have nothing to do with the Waldman statements. And the fact that there's a correlation with the hashtags is irrelevant to this case because we're dealing with the Waldman statements, which none of that correlation analysis he did had to do with.
How do you know that the correlation doesn't have anything to do with the Waldman statements?
Can I clear this at all? No. Oh, yeah. Well, first of all, I know because that would happen right here. You know, if when Mr. Waldman, one of his quotes was published, you would see a big spike right here. And then you would see maybe a little noise down here, and then the third time you might see second time a big spike, and the third time a big spike. That's not here. So that's telling me there's no correlation between the Waldman statements and this hashtag use. And then I've actually provided evidence that there's no correlation because I analyze each of these spikes, and none of them had to do with the Waldman statements.
Is mathematical correlation the same as causation?
No.
Why not?
I mean, correlation is simply a relationship between 2 or more variables or 2 or more things. In this case, the correlation question is, when the Waldman statements were published, at the same time, did you see a correlation with spikes in these hashtags? And again, can we clear this? You see none of that right here. It's actually a downward trend. There's no spikes, there's no correlation. So, you know, again, Mr. Schnell provided no evidence of any correlation.
What correlation opinion did he provide during his testimony?
Well, he provided the correlation that the 4 hashtags, you know, spike together. But again, the hashtags have nothing to do with the Waldman statements, and the fact that they're correlating or moving together is irrelevant to the case because the case is about the Waldman statements.
So what is causation then?
So causation is where one thing causes a change in the other. So as it relates to this case, did the Waldman statements cause Ms. Heard to have economic harm? In other words, did the Waldman statements cause Ms. Heard not to make as much money in her career? And again, Mr. Schnell provided no evidence of this. Ms. Arnold provided no evidence of this. And as a matter of fact, during Ms. Arnold's testimony yesterday, she didn't even know what causation was. You know, she was asked, do you know the difference between causation and correlation? And she said that she's not a semantics expert. We're not talking about the words. You know, when it comes to damages, you have to prove causation prior to calculating damages. You know, so there is no causation that's proven here. Therefore, a damages analysis is not appropriate.
Did you hear Mr. Schnell testify that he agreed with your opinion in this case?
Yes.
And what's your understanding of the opinion that he agreed with?
Well, he agreed that he failed to link the spikes in the hashtags on Twitter to the Waldman statements.
Did he try to do that?
He tried to do that. But again, his analysis was looking at the word Waldman and looking at the word Waldmanian and then trying to say that 25% of the tweets included those 2 terms. But first of all, Waldman isn't the issue here. It's the Waldman statements. And Waldmanian, I don't even know what that is, but it's not relevant to this case.
We can, I think, take that one down, please, Tom. Mr. Banya, what other work have you done in connection with forming your opinions about Mr. Schnell's testimony?
Again, the assignment was to determine if the Waldman statements were part of the tweet, so I continued to dig in, to the data. I believe the next step is, now that I've excluded, the 35% that was before the Waldman statements because they're irrelevant, I wanted to really analyze from the April 2020 forward to see if any of those tweets, contained the Waldman statements.
Did you prepare a demonstrative that reflects that analysis that you did?
Yes, I did.
Your Honor, may I approach again?
All right. Yes, ma'am. Any objections, sir?
No objection as a demonstrative.
All right. We'll mark it for identification as plaintiff's 1295 as demonstrative and published to the jury.
So, Mr. Banya, did you consider the content of the statements made by Waldman as part of the work that you did?
Yes. Yeah, so here I reviewed the Waldman statements again, and what I wanted to do is I wanted to determine what, if any, tweets included the Waldman statements. So what I went back to the Waldman statements, and I came up with key terms and key themes for those Waldman statements, which are listed here. The Waldman statements were about abuse hoax, sexual violence hoax, and fake sexual violence. So what I did is we're now dealing with a 1.2 million tweets because, we're starting in April 2020 because that's when the Waldman statements started. And what I did is I searched the 1.2 million tweets, for these three phrases. And I determined that there were 751 tweets that included those key terms, which is 0.06% of the 1.2 million. And then as I was sifting and sorting and analyzing this data, I realized that a lot of these tweets had the exact same language. It was interesting to see it was the exact same tweet because I'm analyzing the language to see if it matches one of these three. I realized that a lot of these tweets were retweets, likes, or shares. So therefore, I eliminated any of those, and it came down with 95 unique tweets. And then what I did from there is I analyzed those to determine if any of these terms were in there, and I identified 5 tweets that were related to the Waldman statements.
Do any of the hashtags Mr. Schnell analyzed include the words from the Waldman statements?
No, they don't. And, because I am rebutting Ms. Arnold, her testimony yesterday, she was saying that the Waldman statements caused these hashtags. Then throughout her testimony, she walked that back and admitted, no, none of these tweets have anything to do with the Waldman statements. They don't include the Waldman statements. These hashtags are only hashtags that Schnell, in his opinion, felt that they were negative towards Ms. Heard.
Based on your expertise, what are your overall opinions about Mr. Schnell's testimony and the Twitter hashtag data?
Mr. Schnell provided no evidence that any of the tweets were related to the Waldman statements. Mr. Schnell, there's no correlation there. He also provided no evidence that there's any causation that, the Waldman statements caused any economic harm towards Ms. Heard.
Your Honor, I'm about to switch to a different topic. I don't know if you want to break now or push.
All right. It's going to be a little while, I assume?
A little bit more, yes.
Okay.
Yeah.
Let's go ahead and break for lunch, ladies and gentlemen. Okay. Do not discuss the case and do not do anything.
All right, so this is the lunch break. But remember, because we're pausing the video so you see everything, they've been on the lunch break, and the jury is going to be back pretty soon. And we're going to do the same. We're going to squeeze in a break now, and then we're going to break down what we've seen so far in this final stretch of the dueling defamation trial of Johnny Depp and Amber Heard.
200 now.
You are watching Court TV Live, your front row seat to justice. I'm your midday host, Julie Grant. We are seeing the final stretch of Johnny Depp versus Amber Heard playing out in Virginia. Where we are right now is in the rebuttal case. The jury's on their lunch break, but because we were a little behind on the video, purposefully, so you see everything, the jury's going to be back pretty soon. And the big question I have right now, and many of you at home may have the same, is how are they reacting to this testimony today? We're seeing a lot of experts being brought in to tie up the loose ends, so to speak, before the jury gets the case. Let me bring in someone who's been in the courtroom watching things for us, Court TV legal correspondent Chanley Painter. She's standing by outside of the courthouse with the details. Chanley, good afternoon.
Hey, good afternoon, Julie. The jury attentive today. I've seen some mixed reactions as far as juror number 1 seemed to struggle to stay awake a little bit. Juror number 8, the woman on the front row, is into it, as she always is. And what I've really been noticing about her over the weeks is that she will take a moment and actually look to Johnny Depp, who's virtually sitting in front of her the entire trial. But she does purposefully look and just take him in, his reaction, what he's doing at the table. She's doing that again today. Now, so far the witnesses we've been hearing from, we have, of course, the new one, Mr. Hamada, but are recalled witnesses from Depp's case in chief. So I'm noticing initially when the witness takes the stand, the jury, they're looking down, taking notes as far as the direct, and then they'll just sort of sit there and listen and take in the remainder of it. Nothing too overt. This jury is so inscrutable at times to really gauge what they're thinking and feeling, but you know, every little moment or movement I'm trying to take in because you just never know what it may mean in the overall scheme of things. But anyways, court is rolling on today. It's a little bit of a dreary day here, but after this lunch break, I'm sure the energy will pick back up inside the courtroom.
Oh, definitely, Chanley. We could see that gallery packed with all the fans. And I know when you and I were talking last night, and it was late, you know, we talked, you know, around the 9 o'clock hour, and they hadn't started lining up. And you were saying, you know, maybe that was attributable to the fights from the night before. Tell us about that. I know you're watching things outside of the courthouse, and what's kind of happened, what's been the progression, you know, sort of since then, and then how things worked out into today?
Yeah, because of what happened in the early morning hours yesterday, the deputies here on courthouse grounds really cracked down, putting in place strict rules. The line cannot form until 1 a.m. here on courthouse grounds. So that shifted things a little bit more. Not as many issues, but I do want to take a look back at what we found out. We sent one of our PJs out, our photographers out in the early morning hours to that line, and this is what we put together. Let's watch.
If you have a problem, I don't know how you guys are doing this. You're not even supposed to line up until 1 o'clock. No, I'm just I don't care. This is so
The husband was okay.
Then you sit your chair all night, just like everybody else. So stop with this dramatic stuff, okay?
Well, technically, I'm just gonna tell you all.
They can't save seats. This is what they've been doing.
We're not supposed to be here till 1 o'clock. So right now,
get out of line.
Right. Come back. Everyone will have to move out. You got the police attention, you got the sheriff's office attention. So everyone will have to move out. You come back here, you realign up at 1 o'clock.
That seems fair.
You get here before 1 o'clock. Right now it's 11:22. You get here before 1 o'clock. We're not gonna allow you in at all.
I one of the privilege number You know how I work hard to get that.
You come in the beginning. You come in the beginning. You get your ass out here in the morning.
Earlier this week I was
Yes, just to have swinging all the time. Start another trial.
I don't want to be. I don't know what this number system.
My number is yours.
Dude, this is crazy. See there, kind of the rush to get back in line at 1 a.m. That happened again this morning. It was a rush to swarm that area for a spot of the first 100. And our photographer kept showing the lady with the baby buggy, Julie. And of course, yesterday, I know I told you about that outburst after the mid-morning break where the lady with the baby held up the baby inside the courtroom, yelling to Johnny Depp, of course, after the jury left. I love you, Johnny Depp. Our souls are connected. When are you going to admit this baby is yours? And she has not returned. She's not allowed to return.
Oh, she is banned. So the same lady, last night when we were talking, you made the connection for us, Jen. The same woman with that stroller, that poor baby, out all night, and then brought into the courtroom, and she's the one, claiming that it's Johnny Depp's love child, and now she's banned. Wow, that was just such organized chaos out there outside the courthouse, and she seemed to be kind of the catalyst for a lot of those fights that were happening. Okay, Chanley, tell me, so as we're kind of looking ahead to what's coming with this rebuttal, we know we've got the expert on right now who has to kind of button things up, but what about Kate Moss? We're seeing her name on the witness list. Curious if you and your teammates in the field have any intel about whether or not they're going to call her.
Sure, we have confirmed she is expected to testify tomorrow via video link, not here in person, but video on all the big screens inside the courtroom, a live testimony. It will be a much anticipated moment, and we know she's a friend and former girlfriend of Johnny Depp, and it's all because Amber Heard brought her name up during her testimony when she said that she thought and feared, the rumor of Kate Moss and the stairs, insinuating Johnny Depp was going to throw or did throw Kate Moss down a flight of stairs. Now she's coming in for rebuttal. That'll be a big, big moment. We have some big witnesses today, too, Julie, for the rest of the day. To mention, we have a forensic pathologist, a forensic psychiatrist. Someone for the pathologist is going to talk about the injuries and use Amber Heard's descriptions of the brutality of the alleged violence of Johnny Depp and describe how this doctor, Kimberly Collins, would expect more injuries or the type of injuries you would sustain if, in fact, that story was true. That will be interesting. We've already heard from the hand doctor, of course. And we're also anticipating Jennifer Howell. Remember her name from Whitney Heard's testimony? She mentioned, or she was cross-examined about Jennifer Howell, one of her former friends and bosses who she went to live with, who Whitney Heard apparently gave a very different version of the staircase incident and characterized her sister in a way that she was an abuser. So her deposition will be played later today. That's anticipated. And we see Whitney Heard Enriquez sitting there in the gallery all day. She walks in and out of the courtroom through the main public entrance, but she does have a seat up there on the front. And she, of course, arrives with her sister supporting Amber Heard.
Right. Saw her arrive this morning, Chanley, when that crowd of Depp fans was chanting something really ugly at her, something that really can't even say the word, but it was part of one of those hashtags, Amber something else, that was being chanted this morning. Here's that video. If you take a look there, you see there she is, Whitney Heard Henriquez, standing there with a cup of coffee behind her sister, who said good morning to one of your partners in the field there, Chanley Austin Brady, who's been the videographer, kind of posted up there, taking that shot day in and day out. So Chanley, tell me, are they on track in terms of the time? We know the judge has really been specific about how many hours, minutes each time has. In terms of what you're seeing today and what maybe the intel of what's coming, should closing arguments happen on Friday?
As far as we're hearing right now, everything is on track. At the beginning of today, Depp's team had almost 16 hours, a couple of days worth to present a rebuttal case. Now, I believe since Amber Heard's team has arrested after calling 24 witnesses earlier this morning, they have around 4 hours or so to rebut if they want. And these times don't include the 2 hours they're allotted for closing arguments on Friday, to keep that in mind, Julie. But there still are some names from Heard's team that we haven't heard from yet. If we look at their witness witness list. We know her former partner, wife, girlfriend, Taja Van Ree was someone that was on the witness list. Dr. Cowens and Dr. Bonnie Jacobs. Those names were mentioned in opening statements who treated Amber Heard over the years about the abuse. They didn't call those particular doctors in the case in chief. So they still have a lot of certain evidence to work with in that 4 hours. And you mentioned these time limits. It's behooving for these attorneys to really be strategic, right, in how they're going to spend their time, who they're going to call, and prioritize it in a way that's most effective for them. And I just want to mention a little bit more color as I left to come down here at the lunch break to be on with you live. I passed by the courtroom door, Julie, and I see Elaine Bredhoff in there by herself. Everyone is gone. Everyone is gone to lunch, and she's in there at the desk working, organizing papers, preparing. So it's just as attorneys, I think it's good to mention that these people work overtime. Even when they're not on camera, they're not in the courtroom, they're working long, hard days and nights to try to do the best they can for their clients.
Yeah, most definitely. A good note to end on there. Chanley Painter, thank you for all of that. We'll let you head back into the courtroom. We know the jury is set to be brought back in just about 10 minutes, so we're going to squeeze in a break. We'll be right back with more Court TV Live, and when we do return, we'll get you caught up on another major story making headlines. The search is on for a woman said to have been involved in a killing that stems from a love triangle. This is Court TV Live, your front row seat to justice.
15.
Welcome back to Court TV Live. I'm Julie Grant. So we are learning more this afternoon about an elite cyclist who was killed in an apparent love triangle. We want to bring in Court TV legal correspondent Joy Lim-Nakrin. She has been following the story for us since the outset and has the very latest. Joy, good afternoon.
Good afternoon, Julie. So Anna Mariah Wilson was killed in Austin, Texas, just days ahead of a big race that she was set to compete in Waco. She was a respected professional cyclist, just 25 years old, who traveled around to compete in the biggest races in the nation. Well, Colin Strickland was a man with whom she was having, or she had had, some romantic involvement with at one time. According to the arrest warrants, Strickland told authorities that he had gone swimming and gone out to eat with Wilson the day that she died, and he hid it from his live-in girlfriend, 24-year-old Caitlin Marie Armstrong. And authorities believe Armstrong is the one who killed Wilson in a fit of jealous rage. Well, Wilson's family has now said she was not romantically involved with anyone at the time of her death. They said in a statement, in part, quote, "We're absolutely devastated by the loss of our beautiful daughter and sister, Anna Mariah Wilson. There are no words that can express the pain and suffering we're experiencing due to this senseless, tragic loss. Mariah was a talented, kind, and caring young woman. Her life was taken from her before she had the opportunity to achieve everything she dreamed of. Our family and all those who loved her will forever miss her. While we will not elaborate about the ongoing investigation, we do feel it's important to clarify that at the time of her death, those closest to her clearly understood directly from Mariah that she was not in a romantic relationship with anyone." Also today, we've uncovered an interview that Wilson gave to a cycling site called Pure Gravel just weeks before the race that she was set to ride in. She'd been planning for months to compete in the Gravel Locos in Waco and was favored to win until days before she was killed. Let's listen to her speak about the race that she never lived to ride.
I like the mixture of mountain and gravel is really exciting for me too. Because I love both, and it's been hard for me to categorize myself as one or the other, sort of. So I'm really excited for that. And then got a couple, just like, a lot of the other big gravel events, BWR, Rule of 3, Gravel Locos.
So now authorities are still searching for Armstrong, last seen driving a 2012 Jeep Grand Cherokee with a Texas license plate LDZ 5608. If you have seen it or Armstrong, you were asked to call U.S. Marshals at 800-336-0102. And Julie, Wilson's family says she was very passionate about empowering women and building stronger communities. So they've created a GoFundMe page to set up a foundation to realize Wilson's charitable goals.
Oh, wow. That poor family, they to have even the wherewithal to do that, right now after this and the way she was killed, it's just awful. Our hearts go out to them. And surely if the marshals are on it, they will find Caitlin Armstrong. Joy, thank you so much for that report. Appreciate it. We're going to squeeze in a quick break as the jury's set to be brought back soon to hear more in the Depp Heard defamation trial. Don't go anywhere. This is Court TV Live, your front row seat to justice. Thank you for being with us here on Court TV Live. I'm Julie Grant. So in just a matter of minutes, the jury's set to come back into the courtroom and hear more of the rebuttal case put on by Johnny Depp's legal team. We're getting word that the judge is on the bench. Attorneys are talking with Her Honor. Let me bring in my guest, criminal defense attorney and the host of the Diva Court podcast, Marcia Minot. She's standing by in Atlanta. Marcia, we're getting to that final portion of the trial, the last bits that need to be the last loose ends, I should say, that need to be tied up before the jury gets the case. Tell me, if somebody asked you who is winning this trial right now, what would you say to them and why, please?
I would say there's a slight lead as it pertains to the Depp case. And the only reason is because the rebuttal testimony today has been able to refute some of the testimony from the Heard camp regarding damages. Damages cannot be speculative. And if the jurors do not have sufficient evidence to come up with the number, then the number has to be zero.
Right. You know, and damages are one thing, of course, and I know you know this, Marcia, with the law and in civil court, a good reminder, there has to be liability first to even get to the damages, right? So in terms of who is liable, this jury, if they accept the facts as Johnny Depp and Amber Heard have put them forth as true, then they've both been abusive to each other. They've both been violent to each other. Marcia, do you think it's a possibility that this jury may come back and say, nobody's liable for anything, nobody wins here, go home, move on with your lives, no one gets anything in damages?
I think a wash in this case is a very strong possibility. This case has gone into so much more than just defamation on both sides. And it's had testimony from psychiatrists, psychologists, so I think the jurors are very likely to give no one anything in this case.
I do too, Marcia, and we're seeing folks filing in, taking their seats in the gallery before the jury comes in. And something I wanted to ask you earlier was about those numbers, those dollar amounts. And when you think about this case being heard before a jury, I can't imagine there's anyone on this jury who's used to having those kinds of dollar amounts in their lives. I mean, it's really, really wild, you know, what this case is about in terms of the money aspect. Do you think that could be offensive to some people on the jury?
It could. It comes across as monopoly money. It is so high and astronomical.
Yeah, I love that, monopoly money. That's good, Marcia. I like that. We may have to use that and give you credit for it, of course. Everybody on their feet tells us the members of the jury are walking in. 6 men, 3 women on this jury, and 2 people will be released as alternate jurors. We don't know who, but when the time comes, it will just be 7 deciding the facts. Let's listen in together live. Oh, and they're going to a sidebar. Okay, so that gives me more time to keep talking to you, Marcia Minot. So we know Friday's the day the judge has set for closing arguments because she has timed this case out, allotted each side an amount of time, and she's counting even the minutes. In all your years of trying cases, and you've served as a prosecutor, you've done work in the private sector doing criminal defense, have you ever had a judge set a time limit?
Time limit specifically, no, but they will limit the number of witnesses, especially if the witnesses are just corroborating witnesses.
Right. Marcia, thank you kindly. Let's listen in to more of this rebuttal.
And are you aware of her opinion that Ms. Heard's career would have followed the same trajectory as that of Jason Momoa, Gal Gadot, Zendaya, Ana de Armas, and Chris Pine for the Waldman statements?
Yes.
What's your understanding of Ms. Arnold's basis for her opinion that Ms. Heard's career should have been similar to that of those identified actors?
Ms. Arnold stated that when producers or her industry is looking to hire talent and actors, that it's important to best understand the public's perception of the actors that they're considering, and that it's important to look into social media to see what is happening with the actors they're considering for either a movie or even an endorsement opportunity with companies. So that was her approach.
And is that the process she followed in providing her analysis of those purportedly comparable actors?
No. Although she stated that, she went in and brought in these alleged comparable actors, and without really reasoning behind that.
Did you conduct an analysis based on your expertise in social media and internet analytics of Ms. Heard compared to the actors to whom Ms. Arnold compares her?
I did.
And what did you find?
Well, since Ms. Arnold stated that the proper approach is looking at the public perspective, looking into social media, and she did not do that, I felt that was the best approach to do this based on her words. So yes, I did go into best understanding the public perspective of Ms. Heard and the alleged comparable actors using Q scores. And then I also went and did some analysis online and on social media as well.
Can you briefly remind the jury what Q scores are?
Yeah, again, Q scores measure how well a celebrity, it could be a cartoon character, it could be a sports person, how well they're known, how well they're liked, and how much they're disliked. And it's an industry standard tool that's used. It's not just focused on the movies that they're in, but it's focused on them as actors, but also what's happening in their personal lives come to play as well. So that's how Q scores are typically used.
Did you prepare a demonstrative that reflects the Q score analysis you completed?
Yes, I did.
Okay. Your Honor, may I approach again?
All right, thank you. All right.
No objection to the demonstrative.
All right, we'll identify plaintiffs 1296 for identification and publish to the jury.
Mr. Banya, what point in time do these Q scores represent that are reflected on your demonstrative?
So these are the winter 2019 Q scores that are reflected here. And what was important for me is I wanted to find Q scores that represented Ms. Heard after Aquaman. And remember, Aquaman is December of 2018. These Q scores were gathered January and February of 19, but before the Waldman statements.
And what did you find based on the Q scores that you looked at?
So as you see here on the left are positive Q scores, and the higher the number, the better. As you can see, Ms. Godot has the highest Q score out of the group of actors here at a 28. But you're going to notice Ms. Heard has the lowest positive Q score. She has a 9. So I find that very interesting that she doesn't appear to fit in as a comparable with these alleged comparable actors. I think what's also interesting is the average Q score for all actors being scored at that time, which include all the alleged comparable actors here, score at an average of 17. And you can see, again, she is 9, well below that. And then on the right side, you're going to see the negative Q scores. So this is how much people dislike you. So the lower the score is better. You can see Mr. Momoa is over here with the lowest at an 8, but you can see Ms. Heard is over here at a 28, which was quite a difference. A 20-point difference from Mr. Momoa, and also a 10-point difference, from the average of all actors. So she is very, very much little. Her positive score is very low, and her negative score is very high, which tells me that she does not fit in as a comparable as it relates to these alleged comparable actors.
What opinions did you form based on that Q score analysis?
My opinions as it relates to these Q scores is, Ms. Arnold used these actors as allegedly comparable actors. But really, listening to her testimony yesterday, it appears that she's abandoned this approach. I don't think she's using these comparable actors or these alleged comparable actors anymore. She's more relying on her experience, and I agree with that.
Did Ms. Arnold offer a criticism of your use of the Q scores here?
She did, yes.
And what's your understanding what that criticism is?
Well, what I believe she was saying is that I should have ran Q scores for these allegedly comparable actors after each of their breakout films, which I disagree. First of all, Q scores doesn't work like that. Q scores are available twice a year, so it's not that I could pick a month or a different month for each of the Q score actors. So I feel that, what was important for me, and this doesn't always happen when I'm using Q scores, you can get this perfect moment in time. As Miss Heard said, I'm sorry, but as Miss Arnold said, that, Aquaman was Miss Heard's breakout moment. So these scores reflect that breakout moment, and they're terrible Q scores.
How would your analysis change if you had used Ms. Arnold's logic with respect to the timing of the Q scores that you looked at?
I mean, if you really think about what Ms. Arnold was saying, is she's saying that she thinks Q scores are the highest for each actor right after their breakout moment. So I would think, if anything, these Q scores could have been a bit lower, because it's not right after their breakout moment. But what's important for me is the fact that these scores reflect, who Amber Heard was at the time before the Waldman statements, but after the Aquaman release.
We can take that one down, Tom. Thank you. What other work have you done in connection with forming your opinions in this case?
Again, taking the advice from Ms. Arnold, it's important. She says the industry looks into social media, what their followings are like, with the numbers as it relates to their followers. Again, what is the public perception of them? So I analyzed their social media accounts, but prior to the Waldman statement. So.
And how did you do that?
Yeah, so what I did, I don't know if you're all familiar with the archive.org. They have a tool called the Wayback Machine. What archive.org does is it archives the internet. So you can go back in time to see what websites and web pages used to look like in the past. Not all the time can you actually get a celebrity's social media accounts to have been archived, but we were fortunate that each of the alleged comparable actors' social media accounts were in archive.org. So I was able to go back in time prior to the Waldman statements to see what the following activity was for each of the alleged comparable actors.
Mr. Banya, did you prepare a demonstrative that reflects your social media analysis?
Yes.
Your Honor, may I approach?
Yes, ma'am.
No objection to the demonstrative.
All right, we'll mark it for identification purposes. Plaintiffs 1297 and published.
Mr. Banya, could you tell the jury what you found when you looked at the social media?
Yeah, so what I found, again, this is prior to the Waldman statements. First thing you're going to notice here is not all actors use social media. You're going to see Mr. Pine doesn't have Facebook, Twitter, or Instagram, and Momoa and Darmus don't use Facebook or Twitter.
All right, the Depp team trying to show that there's not a connection between the statements of Mr. Waldman, Johnny Depp's agent, and then those hashtags and all the Twitter activity. My time is done here, but don't go anywhere. Ashley Wilcott is in the studio. She's going to be taking over next. Ashley, good to see you.
Great to see you, Julie. Battle of the experts, the analyst on the stand. What is this jury going to do? Have they heard enough evidence yet? We're going to get you right back into that courtroom. Live testimony continues right after this.
All right, your next witness.
Your Honor, on behalf of defendant and counterclaimant Amber Heard, we rest.
All right, rebuttal evidence.
It was the concerns that were brought up at the wrap of the first movie, which is the issue of chemistry.
Miss Heard's breakout moment, the Stars Born phenomenon didn't happen.
New developments in the Depp defamation trial at this hour. Johnny Depp's experts are doing their best to really drown Amber Heard's post-Aquaman prospects. One witness saying that Heard's lack of chemistry with Jason Momoa was a bigger issue than any drama with her ex-husband. And Depp's attorney started the day with 3 times as much time as Heard's team to convince jurors. So which side is winning right now? We're going back to court for Depp's rebuttal case in just a moment, and our legal experts are standing by to discuss when there are breaks or sidebars. All of that coming up next. Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Honored to be with you this afternoon. We are in day 21 of testimony in the dueling defamation cases of Johnny Depp and Amber Heard. Depp's rebuttal case is underway now, and his attorneys are expected to call witnesses over the next 2 days. Amber Heard's team finished its case in chief this morning. Testimony is expected to conclude by both sides this week. And what's at stake? Both sides are suing for millions, claiming the former spouses ruined each other's Hollywood careers with allegations of domestic abuse. On the stand now, internet expert, remember, testifying for Johnny Depp's team, Doug Banya. Let's get you back in the courtroom. You haven't missed any of the testimony.
You have Ms. Heard prior to the Waldman statements with 3.8 Instagram followers and 142,500 Twitter followers. And then you move down to Gal Gadot with 37 million Instagram followers compared to her 3.8 million. And, you know, 2.3 million Twitter followers compared to Ms. Heard's 142,000. And you can then even go down to Zendaya with 65.9 million and 17.2 million Twitter followers. What this is telling me is really, you know, more people are interested in Ms. Gadot and Zendaya and even Mr. Momoa than Ms. Heard on social media. It just tells me a lot of people are interested in these actors as opposed to Ms. Heard, more of a following. Q scores, well-liked, less disliked. So it kind of fits into the analysis of determining whether or not these alleged comparable actors are actually comparable.
Based on your expertise, what are your overall opinions about Ms. Arnold's analysis of the so-called comparable actors?
Yes, again, you know, it appears that she's abandoned this approach, and I agree with that. I feel that, you know, through the Q-score analysis and the social media analysis, that they're just not comparable.
Tom, we can take that one down. Mr. Banya, based on all the analysis you did in this case, what are your overall opinions?
Yes, my overall opinions are that Mr. Schnell failed to prove any causal connection with the Waldman statements and the search or the hashtag activity, those spikes as it relates to Twitter. There's no causal connection there. My second opinion is, you know, based on my social media and Q-score analysis, Ms. Arnold's alleged comparable actors are not comparable. And then third, Ms. Arnold and Mr. Schnell both failed to prove any causation as it relates to the Waldman statements causing economic harm to Ms. Heard. So, you know, as a damages expert, which Ms. Arnold is, you need to take into consideration causation before you can calculate damages. You look at damages and you look at this allegedly damaging event, and not only do you have to prove that 100% of the damages because of these Waldman statements, she didn't even consider COVID. It happened at the same time. You know, a lot of actors probably made a lot less money because of COVID. Maybe films didn't get made. And, you know, when you do an analysis of damages, you prove causation, but you also have to look at everything else that might have caused this alleged economic harm. And she didn't look into any of that. She didn't even know what causation was. So I don't think damages is an appropriate approach in this case.
No further questions, Your Honor.
All right, cross-examination.
Good afternoon, Mr. Banya.
Hi.
You're not a damages expert, correct?
I am a damages expert, but not providing any quantitative damages opinions in this case.
In this case, okay. And is it your testimony that only if a person repeats the Waldman-Depp statements could they be related to the defamation?
Say that one more time.
Are you saying that a person literally has to repeat the Waldman-Depp statements in a tweet for them to be related to the defamation?
No, if you looked at my analysis, I did pick the 3 themes as it relates to the tweets, and I analyzed those themes, and I came up with 5 examples of when those themes were used.
And you ran searches for, quote, abuse hoax, sexual violence hoax, and fake sexual violence, and you ran all those in quotes, correct?
I did.
So only if a person used a tweet with those words in that order and with that spacing would they hit on your searches, correct?
Objection, compound.
Overruled.
Yeah, so I used them in quotes because, you know, hoax could be used in many other contexts. So I wanted to make sure I was fitting my search with the theme of the Waldman statements.
So if someone tweeted misheard faked sexual violence, that wouldn't appear in your searches, correct? Faked with an ED.
It would not.
Okay. And if they use 2 spaces between abuse and hoax, that wouldn't fit in your search.
That's correct.
Okay. Did you? And a tweet can only be 280 characters, correct?
That's correct.
All right. So certain of the Waldman-Depp statements, a person could not tweet the whole thing in one tweet, correct? The whole statement in one tweet.
The Waldman statements?
Correct.
No, you could not tweet those entire quotes.
Did you make any determination if there was an online bullying campaign against Mr. Depp after Ms. Heard's op-ed?
I didn't look into any online bullying campaign for Ms. Heard nor Mr. Depp.
Did you determine if there were tweets harassing Mr. Depp that quoted from Ms. Heard's op-ed?
No, my assignment was to determine if the Waldman statements were part of the tweets that Mr. Schnell provided. I was rebutting him.
And in your analysis of when you testified before, you never looked to see if the op-ed was quoted anywhere, correct?
Objection, Your Honor. May we approach?
Okay.
All right, questions withdrawn. Next question.
Now, you have no objection to Ms. Arnold's use of comparables, correct? Just the use of comparables in general.
I listened to her testimony and my understanding that she abandoned that approach. But as it relates to my testimony today, my opinion was related to those specific alleged comparable actors, that they were not comparable.
You're not offering an opinion as to who the appropriate comparables should be to Ms. Heard, correct?
Correct.
Okay. And you testified just before about the Q scores of Ms. Heard and the comparables. That was Plaintiff's Exhibit 1296, correct?
I don't know what 1296 means.
Okay. The demonstrative in front of you.
Mine? Yes, that's correct.
And you said that those were all for the winter of 2019?
I said Ms. Heard's were from the winter of 2019.
Because isn't it true that none of the rest of these people were from the winter of 2019, correct?
That's correct.
Okay. In fact, Mr. Momoa's was from the summer of
2018. 2020.
Of 2020?
That's correct. Not all alleged comparable actors had Q scores for that date. What was important for me is to get Ms. Heard's Q scores right after Aquaman, but before the Waldman statements.
So you weren't comparing apples to apples, correct?
I wouldn't say that. I'm saying that it's not the exact same years.
Well, so in the winter of 2019, that Q score comes out. That the field work dates for that is from January 22nd, 2019 to February 7th, 2019, correct?
That is correct.
So that would be so the field work would be starting almost immediately after Aquaman just came out, correct?
Yeah, in her Star is Born moment, yes.
You'd agree that for the winter of 2020, where you took Jason Momoa's Q score, would have more time to account for the rise in popularity of the film Aquaman, correct?
Well, actually, if I use Miss Arnold's suggestion, the celebrities tend to have, the celebrity moment right after they have their breakout film. So I disagree with that. I think maybe his Q scores could be lower as it relates to when I use them.
You'd agree that for the winter of 2020, Mr. Momoa's Q score would have more time to account for the rise in popularity of the film Aquaman?
I don't know if it accounts for the rise of popularity. Again, using Miss Arnold's words, usually a Q score will be the highest right after the film, like I did measure Ms. Heard.
May I approach her?
All right. Do you show?
All right, we are going to pause the testimony. You won't miss any of it, but I want to introduce at this time live in studio criminal defense attorney Marie Pereira here with us. Thank you so much. Before we take a break, I must ask you this. Do you think this jury is still listening? You have another expert talking about Q scores. Are they paying attention, do you think?
I think they're paying attention. We're following primacy and recency here. This is the last bite that they have, and they're using it correctly by bringing in the experts because it's all about the money. We're here about money.
All right, thank you. You're going to stay with us when we go back. You're not going to miss any of the testimony. Kate Moss expected to be testifying for this rebuttal case. We'll be right back here on Court TV, your front row seat to justice. Let's get you back into the Virginia courtroom. You haven't missed any testimony. Internet expert Doug Banya is on the stand discussing Q scores on cross.
All right, thank you.
If you look on page 177 of your deposition transcript, you see that?
I don't see a page. Is that what you handed me?
You don't see page 177? At the 4 pages? 4 pages per?
Oh, yes, thank you.
And I asked you at lines 6 through 10, you'd agree that for the winter of 2020, Jason Momoa's Q score would have more time to account for the rise of popularity in the film Aquaman, and you answered yes.
At that time, as I am a rebuttal expert to Ms. Arnold, based on her testimony, I've learned something new from her.
Okay. You didn't look at Ms. Heard's Q score for summer of 2020, correct?
She doesn't have any.
And Ms. De Armas had a lower familiarity score than Ms. Heard, correct?
If I don't have that in front of me, but if you're saying that, yes.
Okay. And Ms. De Armas's career trajectory has gone up since the summer of 2020, correct?
I don't know. I didn't analyze her career trajectory.
Okay. Could you put up plaintiff's trial exhibit 1297? That was the demonstrative. Ms. De Armas has less Instagram followers than Ms. Heard, correct?
Correct.
And Ms. Heard has more than double the Instagram followers of Ms. De Armas, correct?
Yes.
Okay. And isn't it true that you get more social media followers the longer you're on social media?
Not necessarily. It doesn't work that way. It depends on many other factors.
So Ms. De Armas had a lower familiarity score and less Instagram followers, yet your testimony is that she would not be a proper comparable to Ms. Heard?
That's correct.
Okay. And you're not offering a different set of people who should be comparables, correct?
That's correct.
Okay, thank you. You can take that down. Now, you understand that Mr. Waldman has been banned from Twitter for life for harassing Amber Heard, correct?
I don't know that, but if that's the case.
And you understand that Mr. Waldman appealed the decision to Twitter and they have confirmed his ban for life?
Objection, Your Honor. May we approach on this one?
Okay, sure.
Mr. Waldman banned for life is the question that was just asked. It drew an objection. But remember, Mr. Waldman was acting on behalf of Johnny Depp, so is alleged anyways by Amber Heard. And in doing that, she says it was derogatory, lies, and ruined her career. Let's see if we can go back into the courtroom.
You agree that in looking at Mr. Schnell's data, 65% of the uses of negative hashtags relating to Ms. Heard occurred between April 1st, 2020 and June 15th, 2021, correct?
Correct.
Okay. And you would agree that 5 of the 6 highest spikes of the negative hashtags were after the Depp Waldman statements, correct?
Correct.
Okay. And where you talked about the February 2020 spike, and the 65%, by the way, even includes the February 2020 spike of tweets, correct?
That's correct. Well, there was no spike in Feb 2020 during the Waldman statements?
Well, the spike in February 2020 was before the Waldman statements, right?
I would have you. Can we pull up the chart again if you want to talk about the spikes?
Sure. Can you put up 1294? Number one.
Yeah, that spike happened before the Waldman statements.
Okay. And there was hardly any activity in negative hashtags until February 2020, correct?
That's correct.
And you understand that the spike in February 2020 was related to the partial tape that Mr. Waldman and Mr. Depp leaked to the Daily Mail, right?
I'm aware that the articles were related to Heard admitting to hitting Depp.
And you understand that Mr. Waldman testified that Mr. Depp and Mr. Waldman met with the Daily Mail in person to provide the partial tape to the Daily Mail.
Objection, Your Honor.
Hey, he talked about what the number one related to.
What's the objection?
Sorry, lack of foundation and.
I'm asking if he knows or he doesn't.
All right, we'll rule.
So what's important to me is the fact that this spike is prior to the Waldman statements.
Do you know if Mr. Waldman testified that Mr. Depp and he met with the Daily Mail in person to provide the partial tape?
No.
In February of 2020? You don't know one way or the other?
It's irrelevant to my opinion.
Okay. And the spike in July of 2020 came right after the last defamatory statement by Mr. Depp and Mr. Waldman, correct?
The July spike, which is number 2, is not related to the Waldman statements, and there are articles related to abuse between Heard and Depp and feces found in Depp's bed.
And that's based on Google searches you did?
That's correct.
Okay. And the July spike in time came after the June 27th, 2020 defamatory statement by Mr. Depp and Mr. Waldman, correct?
That's correct.
Okay. And 5 of the 6 spikes came after the defamatory statements, correct?
After the Waldman statements, yes.
Okay. Now, you testified before that you eliminated shares and likes of the Depp-Waldman statements from your analysis, right?
Repeat that, please.
Did you say that you eliminated shares and likes of tweets that included the Depp-Waldman statements?
That's correct. When I was doing my analysis, I noticed the exact same text was a part of many of these tweets.
Don't shares and likes disseminate the negative information?
That's quite possible.
Okay. And you agree, right, that use of the term Waldman or Waldmanian occurred over 25% of the time in the negative tweets toward Ms. Heard from April 2020 through January 2021, correct?
Although it's irrelevant to this case, it has nothing to do with the Waldman statements. That's what Mr. Schnell says.
You don't disagree with the search results, correct?
Although has nothing to do with this case or the Waldman statements, I do not disagree.
So if people are tweeting about Adam Waldman or Waldmanian at the same time as tweeting negative hashtags about Amber Heard, it's your testimony that they have nothing to do with this case?
The hashtags have nothing to do with this case.
That's what you're saying? Okay.
Yeah.
Okay. And even if they include the negative hashtags with Mr. Waldman's name and Waldmanian, you're saying they have nothing to do with the defamatory statements?
All 4 hashtags that Snell used had nothing to do with the Waldman statements. Waldman himself has nothing to do with the Waldman statements. We're talking about the Waldman statements here. Waldmanian, I don't even know what that is, but again, it has nothing to do with this case, and it's not related to the Waldman statements. That's what's important.
And the reason you're saying they're not related to the Waldman statements is because someone didn't literally copy what Adam Waldman said in the Daily Mail and tweet it out?
Well, I looked at enough tweets that included the name Waldman that have nothing to do with anything negative or the Waldman statements.
No, they must have had to have the negative hashtags toward Ms. Heard, because the only way that those would have been in the data you looked at would have had the negative hashtags towards Ms. Heard. It was looking at that universe, correct?
Well, first of all, I don't agree that justice for Johnny Depp is a negative hashtag towards Amber Heard. So listen, the assignment was to determine if the tweets that Mr. Schnell presented were related or included the Waldman statements.
In your review of the tweets related to Ms. Heard, you cannot point to any that were positive toward Ms. Heard, correct?
Again, I was not looking for that.
And you did not review the hashtag Justice for Johnny Depp during the time frame from April 1st, 2020 to January 1st, 2020 to see if there were any that were not negative toward Ms. Heard?
I did not look into anything as it relates to anything other than what relates to the Waldman statements. That's what's at issue here today as we sit in court.
Okay. And you didn't form any statistical analysis to rule out the Waldman statement's impact on the hashtags, correct?
Correct.
You did not analyze whether media and press coverage other than the Waldman statements affected Ms. Heard's career, correct?
Correct.
Okay. Looking at the exhibit that's in front of you, where you have the numbers here, those you said are related to Google searches?
The 1 through 6?
Correct.
Yes.
Okay. And can we put up plaintiff's 888? And we could just start at 1. Do you understand that your... Okay. Oh, thanks. And 888, it's page 76. These are the documents you relied upon for your opinion today?
Yes.
And are these the search, where it has the different letters, these are the searches that you ran for the various time frames and the articles that came up for numbers 1 through 6, correct?
No, I mean, obviously document 1A is the Heard supplemental expert witness disclosure. These are documents that I used throughout the time I've been working on this project. So these aren't related to those 1 through 6 numbers.
Okay. These are documents you relied upon for your opinion today?
These are documents that I relied upon when I presented my designation.
This cross-examination is trying to discredit this expert and say, jury, don't believe what he's saying. It's not accurate. We're going to take a break. We will not let you miss any testimony. Hitting the pause button. We'll be right back.
363.
Good afternoon. Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Thank you for joining us. We're going to take you back into court. On the stand, internet expert Doug Banya, and he's testifying as to Q scores. Right now, he's on cross-examination. They're trying to destroy his credibility. Let's get you back into court. You haven't missed any testimony.
For your opinion today, that you're offering today.
Yeah, these are the documents that, yes, I've relied on throughout this case.
Okay. And actually, Michelle, could you turn in this designation to let's see. Hold on one second. 9, 6, 7. Go. Can you just scroll down? Yeah, keep scrolling. Just keep going. Keep going. Okay, stop. This was the chart you provided with your designation for your opinions in this case, correct?
Yes.
Okay. And it's similar to the chart that we had before with the 1 through 6, correct?
That's correct.
And where it has the various boxes, it's talking about documents 6E through 6H, for instance, related to Depp wanting to have Heard replaced on Aquaman.
Yes.
And you prepared this chart, correct?
Yeah, this was part of my designation.
I'd like to have this page as a demonstrative.
Your Honor, I do have an objection, if I might be heard.
All right, you want to come forward? Page 99.
And we have another objection, another sidebar. The attorneys have gone forward. Let's see if we have a time for a question with Marie Pereira. Marie, again, the Q scores. Do you think that cross-examination is doing an effective job of destroying the credibility of Doug Banya, this expert?
It's doing an effective job of putting the jurors to sleep. This is like a statistics lesson. I don't really know about Q scores and hashtags. I think the witness that came on earlier, Richard Marks, really put a face on what money was lost and how it happened, and they should have just stopped right there. This is losing precious time because this judge has a time limit, and I think this cross-examination is pointless on both sides.
And they're both running out of time. Quite frankly, I think Amber Heard's team had 4 hours at the beginning of the day, and that, according to Chanley Painter, who's there live in Virginia, also includes their closing. And I don't see that it's possible for them to complete all of their questioning and cross-examination and closings within the time allotted. Of course, we'll have to wait and see what the judge decides to do. But let me ask you this as well. Cross-examination, I teach trial skills, and it is not something that you want to ask every single question about everything they've testified to, but really you want to get in and get out and only use what you need for your closing. What part of Doug Banya's testimony do you think should be focused on during cross, if anything?
There's nothing that he has to add to it. And I think even calling him as a rebuttal witness might have been an error and a waste of time, because they already had my man, Richard Marks, who is the deal expert, and he really spoke to the jurors in terms of dollars, cents, time, popularity, and what was lost. They didn't even need to bring this boring statistics professor into the game because they're losing the jurors.
And of course, they're trying to say through this expert that Amber Heard was not negatively affected because of anything Johnny Depp said or didn't say. All right, we're going to go back to the courtroom. I understand that we are back to questioning.
Mr. Banya, Other than so as I understand it, the way you determined that the tweets were not related to the Waldman statements was that you looked at time and then you ran certain Google searches, correct?
Correct.
And then the top 3 hits came up.
Correct.
And then you looked through the article to see if the Waldman statements were there?
So as it relates to any trending event, any defamation that's happened online, any allegations of economic loss because something went viral, going to Google, looking at the spikes in time and going back in time to see what was happening on those top 3 sites will give you an indication of the best results that were being served at that time. So something viral that's happening would appear most likely in those top 3 results.
And just so the record's clear, if we could go back to page 76 of this document. Numbers 6A through 6N, going to the next page, those are the headlines of the searches that you found?
Correct.
Okay. And you don't disagree that that negative tweets toward Ms. Heard have continued throughout the analysis of the tweets, correct?
I'm not looking at whether they're negative tweets or those hashtags are negative. I'm determining if those tweets are related to the Waldman statements.
Well, okay, and you have no opinion whether the tweets were positive or negative towards Ms. Heard. That's what you're saying?
Yes, I'm just analyzing whether or not they're related to the Waldman statements.
Okay, thank you. Nothing further.
All right, redirect.
I have no further questions of this witness, Your Honor. Thank you, Mr. Banya.
Yes.
Sir, you can leave the courtroom or you're free to stay.
Thank you.
All right, your next witness.
And while the next witness comes in, it's a perfect opportunity for us to take a break. You won't miss any of the testimony in this dual defamation case. Johnny Depp, Amber Heard, continuing after a short break. Doug Banya, the internet expert, was the 5th witness called by the Johnny Depp team for rebuttal. Let's go back into court. He's done testifying. He's been excused.
All right, just so we're on the same page with Mr. Knight's testimony. Actually, could Mr. Knight go back out, please? All right. So we're on the same page with Mr. Knight's testimony. There is a rule on witnesses. However, Mr. Knight's a rebuttal witness. The purpose of excluding witnesses from the courtroom, usually it's a courtroom, is to deprive a later witness of the opportunity to shape testimony to correspond with that of an earlier witness. The issue we have here, obviously, if it was a direct witness in the direct testimony, you had time to do a rule on witnesses, let them know about the rule on witnesses. With a rebuttal witness, it's a little different because they didn't know they were going to be a witness. You didn't know they were going to be a witness. I understand that part. The problem is the courtroom in this particular case appears to be the world. So what we have to do here is I'm going to do a voir dire, and I'll allow both sides to ask questions as well of Mr. Knight to see what he has seen of the case. And I'm just going to use the factors that the case law in Virginia uses, which the factors to consider, because the court does have broad discretion to permit or prohibit a witness to testify in this particular circumstance. So the factors I'm going to consider is if the impropriety was intentional, which we'll find out, the prejudice attached to it, also if the excluded witness learned about substantive aspects of the case from an earlier testifying witness, and whether that knowledge had any effect on his or her testimony. So those are the 3 factors I'm going to look at in weighing this decision. So keep that in mind when you do your voir dire. And it's my understanding that the evidence that Mr. Knight will testify only relates to Hicksville. Is that correct? Okay. All right, now we can have Mr. Knight. Come back. All right, sir. Mr. Knight, if you could come forward to be sworn.
Do you solemnly swear or affirm to testify truthfully in this case and a penalty of law?
I do. All right. Sir, if you could just have a seat, please. All right, sir, what we're doing is I'm just going to ask you a few questions outside the presence of the jury, and then the attorneys are going to ask you a few questions, okay? Sure. Then I'm going to have you step back outside after that, okay?
No problem.
All right, what's your full name, sir?
Morgan Higby Knight.
Okay, you don't have to be that close. All right. All right, how do you spell your last name?
N-I-G-H-T.
Okay. All right, and sir, before I can allow you to testify, I just want to ask you a few questions. Have you seen any of the trial that's been going on for the past 6 weeks?
Approximately 5 weeks ago, a friend of mine texted me that Hicksville was mentioned, and I watched a little clip where it was mentioned.
Which clip did you watch?
I believe it was somebody testifying about, I think it was the security guard testifying maybe about Hicksville, or I forget exactly who was testifying, but it was something where Hicksville was mentioned, and it was about something about a wrist or something like that.
All right, and what did you do after that? At some point, did you get in contact with attorneys?
So I didn't reach out to them. I didn't really care. The innkeepers that worked at Hicksville before reached out to them and said, we saw some stuff that wasn't true, and then they asked, is it okay if I give the attorneys your phone number? So the attorneys reached out to me.
Okay, and when did the attorneys reach out to you?
May 3rd.
May 3rd. And you talked to the attorneys at that time?
Yeah.
Okay.
Not Camille, but Geraldine.
Okay, and then have you seen any other parts of the trial?
No, she instructed me not to watch anything about it, regardless of if it was about Hicksville or not. So I've been keeping off the internet and turning off anything that seems to be like it's on social media. So I just don't watch any of that.
Okay, all right. And questions, Ms. Brenner?
So, Mr. Knight, you were contacted by an attorney for Mr. Depp on May 3rd?
Yes.
Okay. And you said it was Carolyn?
Geraldine.
Geraldine. Oh, Geraldine. I got it. Okay. And what?
I think it's pronounced Geraldine.
Okay. Can you tell us the conversation you had with her at that time?
Yeah, she just asked me my recollection of the evening, and I told her, and she said, okay, would you mind testifying? And I said, sure. And she said, okay, well then, we're not sure if we're gonna call you or not, but just in case, please don't watch anything having to do with the case. And I said, I will do.
Now, how is it that, to your best knowledge, how is it that Geraldine was able to get hold of you? How did she know that you knew something?
So, like I said, two of my innkeepers, my innkeeper and my manager, had reached out to her team, I think through email, and one of them texted me and said, hey, do you mind if we give Geraldine your phone number?
Now, you also communicated on Twitter, did you not, about this case?
Yeah, 2 weeks prior to Geraldine reaching out to me, someone had made a comment about something that happened by the fire pit, and I said, that's not my recollection. I didn't see, that's not what I saw.
So who was it that made a comment about something that happened at the fire pit?
So once I was told about the fact that Hicksville was mentioned, I went and did a Twitter search of Hicksville trailer. So it was, I don't know who it was, but I was just like, what are they saying about Hicksville? And so that was why I did a search, just to see, because it was weird and fascinating, because the night to me wasn't that remarkable in the context of all the different experiences I've had at the trailer palace.
So explain to me, please, what you mean by you did a trailer search.
So if you go to Twitter and you put in keywords and do a search, all the tweets regarding that subject come up, or anything with those keywords in it. So that is how I found the tweet that I replied to.
Okay. And how many tweets did you find that mentioned Hicksville when you did that trailer search?
Probably like 5 or 6. I only replied to one of them.
Okay. And what do you recall those tweets saying about Hicksville?
The one that I replied to said that there was some incident by the fire pit, and Johnny was yelling at Amber, and I replied that I didn't see that. I was there all night, and I was working that night, so I didn't see anything like that.
So your best recollection on that one was that somebody said somebody was testifying that Johnny was yelling at Amber?
Yeah, and I believe grabbed her or something along those lines.
Okay. Do you recall who said Johnny was yelling at Amber and grabbed her?
I have no idea. It was a stranger, so I didn't really pay attention to who was writing it.
All right, and you said that you responded to it. How did you respond to it?
I said that's not what happened. I was there all night. Yeah, basically. I'm paraphrasing. It was a
Did
few
you
months
say
ago.
anything about what you thought happened?
I just said that didn't happen. I didn't say what. I believe I said maybe something along the lines of, from what I saw, Amber was the one acting jealous, not Johnny.
And you said this to one of the tweets?
Yes.
Do you recall whether that was the Umbrella Man?
I don't recall. That's a ridiculous name, though.
Okay. So tell me about the other 5 tweets that you recall seeing when you ran your trailer search.
I think they were similar in nature, but I don't specifically remember the details of them. That was pretty much the only one I remembered, and that's the only one I replied to.
Do you remember anything about the other 5 and what was said?
No.
Okay. When you said that somebody told you about a security guard, what was your understanding of what the security guard said?
I got a text that somebody in the trial had said that they were talking about the Trailer Palace during the trial. And so that's what led me to go on Twitter and do a search.
And did you have any communications with the two innkeepers about what you knew or what you thought?
No, I hadn't talked to them in years and still haven't regarding the case.
So how is it that the innkeepers then contacted you and said, do you mind if we give you the telephone number to the attorneys?
Because they still have me in their phone, and Christy, who was the manager at the time, is the one that texted me and said, hey, do you mind if we pass this along? Mr. Depp's attorneys want to talk to you.
Do you mind if we pass what along?
Your phone number.
Right, but how is it that, what is the communication you had with the innkeepers that even led them to understand that you believed you had knowledge about the Hicksville incident?
There was no conversation. They knew because they were both working that same night. Jenna was the innkeeper and she was there along with me that night. Christy was the one who texted me and she had come in the following morning for her shift. And I slept over.
We are listening to testimony in front of the judge only, jury not there. This is a crucial witness if the judge allows him to testify. Morgan Knight. He could be an eyewitness to the Hicksville incident. Remember, Amber accused Johnny Depp of sexually assaulting her with a bottle at that trailer park. Stay tuned. We'll get you back to court. You won't miss a thing. Court TV Live.
Call 800-484-7598. 800-484-7598.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Of course, honored to be with you. I want to lay the foundation of what you're going to see when we go back into the courtroom. Of course, you've missed nothing. We hit the pause button so that you can see everything that's happening in the courtroom. And this is where we are. Morgan Knight is on the stand. The jury is not in the courtroom because basically this was a newly discovered witness. Depp's team says he's an eyewitness to the incident at Hicksville where Amber claims that Johnny assaulted her. And this witness, because he's fairly newly discovered in May, had listened to a little clip about the Hicksville incident. He was not sequestered. And remember, the rule of sequestration means witnesses haven't watched or seen any of the trial unless they were an expert and it was allowed. So the judge now has to decide, based on the testimony we're listening to, whether or not this witness will be allowed to testify in front of the jury. Let's go back into the courtroom.
I was live-in innkeeper that night.
So I'm trying to understand. So just based on the fact that 7 years ago, they happened to know that you were working that night.
9 years ago, and it's because I was there with them.
My math, well, it's 2022 right now, and that was what year? Oh, that was 2013. You're right. Okay. So well, how is it that out of the blue they remembered 9 years ago that you worked there that night and that you might have some knowledge?
I mean, to be honest, like, we do get celebrity sometimes, but it was, you know, it's not that unmemorable. It's not like it's any other night of the week. So I'm sure they remembered the specifics of that night.
Had Mr. Depp's attorneys ever attempted to contact you before?
No.
Had you ever attempted to contact Mr. Depp's attorneys before?
No, I had no interest.
All right. Have you had any conversations with Mr. Depp's attorneys other than the one you described with Geraldine?
Since?
Yes.
Well, I met with Camille last night.
All right. And what was that conversation? Please describe.
I just went through, you know, the story again that I had told Geraldine.
And let's hear what that story was.
You want me to go through?
Yes.
The whole story?
Your Honor, we would object to attorney work product.
There's no attorney work product.
No, I'll overrule that
All
objection.
right.
That's fine. That's okay. Go ahead. Go ahead, sir.
Yeah, sure. That I described, like, them getting to the trailer palace, me showing them around, the interactions I had when I was on duty with Mr. Depp and Miss Heard, how the evening progressed throughout the night, the levels of drinking and drug use that I witnessed, what the state of the damaged trailer the next morning, and basically just, yeah, the details that I had only, you know, spent total 45 minutes to an hour with Mr. Depp and Miss Heard throughout the entire course of the night. So it was my recollection of those events during that time.
And what did Ms. Vasquez say to you?
Your Honor, this is beyond, we object on the grounds that it's beyond the scope of the voir dire,
No,
which is
I
limited
think
to the
whatever
three
she
criteria.
said to him
But
is
may I
very
please finish
critical.
stating my objection, Your Honor?
Go ahead. Yes, sir.
The objection is that it's beyond the scope of the voir dire. Your Honor enumerated the three criteria which are relevant here. And this is a rebuttal witness, so.
Your Honor, whatever Ms. Vasquez shared with him is going to be very important here because they knew by this time he was going to be a witness. So,
that's last night. So how does that fit into one of the three factors of deciding whether or not he's going to testify?
Well, one of the three factors, Your Honor, may I approach so that the witness doesn't hear?
Okay, that's fine.
They are approaching with an argument about, can this witness say what Johnny Depp's attorney, Camille Vasquez, said to this potential witness. And I don't know what the judge is going to decide. We have to wait and see. Still with me in studio, Marie Pereira, and also joining us in Los Angeles, California, former federal prosecutor Nima Rahmani. But I'm going to hold it there for your thoughts. Let's go back to court.
Yes. Ms. Vasquez provide you with any information that anyone had testified to or said at any point?
No, she didn't talk about anything except for asking me my experience and just getting a clear understanding of what my experience was. She didn't mention anything outside of the scope of what I saw and just asked me for the facts and told me just tell the truth and let me know, you know.
Do you know what any of the witnesses said in this trial?
About, I mean, outside of what I described earlier with the, a friend of mine texting that someone was talking about Trailer Palace, I do not.
Do you know whether any of the witnesses testified about any jealousy?
Other than the tweet that I replied to, no.
All right. Thank you. Your Honor, may we approach?
All right. Well, do you have any questions?
Oh.
All right, sir, if you could have a seat back outside the courtroom.
Sure.
Thank you.
Can I leave my water?
Yes, you can leave your water.
An interesting develop. Nima, let me ask you, what are your thoughts at this point after the judge has heard this testimony outside the presence of the jury for the judge to determine based on 3 prongs whether or not this witness should be allowed to testify?
Actually, I think he should be allowed to testify. This is a classic rebuttal witness, and really the only basis to exclude him is that his testimony has been tainted by watching other witness testimony, and he testified under oath that he hasn't been following. And this is someone that was recently discovered. That's why he wasn't on the witness list. He just met with Camille Vasquez last night. So I think the judge should allow him in. This is exactly what rebuttal witnesses are for.
All right, and Marie in studio with me. Did you notice Camille Vasquez's reaction as they were going down the road of what did that attorney say to you? What did you say to her? And she wanted to stand up and she kept reacting to that.
She kept reacting because I guess she felt that that conversation should have been a private thing, but there is no privilege there because that is not her client. And she did right, and she told him at the end of the day, just tell the truth. And he testified to that. And I agree with the co-panelists. Absolutely, he's a perfect rebuttal witness, and he should be allowed to testify.
And you were saying the whole time, just say she told you to tell the truth. Just say she told you to tell the truth. And then she said it, and we're like, okay, good, because that's what attorneys should do when they talk to a witness. Number one, they should always talk to a witness before they testify. And number two, you should always tell your witnesses, please just tell the truth. Nima, what are your thoughts? I mean, an eyewitness, how significant? This is huge in my mind. Let me preface with that. The fact that you have an eyewitness potentially to the Hicksville where Amber says Johnny abused her. How significant is this witness to the Depp case?
Actually, I agree with you and Marie. I mean, on both points, this is a huge witness. We thought we might hear from the flight attendant, but this is equally as important. Someone that's going to come and say that Amber Heard essentially lied about this incident, in which case Johnny Depp was jealous and used force on another woman. And, you know, what you said about telling the witnesses, just tell the truth. That's attorney 101, because there's always going to be an allegation. Hey, you met with the other attorney. You didn't meet with me. They told you what to say. Your testimony is tainted. And the way you get around that, and really the ethical thing to do, is to tell the witness always, just tell the truth.
Right, absolutely agree with you. Nima, Marie, you're going to stay with us. We're going to take a break while we have the opportunity, because as you could see, the attorneys are up at a sidebar with the judge. We'll be right back after a short break. You have not missed any testimony, but the judge has made a decision. Morgan Knight is allowed to testify as an eyewitness to the Hicksville incident, or that night in question. We're going to go back into court. You haven't missed any testimony. This witness is taking the stand.
Do you solemnly swear or affirm to testify truthfully in this case under penalty of law?
I do. Sir, if you have a seat.
Good afternoon, Mr. Knight.
Good afternoon, Camille.
Would you please state your full name for the record?
Morgan Higby Knight.
Mr. Knight, where are you from?
I live in Los Angeles, California.
And what do you do for a living?
So I currently own and run Hicksville Pines Bud and Breakfast in Idlewild, California. And I created and ran Hicksville Trailer Palace in Joshua Tree, California, starting in 2009.
And how is Hicksville Pines Bud and Breakfast different from Hicksville Trailer Palace?
So Hicksville Pines Bud and Breakfast is up in the mountains of Idlewild, which is a beautiful snow town above Palm Springs. And all the units are A-frames instead of trailers, which we have. It's obviously a very different climate than Joshua Tree, which is a desert area. The rooms, which are themed at both places, are trailers, vintage trailers from the 50s through the 70s at Hicksville Trailer Palace. So there's also different kind of amenities. There's a pool in Joshua Tree. There's a rec room up at Hicksville Pines.
When did you first become the owner of the Trailer Palace?
Trailer Palace, I started building it in 2009. It took about a year with my collaborator, Stephen Butcher, and on the trailers. And we got done and opened in 2010.
Did there come a time that you sold the Hicksville Trailer Palace?
Yeah, I did at the beginning of 2020. I had some health issues and it was too much to run both at the same time. So I chose Idlewild because it was newer and shinier.
And just for my sake, how long did you own the Trailer Palace?
So 10 years of us being open, 11 years total.
And what was the Hicksville Trailer Palace?
So it started out as a artist retreat. I was a filmmaker at the time and wanted a place to get away and work on film projects outside of Los Angeles. I also put in a recording studio so musicians could record records there. I had lived in New Orleans for 5 years, and there was an amazing recording studio there called Kingsway, where all the musicians would come and they'd live in this big mansion and record their records. And I just thought that was a really neat thing for artists to be able to get away and create create whatever they were working on. Over the course of the build out of all the trailers, themed trailers, which I'm a huge fan of this hotel called Madonna Inn. And so I wanted to do really detailed themed trailers. It became too expensive to just make a living off of an artist retreat. So I decided before I was done to make it a hotel as well.
And what were your job responsibilities, generally speaking, when you owned the Hicksville Trailer Palace?
So I would be live-in manager some nights, a couple nights a week. I would also drive out from Los Angeles twice a week and bring supplies that you can't get out in the Yucca Valley area and Joshua Tree. There's just a lot of things like, Smart and Finals, Costco's and stuff. So I would drive that stuff out. There's also no USPS, so sometimes I'd have to get things shipped to my house and drive them out as well. I would also just do constantly building and creating new stuff at Trailer Palace, whether it's new trailers or amenities. So I would be working on that stuff as well. I'm a big fan of the fact that Disneyland is always making it better and better.
And when you were the live-in manager, does that mean that you spent the night at the Hicksville Trailer Palace?
Yeah, we have a house on site where the recording studio was, and there's a bedroom in there. So whoever is live-in manager those nights stays in the house and basically lives there. There's a kitchen and everything.
Have you ever met the plaintiff in this case, Mr. Depp?
I had met him really briefly at the Viper Room in the late 90s. I worked with some of the people that performed there and was good friends with this girl Robin from the Pussycat Dolls and some other friends in this band, The Imposters. So I was there and I met him once.
How about Miss Heard? Ever met her?
I had never met her before. They were guests at the hotel.
When was the first time that you met Mr. Depp and Miss Heard together?
In late May 2013, when they were guests, Mr. Depp's assistant Nathan had rented out the entire place so they could have a night there in privacy.
And what do you recall, if anything, about Mr. Depp and Miss Heard's arrival to the Hicksville Trailer Palace?
Mr. Depp got lost, so his security guard who arrived early asked me if I could go fetch them because he had an old car that didn't really fare on the dirt roads out there, which are pretty horrible. So I went out and made sure that they got themselves and the car back to Hicksville safely.
Do you remember approximately at what time that was?
It was 3 to 4 in the afternoon.
What was Mr. Depp's demeanor when they first arrived?
At Trailer Palace, he was super excited about the place, really complimentary, just had a lot of questions and seemed like he was in a really great mood.
And how about Miss Heard's demeanor? Anything stick out?
She was pretty quiet. She just kind of didn't say that much when I was giving them the tour of the grounds and the trailer.
And was anyone else with Mr. Depp and Miss Heard when they first arrived?
There's people that are arriving throughout the afternoon. So there was, I think 10 to 12 people total ended up staying. The security guard had gotten there earlier and just to check out the place. But yeah.
And did I understand your testimony previously that the entire trailer park was rented out by Mr. Depp and Miss Heard?
Yeah, the whole place slept, I believe at the time, about 25 people, but there was only 10 to 12 in this party.
And who was part of that party besides Mr. Depp and Miss Heard?
I'm really horrible with names, but I remember one of them was Miss Heard's sister and the security guard I mentioned before, but I honestly forgot his name too.
What happened when Mr. Depp and Miss Heard first came onto the property?
So I gave them a tour of, we give all guests a tour of their specific trailer and the grounds and show them around. When someone rents the whole place, they get another trailer called the bar trailer, which is basically a place to set up their alcohol and stuff. And some people in the group were just putting their beverages in that area.
And where were you when Mr. Depp and Miss Heard, did there come a time when Mr. Depp and Miss Heard went to the bar trailer?
I didn't notice most of the time that my interactions with them, everything's kind of centrally located. So there's a fire pit, bar trailer, and picnic tables all right in the same area. So they were generally around that area the entire evening that I saw them.
And what did you observe of Mr. Depp and Miss Heard as the evening progressed?
So Mr. Depp was super curious and really nice. He was also really interested in my innkeeper because she was a musician, so they would talk about music a lot. At one point, the innkeeper who lived at the next door property went home and grabbed her guitar, and they had sung a song or two around the campfire in the early evening. There was another instance where Mr. Depp, the innkeeper, her name was Jenna, and myself were talking about books and music, and Miss Heard came over and kind of interjected. She seemed a little annoyed that Mr. Depp wasn't spending time with her.
What about Miss Heard's demeanor made you think that she was annoyed?
I think just generally she It's hard. Like I think, I don't know. It was just like a gut reaction. Like I can't describe it, but you know.
How long were you with Mr. Depp and Ms. Heard that evening, generally?
So throughout the course of the evening, I was probably mostly with Mr. Depp, but 45 minutes to an hour total. So it was, that's over the whole course until the end of the night after the check-in.
Okay. And did you have an opportunity to observe Mr. Depp interact with other people, guests at the property that evening?
Yes, I saw him hanging out with his security guard at one point, and outside of the time that him and Jenna were singing around the campfire, he was off by himself a lot of the time, and Miss Heard was over at the campfire with her friends and seemed to have a good time.
And if you haven't already, can you generally describe for the jury your observations of Ms. Heard that evening?
Yeah, she seemed to be having a really nice time with her friends around the campfire. And yeah, everyone was in a pretty good mood.
Did there come a time in the evening that you observed Mr. Depp and Ms. Heard have a disagreement or an argument?
Yes. I was speaking with Mr. Depp, just one-on-one, talking about Hicksville, and Ms. Heard came over and she said that I want to talk to you, and seemed really upset about something. So I went and back in the house because it was really, they went off on their own, and she started yelling at him, and I didn't want to hear it. It honestly was really triggering because I've been in an emotionally abusive relationship before.
Objections. Move to strike.
What's the objection?
You're up. May we approach?
Okay, sure.
We are just getting to the good stuff. Nima Rahmani's still with me. You know, just testified that Amber Heard approached him, said that she wanted to talk to him and seemed upset. What do you think we might expect next?
Oh, I think we're going to hear about a jealous Amber Heard, someone that was instigating these fights, someone who wasn't the victim. And I think this is going to be powerful testimony. But Knight shouldn't be talking about his own experiences. That's just not relevant here.
Right, and that was the nature of the objection. Back to court.
Knight, will you please just explain for us what you observed when you saw Mr. Depp and Ms. Heard having an argument?
Yes. So Ms. Heard asked him to go talk off to the side, and she was upset at him, and she was yelling at him. And I personally had been in
Objection.
All right, I'll sustain the objection.
Okay.
If you could just explain to the jury what you observed when you saw Mr. Depp and Ms. Heard having an argument.
Okay. He was kind of cowering and seemed almost afraid, and it was really like odd to see because he was older than her, obviously. So, but I just went back in the house because I didn't
Objection.
want
You went to what he did.
All right, I'll sustain as to.
Understood. So after you observed the argument, fair to say you went back to to your house on site?
Yes, I did, yeah.
Okay. What happened after that?
So when I saw Mr. Depp on my next rounds, he apologized profusely and said, "I'm really sorry about that." She was upset.
Objection, Your Honor, hearsay.
Sustain. Next question.
What, if any, type of reaction did Mr. Depp have?
He was just really...
Objection, Your Honor, hearsay. He's going to say it again.
It's the reaction, it's not the statement.
All right, if you could make that clear, that's fine.
Just what type of physical reaction did Mr. Depp have after the argument between Mr. Depp and Ms. Heard?
He honestly, throughout the rest of the night, became a lot more quiet and was just very more petulant. In the beginning of the night, he was a lot more outgoing and extroverted, and throughout, as the course of the night went on, he was less and less so and more quiet.
Did you observe any of the guests consuming alcohol while on the property?
I assume they were. I mean, people had cups and there was alcohol set up in the bar trailer, but I didn't physically see them pour alcohol into their cup and cup go into the mouth per se.
Did you witness Mr. Depp drink any alcohol that evening?
I couldn't say.
Anything about Mr. Depp's demeanor that made you think he was perhaps intoxicated?
Yes, as the night went on, I am a former bar owner, so even though I wasn't drinking that night, I'm very familiar with the signs. So just as the night went on, like I said, he became more and more quiet, but he also, as we would have conversations, his head would kind of sway a little bit back and forth, which was a little, he was much less sharp than he was earlier in the night.
Did Ms. Heard appear intoxicated to you?
She did. She seemed, I think when she was angry at him, it seemed like she was intoxicated, but that's just based on my experience and my own personal trauma dealing with abuse.
Objection, Your Honor. Move to strike.
All right, I'll sustain the objection. We'll strike it from the record. Please disregard that testimony.
Did you observe anyone do or take drugs?
I did not.
Did you witness Mr. Depp and Ms. Heard interact other than the argument that you previously described for the jury?
At the end of the night, I heard a commotion. I was inside the house and came out. I couldn't tell what was going on. And Mr. Depp and Ms. Heard were having a discussion about I'm not sure what, but then they went to their trailer. At that point, a lot of people had already gone to bed. So it just kind of petered out. Everyone went to bed, including myself, and I didn't hear anything else the rest of the night.
This eyewitness at Hicksville, just described an argument between Johnny Depp and Amber Heard and states that his observation was that Johnny Depp was cowering. A powerful eyewitness or not? What do you think? Let us know on social media. We're going to squeeze in a break. We will hit the pause button. You are not going to miss any of the testimony.
philo.tv.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Let's lay the groundwork for what you're going to watch when we go back into court, because we did hit the pause button. You have not missed any of the testimony. Right now, attorney for Johnny Depp, Camille Vasquez, is questioning Morgan Knight on direct examination. So far, he has testified as the owner of the Hicksville Trailer Palace that he did see arguments between Johnny Depp and Amber Heard. He thinks there was drinking. Now let's go back to court. The question remains, did he see any violence between the two?
See Mr. Depp grab anyone?
Objection, leading.
Sustained.
Did you ever see Mr. Depp become physical with anyone?
Objection, leading.
Sustained. Next question.
Did you ever witness Mr. Depp get angry that evening?
Objection, leading.
Sustained.
What, if anything, happened the next morning?
The next morning, we have checkout at noon at the time, before COVID. And so around 11 o'clock, one of my innkeepers let me know that there was some damage.
Objection, hearsay.
Did something happen that caused you to go to Mr. Depp and Ms. Heard's trailer?
Yes, I was informed that.
Objection, hearsay.
It's not being offered for the truth, Your Honor. I mean, may we approach on this one topic?
Sure.
Thank you.
All right, Marie in the studio with me, and we've both been talking at the same time over all of this because of lots of things we're thinking. What are your thoughts as you're watching this unfold?
I am thinking that he's a great witness, and I think that he is an unbiased witness because he says both of them look like they were not in their right state. They were both drinking. He makes really Amber look like she's the aggressor because he says that Johnny was almost acting like a coward and being scolded. And he says so far that he didn't see any violence. I think he needs to stop talking about his own personal situation with violence.
The innkeepers let me know that there was some damage in one of the trailers, and it happened to be Mr. Depp and Ms. Heard's trailer. So I wanted to inspect the trailer because I was extremely worried. All those trailers that Steve and I worked on were like my babies, and the one they were staying in was the only one that was mostly original and restored 1950s style, and so I was very concerned.
So what did you observe when you went to the trailer?
I observed that there was a light sconce by the bathroom in the bedroom that had been broken off the wall, and a couple pieces were on the floor, and they were, yeah, it was basically just broken. The light fixture was hanging on the wall still, except for the pieces that were on the floor.
Did you come to understand how that happened?
Objection, foundation, and
All right,
light.
foundation. I'll sustain as to foundation, how he knew.
Did you ask how the sconce was broken?
Objection, hearsay.
Sustained.
How often do light fixtures in the trailers break?
They break pretty often. I mean, it's not like a usual thing, but things in the trailers generally get broken because it's all vintage trailers. And I would say as much as every couple weeks, there's some incident of damage in one of the trailers. In this case, Mr. Depp had told me that.
Objection, hearsay.
Objection.
So anyway, yes.
Beyond the light fixture, was anything else in the trailer damaged?
No, everything else looked fine. In fact, we have something we call a piggy fee that we address to guests, that if there's anything, what we call inconsiderate or unusually large messes, we charge them extra for it for a $25 an hour cleaning fee, but they did not receive one of those because everything outside of the light fixture looked fine.
And what was your reaction to seeing the damaged light fixture?
To be honest, I was relieved because it was not a big deal. There was already another light in the room, so I just tucked the wires in the wall until I had a few months later time to buy, it was matching sconce with another one in the room. So I had to, on eBay, find a matching pair that would fit there. And when I finally got around to it, I was able to get that and charge it to Nathan, whose credit card I had.
And what was your understanding of who Nathan was?
Mr. Depp's assistant.
Okay. And what did you charge Nathan or Mr. Depp for replacing that pair of light fixtures?
The pair came out to $62.
While you were on site, Mr. Knight, did you ever wear a mesh shirt?
No, I would absolutely never wear that.
At any time during Mr. Depp and Ms. Heard's stay on the property, did you see Mr. Depp become physical with anyone?
Objection, leading.
Overruled. That's
I'm sorry, that answer was?
I never saw Mr. Depp get physical with anyone when I saw him.
Thank you, Your Honor. Nothing further.
Cross-examination.
Thank you, Your Honor. Mr. Knight, you are a pretty big fan of Johnny Depp, aren't you?
I am not. To be honest, throughout the evening,
Sorry, I just asked you one question.
Oh, I
didn't
apologize.
ask you the rest of that.
I
You
apologize.
wanted to participate in this trial, didn't you?
I did not. I
You
was
knew-
asked by the attorney, and I wanted to. They asked me, and I said, I'll be happy to come and tell the truth.
You knew this was on camera, that it was being broadcast to a lot of people, and you saw testimony, did you not, in this case? And you seized the moment and responded to the umbrella guy, the lead person for Mr. Depp's Twitters. Did you not?
Objection, Your Honor. Argumentative compound.
Overruled.
Mr. Umbrella Guy is the lead. The lead.
You
what?
know that he leads one of the most predominant pro-Depp Twitters out there.
I have no idea. I don't care or follow the Umbrella Guy.
In fact, you do follow a Twitter called Johnny Depp Fan, don't you?
Absolutely not.
You don't? That's your testimony under oath?
It is my testimony under oath.
All right. And on April 21st, Mr. Depp testified in this case about Hicksville, didn't he?
I wasn't here.
And in fact, you tweeted in response to the umbrella guy on April 21, 22, quote, "That never happened. I was with them all night. Amber was the one acting all jealous and crazy." Do you
Yes,
recall writing that?
I do recall writing that.
Michelle, can you bring that up, please? We're going to call it Defendants 1903.
1903.
And I'm going to go ahead and ask you to redact, but leave in the umbrella guy and the date and the bringing in the Hicksville. Your Honor, I'm sorry, I'm just... While she's working on that, did you write and direct a piece called Matters of Consequence back in 1999?
I did.
And didn't Mr. Depp's first wife, Lorianne Allison, work as a makeup artist on that?
She absolutely did.
And while we're looking at that, 4 days after you tweeted to Umbrella Man,
I was Umbrella Guy.
The umbrella guy. Okay. Well, all right, now we have this up. I'm going to ask you to take a look what is Defendant's Exhibit 1903. Do you see that?
I do.
Okay, and that's from that umbrella guy on 4/21/22, correct?
Correct.
And it says bringing in the Hicksville incident accusations. Do you see that?
I do.
And there's clearly Mr. Depp testifying there, likely a video, right?
Okay.
And you respond, that never happened. I was with them all night. Amber was the one acting all jealous and crazy. Do you see that?
I do.
Your Honor, I'm going to move the admission of defendant's 1903.
Any objection?
Yeah, Your Honor, we believe the first part of the that umbrella guy's tweet should be unredacted for context.
Well.
I have no idea what I was replying to.
It's hearsay. It's rank hearsay, and context
Your Honor,
is not necessary.
Your own approach.
Of course.
Take a look.
Approaching again, cross-examination has begun of this witness who says that he did not see Johnny Depp engage in any physical with anyone, any physical violence. We're going to take a break, but we will pause the testimony. You won't miss anything here on Court TV, your front row seat to justice. Let's get you back into court. You haven't missed any testimony on the stand. Morgan Knight, the owner of the Hicksville Trailer Palace. All right, Marie, we're in a sidebar while they're arguing about it. Do you think, I mean, you know, this witness, I think, is obviously has no stake in the game, and I'm going to hold your thoughts as we hear what happened.
Make that redaction. With that redaction, any objection?
No, Your Honor, thank you.
Okay, 1903 will be in evidence as redacted.
Okay. Yes. Now, so you reached out to the umbrella guy in this text, this Twitter, right?
I wouldn't call it reaching out.
Okay. And in fact, the umbrella guy is in Mr. Adam Waldman. Do you know who Adam Waldman is?
I have no idea.
Well, he's testified earlier that he talks to the umbrella guy.
That he what? He talks to the umbrella guy?
Yeah. Were you aware of that?
I honestly, this sounds like schizophrenia.
Okay. Now, 4 days after this event where you texted, Your Honor, yeah, it's in, okay, good. 4 days after that, you tweeted something pretty nasty about Elon Musk, didn't you?
I did.
Okay, thank you. So you don't like Elon Musk, right?
Objection, relevance.
Oh,
I don't know Elon Musk.
Overruled. Thank you.
So that was the context of that is that he had,
I didn't ask you for the context.
I apologize.
Okay. But you texted something that had swear words in it. Would you agree about Elon Musk?
Yes.
Okay. Now, let's talk about your recollections here. 45 minutes to an hour. Your recollection is that Mr. Depp actually drove there?
Yes.
What type of car was he driving?
An old one that was a convertible.
An old convertible?
I'm not a car guy, so I couldn't express the model.
All right, and your recollection was this was May of 2013?
Yes.
Okay, do you recall when in May?
Late May.
Okay. Now, you said that you spent a total of 45 minutes to an hour with Mr. Depp and Ms. Heard, is that correct?
Mostly Mr. Depp, but that's after the tour and after they were checked in throughout the course of the night.
Okay. And you don't recall any of the people that were there other than Ms. Heard's sister and the security guard, correct?
I don't recall any of their names.
Do you remember how many of them were female?
I believe it was predominantly female.
Do you remember how many males were there?
I don't, outside of the security guard.
Do you remember what any of the other people looked like?
They honestly just seemed like youngish hipsters, like for lack of a better term. I know that previously a couple of them had stayed at Hicksville Trailer Palace. That's how they knew about the place.
Okay. So you don't recall seeing how much anybody had to drink that night, correct?
I did not witness that.
And do you recall the use of drugs at all?
I did not witness that.
Okay. Were you sitting at any point with these people at the campfire?
I was not.
Okay. And when you said that that you saw Ms. Heard and Mr. Depp, and Ms. Heard was yelling at Mr. Depp, where were they?
She pulled him for a chat, and it was off towards their trailer, like a little bit off towards the dirt.
How many feet were there between the campfire and their trailer?
The campfire and their trailer?
Yes.
Approximately 75.
Okay. So where in that 75 feet did Ms. Heard pull Mr. Depp and yell at him and he cowered?
20.
Okay. 20
from the campfire.
From
not
the
trailer.
campfire.
Yeah.
So your testimony is that Ms. Heard grabbed Mr. Heard pulled him 20 feet over, yelled at him, and he cowered.
Yes, that's what I witnessed.
And then did they go back?
I went inside the house.
So you don't know whether they returned?
Just describing what he witnessed. Still with me before the break. I'd like to get some last thoughts and we'll pause the testimony. Marie, what are your final thoughts as we're watching this witness and his testimony?
I think so far, I think that Depp's team is doing a very good job because they're placing her as the person who is the aggressor. They didn't witness him being violent towards anyone. And during that incident, she alleged that he grabbed the arm of another female guest and said, "Oh, are you coming on to my girl? That's my girl, and I'll break your arm." No one witnessed that. At least this witness did not. And that person on the stand was there for the whole thing.
And nobody was ever presented by Amber Heard's team that testified, oh, Johnny Depp twisted my arm and did what Amber Heard said. All right, Nima, quick thoughts from you on this trial at this point.
You know, Ashley, I want to give Elaine Bredehoff credit. A week ago, we saw one of the most cringeworthy performances in court TV history, and she was tripped up on objection after objection by Camille Vasquez. But today, she got her revenge, and I thought she did an outstanding job objecting to those leading questions. I don't think Camille got the information out that she wanted, and I think, frankly, we all expected a better witness here.
All right, thank you. Agree. Lots of objections by his team. Thank you so much to Marie Pereira for joining us today in person in studio. Always appreciate the expert analysis. Nima staying with us. Stay tuned here on Court TV Live.
Hard work pays off.
Hi, good morning. All right, your next witness.
Your Honor, on behalf of defendant and counterclaimant Amber Heard, we rest.
All right, rebuttal evidence.
It was the concerns that were brought up at the wrap of the first movie, which is the issue of chemistry.
Miss Heard's breakout moment, the Stars Born phenomena didn't happen.
New developments in the Depp defamation trial. Earlier, Johnny Depp's experts did their best to drown Amber Heard's post-Aquaman prospects. One witness said that Heard's lack of chemistry with Jason Momoa was a bigger issue than any drama with her ex-husband. On the stand now, an eyewitness to the alleged Hicksville trailer park assault, where Amber Heard says Johnny Depp performed a cavity search on her. Is that what this witness saw? We're going back to court for more of Depp's rebuttal case in just a moment. Our legal experts are standing by to discuss when we have breaks or sidebars. All of that up next. Good afternoon. Welcome back to Court TV Live. I'm Judge Ashley Wilcott, honored to be with you. Again, we're going to take you back to court. You have not missed any testimony. We've hit the pause button. And on the stand, Morgan Knight. He owns the Hicksville Trailer Palace and is testifying on cross-examination as to what he saw, what he witnessed when he was there that night.
I
do not.
Okay. And do you know whether there were any disagreements or physical communications, anything of that nature at the campfire?
I do not.
Do you know whether Mr. Depp did anything to anybody else at the campfire?
I didn't see anything.
Okay, do you know whether Mr. Depp grabbed anybody's wrist and asked them if they knew how many pounds of pressure it took to break their wrist?
I wasn't there the whole time.
Okay. Is it your testimony that Mr. Depp and Ms. Heard went last to their trailer? Everybody else went before them?
The rest of the people, I think about half of them had already gone to bed, and it was all around the same time at the end of the night that the rest kind of scattered. There might have been a couple of people that went right after them or right before, but it was all around the same time.
Okay, so your recollection is that when Amber and Johnny Depp went back to their trailer, that dissipated, everybody then left at that point?
Yes.
Okay. Now, how far away was your house that you were staying in from the trailer that Amber and Johnny Depp were staying in?
I'd say it was about 75 feet away.
Okay. And the next time that you saw or heard anything was when you went there in the morning and saw the broken sconce. Is that correct?
Yes, I didn't hear anything after went to bed.
Okay. And that's the extent of your knowledge?
Yes.
Okay. I have no further questions.
All right, redirect.
Mr. Knight, how did you get involved in this trial?
I got a text from one of our old employees who I didn't talk to for
Objection,
years.
hearsay?
Don't tell us what the text said, just how did you get involved?
I got a text from, I got a...
That's still hearsay, Your Honor.
Okay.
Objection.
No. Overruled.
Thank you. Go on, Mr. Knight.
I was asked if it was...
No.
Objection, hearsay?
I apologize.
What did you...
I got a text...
What did you received a text? Okay.
Yes.
From whom?
From a former employee.
Okay. And how long had it been since you had heard from this former employee?
Approximately 5 years.
And did you contact Mr. Depp or any of his attorneys?
Objection, leading?
Overruled.
I did not.
How did you get in touch with Mr. Depp's attorneys?
They got in touch with me.
Objection, hearsay?
Overruled.
Go on, Mr. Knight.
They reached out to me.
Okay. Sorry.
It's okay.
I don't have an objection right now.
Thank you.
It's only if he talks more.
Next question.
And how do you feel about participating in this trial?
Objection, relevance?
It's extremely relevant considering that they have accused him of being...
Overruled.
Thank you.
How do I feel about it?
Yeah.
I'm happy to tell what I saw, and that's the extent of it. I really don't care outside of that.
Thank you very much, Mr. Knight. Nothing
All
further.
right. I assume this witness is not subject to recall. Is that correct? All right. Sir, you're free to go. Thank you.
Thank you.
All right. Your next witness? Or is it going to be a deposition, or is it going to be...
Apologies, Your Honor. Thank you. Dr. Shaw.
Okay,
Plaintiff
Dr.
calls
Shaw.
Dr. Shaw.
Okay.
This witness is done testifying. Let's bring in our experts. We'll pause the testimony. Still with us in Los Angeles, California, former federal prosecutor Nima Rahmani. Now joining us live in our studio, trial attorney, former criminal defense attorney Erica Wilson. Erica, let me start with you first. This witness, did this move the ball forward, do you think, for Johnny Depp's team?
I think it did a little bit. I mean, again, this is his whole rebuttal case, and so I would hope that his team is very strategic in bringing in people that is going to specifically rebut some of the main things that Amber Heard has put forward. So I think that this witness could be very helpful, and I like the attorney's question at the end. She wanted to kind of establish, hey, he's not an interested witness, so what he says does kind of hold a little bit of credibility.
You're right. I think you're right. You know, they, on cross, Nima tried to destroy his credibility, and they had to kind of rehabilitate him, which I think they did. How effective do you think? I know that you commented about Elaine Bredehoft and the fact that she objected a lot during this direct examination. How effective was her cross for Amber's team?
I think it was somewhat effective. I had really high hopes for this witness because we saw that preview during the judge's voir dire, something that the jurors didn't see, but everyone on court TV saw. So I thought he was going to be a bombshell witness for Johnny Depp, really disprove a lot of Amber Heard's allegations regarding the Hicksville incident. But that's why I said I think Elaine did a good job tripping Camille up with those leading questions, really threw her off her game during the direct examination. I thought the cross was somewhat effective. She asked some questions that I think may have been, and by she, Elaine, potentially misleading, because at least everyone's reporting on social media that the witness didn't really follow that Twitter account.
And, you know, we just have to say that's the point of cross-examination. You want the jury to hear what you're saying, not the witness. Effective or not, we'll have to wait and see. We're going to get you back into the courtroom. The next witness taking the stand.
I swear or testify truthfully in this case or penalty of law.
Thank you, sir. All right, yes, ma'am.
Good afternoon, Dr. Shaw. Can you please state your name for the record?
My name is Richard John Shaw.
Dr. Shaw, can you please describe your educational background?
I'm a psychiatrist. I went to medical school at the University of London in England. I went straight after high school. That's actually the system in the British medical system. I did 2 years of preclinical training and then 3 years of clinical work with patients. Following that, I moved to New Zealand to do an internship. It was an internship in neurology, medicine, surgery, and psychiatry. I spent 3 years in New Zealand, and I did a year of psychiatry residency training. Excuse me. And following that, excuse me. Following that, I moved here to the United States for the first time and did a residency in adult psychiatry at the Albert Einstein College of Medicine, which is in New York. That was 4 years of training in the Bronx. And I also did some subspecialty training in family therapy, couples and family therapy as in my 4th year. And after that, I moved to California, and I've worked at Stanford. I studied at Stanford. I did a fellowship in child and adolescent psychiatry, and I've been at Stanford pretty much since then.
Dr. Shaw, what is your current position?
I'm a professor of psychiatry in the Department of Psychiatry at Stanford. I also run what's called the Psychiatry Consult Service at the Children's Hospital at Stanford.
What, if any, professional certifications have you received?
I have what's called board certification in adult and general psychiatry. I obtained that from the American Board of Psychiatry and Neurology in 1991. And then I obtained subspecialty board certification in child and adolescent psychiatry in 1993.
Are you a member of any professional organizations in the field of psychiatry?
Yes, I am. I'm a member of the American Academy of Child and Adolescent Psychiatry. I'm also a member of the Academy of Consultation Liaison Psychiatry.
How long have you been practicing psychiatry?
If you include my training in psychiatry residency in the US, that would be since 1985.
So is that approximately 35 years?
Yeah, I think so.
Okay. What percentage of your practice involves treating patients?
Yeah, approximately 3/4 of my time is working with patients. I work in the pediatric hospital, treating a combination of mainly children and adolescents with severe medical conditions, but also working with parents of children who have severe medical conditions. I also consult to the pediatric emergency room, and we evaluate patients who show up with suicide attempts and other serious situations.
What does the remaining quarter of your practice entail?
Well, as a professor, I have to do a number of academic activities. So I do research, I do a lot of teaching, I give lectures, I supervise residents, medical students, and fellows in psychiatry. I do some administrative work. Yeah, so it's a pretty diverse, varied day and week.
Can you tell the jury a little bit about your research and academic work?
Yeah, a lot of my research has involved looking at the issue of trauma and PTSD in parents who have medically fragile children. A lot of these parents are naturally really affected by their child's illness and develop trauma symptoms. So I've developed some interventions to try to help parents, provide support and treatment to reduce their symptoms of trauma.
Have you published articles or books in your area of expertise?
Yes, I have. I've published approximately 70 or probably closer to 80 peer-reviewed manuscripts in different scientific journals. I've also published a number of book chapters on various topics, approximately 30. And I have published 3 textbooks, one of which has gone into a second edition on topics that are related to my area of expertise. And one of them actually is about the treatment of PTSD in parents of premature infants.
Have you published a book through the APA?
Actually, all of those books were published through the APA, the American Psychiatric Association. They have a publishing house, and that's been my publishing company.
What is the APA?
The APA, the American Psychiatric Association, not to be confused with the American Psychological Association, is a professional organization that represents psychiatrists in the US. The last time I looked at this, I think there's about 37 or 38,000 members. And the APA has many different roles. One of it is advocacy in psychiatry in the US, but it also has an important role in terms of education. So they host an annual scientific meeting every year in which psychiatrists will present their research. It publishes a number of journals in the field, and from time, fairly frequently it publishes guidelines for professional practice or about ethical guidelines that they hope that the members will follow as part of their practice.
Witness number 7 for Johnny Depp's rebuttal. Dr. Shaw is going through his qualifications. We are going to stop the trial there. So when we come back, you will continue to hear his testimony here on Court TV Live. the stand for Johnny Depp as part of his rebuttal is a forensic psychiatrist. He's going through his qualifications. Let's take you back into court where you have not missed any of the testimony.
Involved with the APA?
Well, I mentioned my publishing. I also present at the scientific meetings. I last presented in 2021 during COVID. It was virtually, but on the topic of group therapy for parents with trauma symptoms. I follow the APA and their various guidelines. I think it's a really influential and important institution.
Going back to your credentials, what, if any, professional awards have you received?
I've been given several teaching awards at Stanford University, and the American Academy of Child and Adolescent Psychiatry that I mentioned honored me with an award for service to my specialty several years ago. I don't remember exactly when.
Have you given any public presentations in the field of psychiatry?
Yes, that's part of our work as an academic psychiatrist, is to lecture, to give presentations. So I present fairly frequently at annual scientific meetings, as I mentioned. I've been invited to give grand round presentations at different medical centers, including University of Pennsylvania and Harvard. So that's just part of our role is to try to educate our colleagues about our work.
Have you testified as an expert in the field of psychiatry before?
Yes, I have.
On how many occasions?
I would estimate, in terms of deposition and trial testimony, approximately 50 times in the past 15, 20 years.
What type of cases did you testify as an expert in?
They're pretty varied. So some of them have been medical malpractice. I've also done a number of cases evaluating victims who've been subject to physical or sexual assault or trauma.
What work were you asked to do in this case?
My role in this case was to give my opinions about the testimony and opinions of Dr. Spiegel, whom you heard from yesterday morning.
And what work have you done to form your opinion?
I was present yesterday in court listening to his testimony. I have viewed his depositions. He had 2 depositions earlier this year, and I watched those depositions. I've also read a lot of deposition testimony. For example, testimony by Mr. Depp's psychiatrist, Dr. Blaustein, by his physician, Dr. Kipper, and nurse Debbie Lloyd. I've reviewed depositions by many of the therapists involved in this case, including Dr. Banks, the relationship consultant, Dr. Cohen, who was Ms. Heard's therapist, and I think Dr. Anderson, who I think provided some couples therapy. I've also reviewed the medical records of Dr. Kipper and Dr. Blaustein, and some various email communications. I think a lot of the information that has been talked about here.
Thank you. Your Honor, at this time, we'd like to offer Dr. Shaw as an expert in the field of psychiatry.
Any objection?
Can we approach?
Okay.
Offering this witness, Dr. Shaw, as a forensic psychiatrist, as an expert. Now they're approaching. Erica, what are your thoughts about the reason they might be approaching? I mean, if you have somebody testify as to all the qualifications, typically it's not that difficult. They can then be considered an expert.
I really wouldn't know what the reason for the possible objection. He seems well qualified in terms of voir dire, and then not to mention they still have an opportunity to ask whatever follow-up questions they want to ask if they have any other additional questions about his qualifications. So I'm really kind of at a loss for words for why these attorneys would, pick your battles. This is not one of those ones that you really want to go after.
Right, and his qualifications, he then followed up by the fact that he sat in during Dr. Spiegel's testimony, which we know experts are allowed to do, Nima, in. He also listened to depositions by the other therapists. What are your thoughts about this particular witness as a rebuttal witness?
Ashley, I agree with Erica. There's no legal basis to challenge this expert's expertise or qualifications to testify. I mean, Dr. Shaw's a professor at Stanford. He's testified 50 times. He's there on rebuttal to rebut what Dr. Spiegel said yesterday. So maybe there's some other issue that they need to discuss. Maybe his opinions weren't disclosed, but there's really no basis to exclude him altogether.
And, they're going back. I have another question. We'll hold that back to court.
Dr. Shaw, you testified that you observed Dr. Spiegel's testimony yesterday?
Yes, that's correct.
And to reorient the jury, can you please generally describe the main areas in which Dr. Spiegel testified?
Yes, he...
Objection, Your Honor. They heard what he testified to. What's his opinion?
All right. Foundation to reorient them?
That's okay. We can move forward.
Okay. Do you have an opinion of Dr. Spiegel's testimony?
Yes, I do.
And what is your opinion?
I have a couple of primary opinions. The first is that my opinion is that he violated the ethical principles that are outlined in the Goldwater Rule when he gave his opinions about Mr. Depp, specifically with relationship to personality traits and his cognitive abilities. My second primary opinion would be that that Dr. Spiegel's opinions were unreliable and that he had insufficient information.
Objection, Your Honor.
All right. You're going to approach?
Yeah.
This doctor just said Dr. Spiegel's opinions were wrong, basically. But he's an expert. I'm just struggling for words because, Erica, let me start with you again. This doctor, Dr. Shaw, is an expert, a forensic psychiatrist, and certainly I think he could opine in his opinion that Dr. Spiegel was wrong.
Absolutely. I mean, that in its very self is what expert witnesses do. They give their expert opinion. And if they lay the foundation and he's heard the testimony, he can then say, I don't think that his opinion that from the previous doctor was sound. And that's exactly what he's supposed to do. So again, I'm not sure what all of these objections are, maybe to kind of throw the doctor's testimony off, to kind of get them off their rhythm. But I don't see a real basis to object at this point.
And I don't even see a real rhythm because the fact of the matter is he hasn't really started testifying. All right, Nima, when we come back, we're going to talk about trial skills when I have an opportunity with you. But we are going to take this opportunity while they're at the sidebar to take a break. You're not going to miss anything. Stay with us here on Court TV Live. Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Let's get you back into the courtroom on the stand. Forensic psychiatrist testifying for Johnny Depp's side of this case. They were at a sidebar when we took a break. Let's go back. They're now resuming testimony.
Dr. Shaw, you mentioned the Goldwater rule. What led up to the publication of the Goldwater rule?
The Goldwater rule came about in response to an incident that occurred during the 1964 presidential election when Senator Barry Goldwater was running as a Republican candidate. And there was a magazine called Fact Magazine that started a campaign to discredit Senator Goldwater. And they obtained a mailing list from the AMA and sent out a single survey questionnaire to about 12,000 psychiatrists in the US, asking if they felt that Senator Goldwater was fit to run for office. And about 2,000 psychiatrists responded, 1,000 of whom expressed very negative opinions about Senator Goldwater and made comments such as, for example, he was a megalomaniac, he was a paranoid schizophrenic, that he had narcissistic personality disorder. And as a result of that, he was replaced as a candidate and then went on to sue Fact Magazine for defamation of character. And he was successful in that lawsuit. And in response to this incident, the American Psychiatric Association, that I think was really concerned about how psychiatry was being represented and statements psychiatrists were making about someone they had never met or evaluated, issued the Goldwater rule. And the main premise of the Goldwater rule was that it was improper for a psychiatrist to render a professional opinion about a public figure unless they had personally and closely evaluated them.
What justifications did the APA provide, other than the ones you mentioned, for enacting the Goldwater rule?
They wanted to make sure that psychiatric illness wasn't being stigmatized. They wanted to ensure that individuals weren't defamed by statements made by a psychiatrist that weren't backed up by medical evidence. And they also wanted to preserve the integrity of the psychiatric profession, since I think the public in general, when a psychiatrist speaks out publicly and expresses an opinion, a psychiatric opinion, people generally like to take that seriously, and the APA wanted to make sure that those opinions were credible and could be relied upon.
Have there been any updates to the Goldwater rule?
Yeah, since 1973, which was when the Goldwater rule first came out, there have been a number of revisions and publications by the APA. They're called Annotations in Psychiatry, in which the Goldwater rule has been better defined and expanded to some degree. So, for example, in 2017, in this publication, the APA reasserted that it was not ethical to provide a psychiatric or professional opinion about someone who had not been evaluated personally by that psychiatrist, that it was unethical to provide an evaluation without obtaining consent from that individual. They also sort of really kind of defined what a professional opinion is, and how they defined it is that an opinion that a psychiatrist expresses about someone's speech, behavior, or any characteristic about that person, if that opinion is made using the expertise, experience, and knowledge inherent in the practice of psychiatry, that is considered a professional opinion. So it might include making a diagnosis or not making a diagnosis. And the other I think a couple of important things about that 2017 document were that the APA specified that if a psychiatrist is to give an opinion about someone, about the diagnosis or personality characteristics, whatever, that they have to follow an appropriate methodology. They have to do an evaluation that follows the standard practice of a psychiatrist here in the US. And if they don't do that, they are considered to be, affecting the integrity of both the psychiatrist and the psychiatric profession. And this revision of the Goldwater rule definitely received a lot of support. The president of the APA at the time stated that breaking the Goldwater rule was irresponsible, stigmatizing, and definitely unethical. So that was a very strong statement from the president of the APA.
What other medical organizations have weighed in on this issue?
Yeah, the number of organizations have their own sort of version of the Goldwater rule. The American Medical Association, that represents physicians in the US, has an annual meeting, and they have what's called a Council of Ethical and Judicial Affairs, and they had a meeting in 2017 in Honolulu, and they came up with their own statement about the issue of whether physicians can provide opinions without directly evaluating somebody. And their opinion was that physicians should refrain from giving a psychiatric diagnosis about any public figure, including celebrities and people in the media.
Are there exceptions to the Goldwater rule?
There are exceptions, yeah. And I think Dr. Spiegel had a lot to say about this yesterday when he was saying that if you couldn't express an opinion without evaluating someone, it sort of made the whole specialty or role of experts in the court sort of null and void. But there are exceptions and situations in which an expert can give testimony in court. So one good example would be if there was a medical malpractice case, or if there was a case that involved a patient who'd committed suicide and the courts wanted to find out whether the psychiatrist had followed appropriate practice. The expert can review medical records and can give an opinion based on those records, provided those records have sufficient information, for example, about the diagnoses, about the treatment, about how the patient was responding or not responding to treatment.
Did you form an opinion about whether Dr. Spiegel complied with the Goldwater rule?
Well, my opinion is that he did not. He expressed a number of professional opinions about Mr. Depp that we heard about yesterday. And again, he did so without an evaluation, without consent. He did not follow the guidelines of the APA in the 2017 revision, where it was considered important that there be sufficient information obtained by that expert to give an opinion. So I would definitely felt that his conduct, unfortunately, did violate the Goldwater rule.
And specifically, what opinions of that Dr. Spiegel gave yesterday do you feel violated the Goldwater rule?
Yeah, I think that, well, there were sort of two primary ones. The first that you heard about was that Dr. Spiegel had professional opinions about Mr. Depp's personality. And he talked a lot about how he believed that Mr. Depp had narcissistic personality traits. So, and he also, talked a lot about narcissistic personality disorder. So, narcissistic personality disorder is a diagnosis in the Diagnostic and Statistical Manual. It's called the DSM-5 for short. It's a diagnostic manual published by the APA.
Objection, Your Honor. Can we break for a moment?
Okay.
They are approaching. Nima, I'm spinning back to you because I've got to ask you this, trial skills-wise. Have you noticed they were stating objections and the reason for the objection, the basis of the objection. Now it's objection, may we approach? Objection, may we approach? In terms of trial skills, in your opinion, as a former federal prosecutor, is this the correct way to handle this?
It is. You're not supposed to make speaking objections as a lawyer. I mean, you see the lawyers talking over one another, arguing. You know, we obviously don't like all the sidebars. It's a break in the action. I'm sure the jurors aren't happy about it, but really that's the proper way to discuss an objection outside the presence of the jurors. You don't want to be talking over one another.
And just a reminder, in some states, I know they do not record sidebars, and the judge then has to say what happened in a way they can say it in front of the jury. In a lot of states, they record these sidebars. So this is on the record, but to your point, Nima, outside the presence of the hearing of the jury. It looks like they are going to continue direct examination.
Go ahead, Dr. Shaw, please continue.
Sure. So I was just talking about narcissistic personality disorder in the DSM-5. So the diagnostic criteria for that are, I'm not going to remember every word about this, but essentially it's a pattern of grandiosity, a need for admiration, a lack of empathy that's demonstrated by that person since young adulthood. And the DSM-5 has 9 specific criteria, and for someone to meet the diagnosis, you have to meet 5 of those criteria. And so when, as a psychiatrist, we're trying to make a diagnosis of any personality disorder or any diagnosis in general, the normal professional guidelines would dictate that we would do a very careful diagnostic interview. And there are actually interviews specifically written to assess personality disorders. It's also possible to have the individual fill out questionnaires. There's something called the Narcissistic Personality Inventory. This is a 40-item checklist that taps into various components of narcissistic personality disorder. And it's also possible to get psychological testing, like the MMPI that I think you heard about in reference to one of the other experts here. So with all of this information, including collateral information from family members, work colleagues, information of that sort, it is possible to come up with a diagnosis of narcissistic personality disorder. So in the case of Dr. Spiegel, he had none of this information, even though he came out and stated with what he described as a degree of medical certainty that Mr. Depp had narcissistic personality traits. And if you remember somewhat towards the end of his testimony yesterday, he was asked to, since he couldn't provide any documentation from the medical record about narcissistic personality disorder or narcissistic personality traits, he was asked about what is referred to a lot in his testimony as record evidence. So information that he obtained from depositions, from text messages, from emails, whatever. And so he was asked to give, I think, 5 examples of record evidence that would make it seem like Mr. Depp met criteria for narcissistic personality traits. And I'll just mention a couple of them, just to illustrate my opinion, is that testimony did not really hold together. So he stated, for example, that
let's pause it right here so we can take a necessary commercial break, and we'll take you back into the courtroom in Fairfax, Virginia.
.com for a limited time offer.
Back to court. Dr. Shaw on the stand. You haven't missed any of his testimony, testifying as to why he believes that the opinions of Dr. Spiegel cannot be considered under the Goldwater rule.
Narcissistic personality disorder is a sense of entitlement. And the example Dr. Spiegel gave is that he believed that Ms. Heard married him for his money. So clearly, sense of entitlement is from a psychiatry perspective, that's very different from a belief that someone wanted you for your money. A second example that was given was that he was asked to give an example of how Mr. Depp had shown that he was envious of others, which is another criterion for narcissistic personality disorder. And the example that Dr. Spiegel gave is that Mr. Depp was jealous of Ms. Heard because he believed she was having an affair with Mr. Franco. Now, if we look at these two terms as a psychiatrist, there's a big difference between being envious and being jealous. As a psychiatrist, when I think about envy, I think about somebody wants something that someone else has, and it makes them feel
Objection, Your
bad.
Honor. I think this is going beyond his
All right.
testimony.
He's giving his opinion as to how Dr. Spiegel violated the Goldwater rule with respect to his testimony about narcissistic personality traits.
He did, but now sustain the objection. Next question.
Okay. Okay, and you mentioned two major examples. What was the second one?
The second one was confusing being envious with being jealous.
Oh, sorry, Dr. Shaw. I mean, you mentioned two major examples of ways Dr. Spiegel violated the Goldwater rule. What is the second?
Oh, sure. So the other big category had to do with Dr. Spiegel's evaluation of Mr. Depp's cognitive abilities. And his general opinion was that Mr. Depp had deficits in his memory, in his attention, in his processing speed, that he had word-finding difficulties. Again, Dr. Spiegel did not evaluate Mr. Depp, and the information that he relied upon, there were two pieces of information. The first was that he watched a very long deposition that Mr. Depp gave the day after I think he had flown back from London to the East Coast. And he made observations about Mr. Depp's behavior in that deposition, and felt that he could opine or give an opinion about processing speed and other cognitive aspects. He also made reference to something you heard about yesterday, this thing called the mini mental status examination. This is a brief screen for memory and cognitive functioning that is often done. And he testified that Dr. Blaustein had administered the mini mental status examination. And although, from the records, all we know is that...
Objection, Your Honor.
I'll sustain the objection.
Dr. Shaw, without going into Dr. Blaustein's record, what information does a mini mental exam provide?
Objection, Your Honor. It's beyond the scope of his estimation.
Overruled as to that limited question.
Mm-hmm. Yeah, so the mini mental status is, it's a series of about 10 or 11 questions and tasks that someone completes, and you get a score out of 30. What Dr. Spiegel testified was that Mr. Depp could not recall 3 words after 5 minutes. And he used that as an example of Mr. Depp having cognitive deficits that he specifically attributed to Mr. Depp's alcohol and substance abuse. And he really did not have sufficient information. I liken a mini mental status exam it's like taking someone's temperature. If it's elevated...
Objection, Your Honor, and I think it's going beyond
No,
designation.
I'll sustain the objection.
Okay. Now it's probably a good time for a break.
Okay, sure. All right, ladies and gentlemen, I know you had a break, but we didn't. So we're going to go ahead and take our afternoon break for 15
All right, there's a break. So Nima Rahmani, Erica Wilson are still with me. Erica, your last thoughts about this rebuttal witness, Dr. Shaw, and if it's helping.
I think it is helping, but my first question is, how did Dr. Spiegel's testimony even get in the first place? I'm sitting here and I'm wondering, how would you even let a licensed professional who has not assessed or done any sort of therapeutic interventions with Johnny Depp opine as to any sort of diagnosis? So I think it's boring, it's tedious, but I think it's very necessary in order for the jury to be able to know that these diagnoses that Dr. Spiegel gave were not medically sound.
And you raised a really good point, because there should have been pretrial motions about these things, Nima, and this should all have come out in pretrial motions so they knew how to proceed smoothly at trial and not waste the jury's time. What is your assessment of this expert's testimony?
Ashley, even though speaking objections are inappropriate, they give us a lot of information, and now we know why we have so many sidebars, because Dr. Shaw's testimony is limited to this narrow issue, this Goldwater rule, this alleged ethical violation by Dr. Spiegel. So to the extent that Depp's team is trying to get additional opinions out of him, they're objectionable. But, I agree with Erica, really kind of boring testimony here. You have one doctor opining about another. You have a limited amount of time, and we expect maybe Johnny Depp to show up tomorrow. But is this how you want to end if you're his team?
Right. Primacy and recency. Nima Rahmani as well as Erica Wilson, thank you both for joining us, for all the expertise. Of course, I also want to thank all of you at home for joining us. Michael Ayala is going to take it from here. Still to come, testimony from the former boss and roommate of Amber Heard's sister.
best deal ever.
Hello, and welcome back to Court TV Live. I'm Michael Ayala. Thank you so much for being with me this evening. Day 21 of testimony. Amber Heard has rested her case in chief, and Depp's rebuttal case is in full swing. The jury is hearing from witnesses who directly contradict some of the testimony heard during Amber's case. Now, Team Depp called his own doctor today to contradict Heard's medical expert regarding his hand injury. They also called a series of witnesses who did their best to undermine Catherine Arnold's testimony that Adam Waldman's alleged defamatory statements caused the decline in Heard's career. It is, folks, the stuff of rebuttal cases. It's what they're made of, and still to come, two potentially game-changing witnesses, Jennifer Hollowell and Kate Moss. Now, Hollowell's videotape deposition will contradict Amber's sister's account of that staircase incident. That could come up later this afternoon. And Moss, of course, will try to clear up a nasty rumor about Depp pushing her down a flight of stairs, and then no doubt tell this jury what a wonderful guy Depp was when they were dating. All that and more for what is shaping up to be a pivotal final week in the dueling defamation suits trial. All right, I want to get you back into the courtroom now. On the stand still, Dr. David Shaw. He was brought in by the Depp team to contradict some of the testimony brought in by Dr. David Spiegel. Of course, he was the expert brought in by Heard's team to talk about a diagnosis from afar, or from the corner of the room, as my mother would say, of Johnny Depp. In fact, that he had narcissism and had traits that would lead to an idea that would be connected with domestic violence. Let's go back into the courtroom for his continued direct examination.
Dr. Shaw, is the Goldwater rule limited to diagnoses?
It's not. It's includes all professional opinions.
Do you agree with Dr. Spiegel that the Goldwater rule doesn't apply to expert witnesses?
I don't agree, no.
How could Dr. Spiegel express an opinion without violating the Goldwater rule?
This has actually been a topic that's been written and published about. So it is possible for someone to give testimony about a matter without interviewing someone. And there's certain sort of ways that it should be framed. So, for example, when Dr. Spiegel was testifying about the report that Mr. Depp was unable to recall these three objects, what he could have done is said that I have not personally examined Mr. Depp, so I can't speculate about his cognitive state or ability to function cognitively. However, it is possible that someone who's not able to recall three objects could have issues related to substance use, which was what his opinion was. However, what he should have done in expressing his opinion is then have followed up to say that in order to really establish whether these were relevant and significant cognitive deficits, Mr. Depp should have had psychological testing to establish the nature of these deficits. And he should also have added that there are other potential explanations for these findings. So, for example, it's possible that Mr. Depp...
Objection, Your Honor. He's now going past the designation.
I think he's just opining as to, or is responding to Dr. Spiegel's testimony yesterday.
No, he's opining as to what Dr. Spiegel could have said, but it's past the, whether he, about the Goldwater rule.
If we can move on.
Okay. Who is qualified to give an opinion about cognitive deficits and processing speed?
It would have to be someone who could conduct the type of neuropsychological testing that I was mentioning. You can't establish the presence of cognitive deficits without a battery of tests.
Objection. Again, this is beyond the Goldwater rule.
Overruled.
You can't establish cognitive deficits without appropriate neuropsychological testing. And that can only be done by a psychologist or neuropsychologist. So a psychiatrist like Dr. Spiegel would be giving an opinion outside of his area of expertise if he gave an opinion about cognitive deficits that required psychological testing to be further evaluated.
Dr. Spiegel yesterday testified about the practice of forensic psychiatry. Do you recall that testimony?
Yes, I do.
What is forensic psychiatry?
Forensic psychiatry is a specialty of psychiatry that relates to matters on the intersection between psychiatry and the law. So, for example, what we're doing today is forensic psychiatry, where a psychiatrist comes into court and gives an opinion about a matter to help the court come to an opinion.
Are there professional standards that govern the practice of forensic psychiatry?
Yes, there are.
And what organizations have issued those standards?
One of the primary organizations that has issued guidelines about the practice of forensic psychiatry is called the American Academy of Psychiatry and the Law. This is an organization that represents forensic psychiatrists. And it has published guidelines about what constitutes an ethical and sound practice of doing a forensic assessment and providing a psychiatric opinion. So this guideline, I think was published in 2015, actually contains many elements that are consistent with the Goldwater Rule. So, for example, it states that for a forensic assessment to be done, there has to be informed consent, and there should be a very thorough, comprehensive evaluation that would include reviewing past records, past psychiatric history. It would include doing what's called a mental status examination, which is a careful evaluation of someone's mood, cognition, things of that nature. And the guidelines do state that it is reasonable or permitted to provide an opinion without an evaluation, but if you're going to do that, there's some things that you have to really make clear in your opinion when you express that opinion. And the first is that you have to acknowledge the limitations of your opinion and not, like Dr. Spiegel, say that his opinion was held with a degree of medical certainty. You have to explain what's missing, what data you did not have that you were not able to rely upon in coming to that opinion. You also have to talk about what additional information you would need to come to that opinion. And even though these guidelines say it's permissible to do this, the text is still, I think, not fully in support of psychiatrists doing this. So their statements are that opinions rendered without a proper database, which is what we as psychiatrists rely upon to make diagnoses and give opinions, professional opinions, is questionable and not generally recommended.
Did you form an opinion about Dr. Spiegel's testimony with respect to these practice guidelines?
Yes, I did.
And what is your opinion?
Well, my opinion is that he did not follow those guidelines. So, for example, he did not have consent. He did not do even a basic evaluation of Mr. Depp. When he gave his opinions, as I just mentioned, he said they were opinions that he had to a degree of medical certainty, and he did not make any statements about what other additional information he would have wanted to make that opinion. So, for example, when asked about should neuropsychological testing be performed, he said most patients don't have access to that, which is actually not at all true. I mean, every medical school has neuropsychologists that can do testing. So I think that was an unfortunate statement. So I think those are the primary ways in which the Goldwater Rule was violated and the practice guidelines were not adhered to.
Dr. Shah, yesterday Dr. Spiegel was talking about correlation and causation. What is the difference between correlation and causation?
Objection. It's not in this designation.
It is. We can approach and I can show you.
Okay.
All right.
All right, they're going to a sidebar, so let me bring in my guest. I'm still with trial attorney and former criminal defense attorney Erica Wilson. Erica, great to see you as always. Thank you for being with me. First and foremost, this particular witness is called in to sort of rebut, we'll use that word, the testimony of Dr. Spiegel. Now, I gotta say he's doing a fairly good job at this point, right? So what does the jury do with Dr. Spiegel's testimony now? They go back into the deliberating room, somebody says something that Dr. Spiegel said. What do you think happens?
Well, see, I think this is going to be a problem because now you put the task of the jury to go in and make these different nuances. Did he give the prerequisite information? Did he qualify it in the right way such that it wasn't an evaluation? And I don't think you want the jurors getting down into the weeds for this particular specific issue, but I do think Dr. Shaw's testimony today is somewhat helpful to be able to give clarity such that it does kind of give the jurors a reason to give the side eye to what Dr. Spiegel said and not give that much weight to his opinions and or, depending upon what the jurors are going to determine, the diagnoses by Dr. Spiegel of Johnny Depp.
Yeah, you know, it's interesting because they've been given time limits in this case, right? So when you talk about using your time effectively, I wonder if this is the most effective way to use your time, because everything that he is telling this jury, I think you can already opine just from hearing Dr. Spiegel testify. You know, he did tell the jury, now there may be some ethical issues, but he did tell them he never examined Johnny personally. He told them what he based it on, basically watching depositions and some reports from other doctors. And a number of times he said he didn't want to call what he was doing diagnoses. It was more of a professional opinion. So all those things, when you take into account, I think that's exactly what this guy is saying, and that's what the jury's going to do with the testimony. So why spend so much time with this guy?
It's not an efficient use of their time. I keep saying they only have, these jurors are fatigued, so you're gonna have to go out with a bang. You don't want to bore them to death. I think, honestly, Dr. Shaw could have been done maybe about 30 minutes ago. Yeah. You go get in and get out what you need to get, and then sit down. And then with the more meaningful witnesses, the ones that are going to have the bigger impact, that's where you leave your time. Because remember, they have very limited time, so you don't have time to just have him pontificate and regurgitate the same things that Dr. Spiegel has already said.
Absolutely, and I think maybe it's possible by spending so much time with this doctor to refute Dr. Spiegel, you almost give Dr. Spiegel more importance than he really should have. Because the jury's saying, well, why are they spending so much time on these issues? Maybe what Dr. Spiegel said was important. You know, that kind of thing. All right, Erica, stand by. We do have to take a break right now. We are going to take that break when we come back. Now, we hit the pause button. Once they're done with that sidebar, they should be done by the time we get back. We'll take you right back into the courtroom. So keep it right here on Court TV. Welcome back to Court TV Live. I'm Michael Ayala. We continue our coverage of the dueling defamation suits trial featuring Johnny Depp and Amber Heard. On the stand, Dr. Richard Shaw. He's been called by Johnny Depp's team in their rebuttal case to basically rebut the testimony of a witness called by Heard's team yesterday, Dr. David Spiegel. Let's get back into the courtroom. I believe that sidebar is over.
Go ahead, Dr. Shaw.
Yes, so the difference between a correlation and causation, correlation is a statistical analysis of a relationship between two different factors. So in Dr. Spiegel's testimony, he talked about, there being a correlation between opinions he had about Mr. Depp, his narcissistic personality traits, his substance abuse, things of that nature. So a correlation doesn't say anything about whether or not these factors caused that, the behavior he was discussing. Perhaps one of the easiest ways I could describe this difference between correlation and causation is if we look at the issue of measles, if you'll bear with me. So there's a correlation between being young and catching measles. Now we know that measles is not caused by being young. Measles is caused by a virus. But young children have not been exposed to the virus. They don't have the immunity, so they have a higher rate of measles. So the difference statistically is, the difference is between causation and correlation is illustrated by that example. So another way I might put this is if we had 100 people in a room, just bringing it back to the issue of IPV that Dr. Spiegel was testifying about. Let's say we had 70 people who had all the risk factors for IPV and 30 people who had no risk factors for IPV. So what can we say about those 70 people? We can't say that any single one of those people has perpetrated IPV, even though they may have all the risk factors. And if we look at the 30 people who have no risk factors, we also can't say whether or not they have perpetrated IPV. So the actual presence of risk factors for IPV that Dr. Spiegel was talking about, they say absolutely nothing about what happened in this case.
Thank you, Dr. Shaw. Nothing further.
All right, cross-examination.
Good afternoon, Dr. Shaw.
Good afternoon.
You're not offering any opinion as to Mr. Depp's psychology, correct?
That's correct.
And you testified a lot about the Goldwater rule. You know of no case where an expert has been excluded from testifying based on the Goldwater rule, correct?
I don't know about the whole universe of cases. It's possible, but I don't know personally about one.
And you, before this case, you've never offered an opinion on the Goldwater rule before, correct?
That's correct.
And you've never written an article on the Goldwater rule, correct?
I have not.
And you've never given a presentation on the Goldwater rule, correct?
I have not.
And you've never been on any committees regarding the Goldwater rule, correct?
I have not.
Okay. And you agree that you've testified that there are exceptions to the Goldwater rule about having to interview the subject, right?
Yes.
And you understand that Dr. Spiegel requested to meet with Mr. Depp twice, but Mr. Depp declined, correct?
I'm aware of that.
And Dr. Spiegel stated in his designation and at trial yesterday that he did not meet with Mr. Depp, right?
Yes.
Okay. Can we put up Defendant's Exhibit 1904? Dr. Shaw, have you seen the opinions of the Ethics Committee on the Principles of Medical Ethics?
Yes.
Okay. And if you could turn to 79 of the PDF, and it's actually, thank you. You see where it's highlighted here?
Yes.
And it says, psychiatrists have also argued that the Goldwater rule is not sound because psychiatrists are sometimes asked to render
Objection,
opinions.
hearsay.
He's an expert.
Overruled.
Without conducting an examination of an individual. Examples occur in particular in certain forensic cases and consultative roles, this objection attempts to subsume the rule with its exceptions. What this objection misses, however, is that the rendering of expertise and/or an opinion in these contexts is permissible because there is a court authorization for the examination or an opinion without examination. And this work is conducted within an evaluative framework, including parameters for how and where the information may be used or disseminated. You see that?
I do, yes.
And this court authorized Dr. Spiegel to testify in this case, correct?
Yes.
Okay, thank you. I have nothing further.
All right, redirect.
Dr. Shaw, Mr. Nadelhoff just asked you about the court authorization of Mr. Depp's evaluation. Are you aware that the court has twice denied Ms. Heard's request for an evaluation of Mr. Depp?
I heard that yesterday in testimony, yes.
Okay, thank you. Nothing further.
All right. Thank you, sir. You can either have a seat or you can leave. Thank you. Your next witness. All right. Good to see you.
All right, now before we go back to the courtroom, I want to take this opportunity to take a break because coming up now is the videotape deposition of Jennifer Holloway. Again, she was a former employer and she actually stayed with Whitney, Amber's sister, for a while and has some very interesting things to say about what Whitney had told her about that staircase incident, which could really turn this case on its head. So stay right where you are. When we come back, we're going to take you into that courtroom for that deposition. Keep it right here on Court TV.
Give Lumia a try today.
Hello, and welcome back to Court TV Live. I'm Michael Ayala. We are getting down to crunch time in this dueling defamation suit trial between Johnny Depp and Amber Heard. Johnny probably has another day or so of witnesses. I believe only about 4 hours left in Heard's case, and 2 of those have to include closing arguments, so not a lot left for this jury to hear. Coming up next is a witness that I believe is very important. It's a videotape deposition. Her name is Jennifer Howell. She was friends with Whitney Enriquez. Now, Whitney is also Amber's sister, and of course she was present and testified to what happened at that staircase incident. Well, after all that, if you remember her testimony, she said she got out of the house, she had to get out. She went to stay with a friend. That friend was Jennifer Howell. And apparently she had conversations with Jennifer about that incident, which differ from the story she told on the stand. So let's get back into the courtroom for the videotape deposition of Jennifer Howell.
Please state your name and address for the record.
Jennifer Howell, Los Angeles, California.
And what is your current occupation?
I run the Art of Elysium, CEO of the Art of Elysium.
Let me just go back. Now, you've indicated that Whitney lived with you from January 2015 May 2015 to April 2016. Are you absolutely certain about those dates?
I am certain, yes. She came and went at different periods, but all of her stuff moved out of my house April 2016.
And I'm sorry, did you say you were 100% certain of that? Ms. Hall, could you answer my question?
Yes, she did go back to Amber and Johnny's at different points, but she was still living with me during that time.
The question I asked, because you were talking at the same time Ms. Vasquez was giving an objection, was I believe that you said you were 100% certain of those dates. Is that correct?
Same with me.
All right.
Oh, you previously testified that you are the CEO for Art of Elysium. Is that correct?
That is correct.
And are you still currently in that position?
Yes, I am.
And how long have you been the CEO for Art of Elysium?
I am the founder of the organization, so we did our first workshop in August of 1997, filed the legal paperwork in February of 98 to set up a 501c3. So I guess since the beginning of the charity.
Ms. Howell, when did you first meet Amber Heard?
At the Pineapple Express premiere is where I met she and her sister Whitney.
Do you remember approximately what year that was?
I believe it was around 2008. I'm sure that could be pulled. It was the LA premiere. I think there was probably multiple premieres, but it was the Los Angeles premiere of Pineapple Express.
Was Ms. Heard there with Mr. Depp?
No, this was long before. I was a guest of James Franco, and Amber was in the movie. And so I met she and her sister at to be specific, at the after party of the premiere.
Did Ms. Enriquez end up working for Art of Elysium at some point?
Yes, she did.
What year did Ms. Enriquez begin working with Art of Elysium?
I believe it was in 2014. I don't have those documents right in front of me. I believe it was leading into the year Amber was receiving the award.
And what was Ms. Enriquez's position at Art of Elysium?
Art salon manager, director.
Does Ms. Enriquez still work for Art of Elysium?
No.
When did that end?
2015, I believe.
Each time you saw Mr. Depp, did you ever see him doing any illicit, illegal drugs?
Never.
Did you ever see him consuming excessive amounts of alcohol?
Objection. Never.
Did you ever see Mr. Depp appear intoxicated?
No.
Did Ms. Heard ever show you photographs of depicting injuries on her face or body?
No.
Did Ms. Heard ever tell you that Mr. Depp was abusive towards her?
No.
Mr. Depp paying your legal fees, Ms. Howell, for this deposition and the testimony you've provided in the UK action?
He is not.
Who is?
Myself.
Do you feel any particular sense of loyalty towards Mr. Depp?
None at all.
Do you feel any sense of loyalty towards Ms. Heard?
None at all.
Ms. Howell, do you recognize this check as the check that the Art of Elysium received on behalf of Ms. Heard for a donation, an anonymous donation of $250,000?
Yes. Yes.
Well, you testified previously that you understood that the anonymous donor was Elon Musk. Is that true?
Yes.
If I could please have Exhibit 4 brought up. And for the record, it's date stamp JH 22 through 29.
Good for.
Do you recognize this document, Ms. Howell? And if you need to scroll through the 8 pages, feel free.
Can you scroll down? Yeah, I recognize that.
And what is this?
That is an email, I believe, I sent to Whitney.
Scrolling up to the first page of this attachment, who is Marcel
Parasol?
Sure, Parasol.
He is one of my oldest friends in Los Angeles who has served as a board member of the Art of Elysium and is one of my biggest confidants here in LA, kind of for the course of my career.
And going down to the 3rd page of this exhibit. Thank you. This is an email, Ms. Howell, that you sent to Whitney Henriquez on or about Tuesday, July 28th, 2020 at 11:02 a.m.
It is.
This is a true and accurate copy of an email exchange that you sent to Ms. Henriquez?
Yes, I believe I'm the one who gave that. Yes, it is.
And then did you forward this email exchange and the attachments to Marcelo Parasol?
Yeah, I asked him to keep it for me.
Why did you send this email and letter to Ms. Henriquez?
Because I've struggled very much with what to do in a situation that I love someone who I know is doing something very wrong, and I know that they're doing it because they're trying to protect their sister, and I'm trying to protect her, and I'm just trying to get her to wake up and do the right thing, which is tell the truth. It's the only thing that can help everybody involved in this case.
Ms. Howell, do you recall submitting a witness statement in the United Kingdom?
Yeah, they basically just called to verify the witness statement that was submitted previously.
And do you recognize this document to be the witness statement and the declaration that you submitted in the UK? And if you want to scroll down to look at it.
Yes, I recognize it.
And at the first page, do you see a date on this document?
January 13th, 2021.
Thank you. And is this document a true and accurate copy of the declaration that you submitted in the UK proceeding on or about January 13th, 2021?
Yes.
And are all the statements in your UK declaration accurate and true?
I mean, yes, I signed it, yes.
All right, let's pull up what I believe was Depp Exhibit 9. It's been marked as Depp Exhibit 9. Exhibit 9. So, Ms. Howell, earlier you were shown this document. Scrolling to the end of it.
Can you go? Okay.
There. Did Mr. Waldman assist you in drafting this email?
Absolutely not.
Did you speak with Mr. Waldman at all about drafting this email?
About writing an email? No. I did that on my own accord.
Did you speak with Mr. Waldman at all about contacting the ACLU?
I do not recall having a conversation with him about that.
And Ms. Howell, you testified earlier that you received a check from Fidelity Charitable in January of 2018. Is that correct?
I don't know if I said the date, but yes, I received an anonymous donation from that check that was submitted. Whatever it's on there, I just don't know the date off the top of my head.
And you testified that there was a letter sent along with that that said that it was in honor of Amber Heard?
Yes. Richard, I was guaranteed 20 minutes with him after being attacked for 3.5 hours by your side the last time. So I am going to stick by what I was told before entering this and what your side agreed to.
All right, your next witness.
Your Honor, Mr. Depp calls Candy Davidson Goldbraun, who is the corporate designee of the Children's Hospital of Los Angeles.
All right, and that's by deposition, is that correct?
Yes, Your Honor.
Okay.
All right, still with me, trial attorney and former criminal defense attorney Erica Wilson. Erica, I'm a little confused by that witness, okay? We had heard that her testimony was going to basically contradict the testimony of Whitney Enriquez, Amber's sister, about the staircase incident. What's clear is there's an email exchange where she's imploring Whitney to do the right thing, which I would imagine has to do with what we thought she was going to say, which was Whitney came to her house after the incident, and apparently over the course of a couple of days told her that it was actually Amber that was the aggressor in that situation and that she hit him and it didn't work out the way she says on the stand. What exactly do you think happened there, and that we were only allowed to see that part of her videotape deposition?
Well, this is rebuttal, so you can't just throw everything in the kitchen sink. It has to be directly related to the issue that you're trying to rebut. And if you recall, Amber Heard's sister, went on and on about Ms. Howell, how close they were. So I think this email is very pivotal, especially when you look at the fact that she's saying, hey, we were close, we were friends, and I reached out to her. I said, hey, you need to do the right thing. So I think this limited scope of her testimony is going to be very impactful.
So I would imagine they were verifying the email exchange. That email exchange, which we didn't hear read, will ultimately be allowed into evidence and the jury will see it? Is that what's going to happen here?
It would have to, because again, if they're allowing this part of her testimony to be in, the foundation at this point would have already had to been laid. There's so many exhibits that these jurors are kind of going to get lost in translation, but I do anticipate that the actual emails will have to come in.
All right, so let's say they come in and let's say they say what we think they're going to say, or what she testified to in the UK was that Whitney told her that things went down very differently than she expressed on the stand. I would imagine that's what she's referring to when she says she was getting ready to do something very wrong. If that is in fact the case, what impact will this have on Amber's case?
It's going to blow it up because her credibility will be shot. Because again, her sister has already testified, hey, Jennifer and I are friends, we're very close, she's almost like a sister to me. So I think that her testimony via this deposition is going to carry a lot of weight, and it's definitely going to show that her sister as well as Amber Heard are not credible.
And the other thing it does, and we talked about this last time you were here, this staircase incident is very important because apparently what happened here resulted in some injuries to Amber Heard. He apparently grabbed her, according to the testimony, grabbed her and was hitting her. She ended up with those black eyes, et cetera, et cetera. If in fact her credibility is shot on that incident, it would suggest that she doctored photos, that she did all these things. So I think it has a real sort of domino effect on all of her stories, wouldn't it?
Absolutely, and I think that's the particular reason why this witness is going through such detail and trying to explain that, because I believe she was asked, did you ever even see any pictures? So again, it's definitely going to call into question, well, where did these pictures come from? And if everything else in her story is not credible, then the jury will only have to come to the conclusion that the photos were doctored.
Yeah, and they're not going to like her for that, for sure. And when you start looking at all these other incidents, there were 14 of them. I think they all, again, fall like dominoes. All right, we're going to have much more testimony when we come back. As you heard, they're beginning to call one more witness. We'll get you back into the court when we come back. Keep it right here on Court TV. and welcome back to Court TV Live. I'm Michael Ayala. Quick note before I send you back to the courtroom. You know, throughout the day, we hit the pause button so that you don't miss anything in the courtroom. So we're actually behind what's happening live in the courtroom. But that's neither here nor there. Again, we do this just so you don't miss any testimony. Where we are right now is taking the stand is Candy Davidson Goldman. Now, she is someone who is for the Children's Hospital. She's being called on the rebuttal case again of Johnny Depp. So let's get back into the courtroom as it begins her direct examination.
Here to testify today on behalf of the Children's Hospital.
Correct. Yes.
Okay. So as of June 2018, had any payments been made by Ms. Heard to the Children's Hospital in connection with the $3.5 million pledge, aside from the original $100,000 check from Mr. White in August of 2016?
Yes, there was a payment, a gift on January 9th of 2018.
And what amount is that gift that you're referring to?
$250,000.
Okay, and was that gift made by Ms. Heard or on Ms. Heard's behalf?
By Ms. Heard.
Okay, and what are you basing that statement on?
By the check that we received from Fidelity. Fidelity charity that came to Children's Hospital.
What is this document?
The letter to Mr. White from myself inquiring about further installments on the pledge that had not been fulfilled.
And why did you write this to Mr. White on June 14th, 2019?
I was trying to figure out if there were any other payments coming from Mr. White to fulfill the pledge, because the Children's Hospital Los Angeles had not received any other correspondence from him.
And what is this document?
It is a letter to Ms. Gottlieb from myself on behalf of Children's Hospital Los Angeles, inquiring about additional gifts, pledge payment installments.
This letter appears to be directed to Miss Amber Heard, care of Jody Gottlieb. Is that correct?
Correct.
Who's Jody Gottlieb?
In the Children's Hospital Los Angeles records, Jody Gottlieb was our contact.
All right, so Ms. Goldron, she's with the Children's Hospital. If you remember, Amber had pledged to give half of her divorce settlement, $7 million, to the Children's Hospital. And apparently this was testimony about how much they actually received, about $250,000, and they were still waiting for more. Let me bring back in Erica Wilson, trial attorney, my guest for this hour. I want to look at the bigger picture now and ask you, how do you think so far Johnny Depp's rebuttal case is going?
Again, I will say it again, I'm not that impressed so far. Again, they are belaboring these witnesses. Some of these witnesses, literally 1-2 questions, you hit them hard, and you get them out. I think they're going to, the jury fatigue is going to set in. I think they need to end with a big bang, but hopefully with Kate Moss and some of these other witnesses, and preferably Johnny Depp, they will be able to get that. But so far, I think they're belaboring a lot of these issues.
Yeah, my understanding from the field and our field producers out there is that they will end with Johnny Depp. I mean, there's really no better way to go than that. Your thoughts on that?
Oh, absolutely, because he's the star in real life, and he's the star of this trial. And so the jurors love him, the judge loves him, so I think that's the best choice at this point.
Yeah, no question about it. So right now, if you had to say who's winning this trial, and oftentimes I'm a little loath to do that, but it's the way we sort of keep score in these cases. Where would you say they stand right now?
I say Johnny Depp has a better chance, only because he can show definitively that he did have a loss, only through Disney. But I think it's going to be a toss-up with both of them, especially with Amber Heard and Aquaman. Her career went down because she didn't get along with the star. There was testimony to that. There was some testimony for Johnny Depp that, his diva-like antics kind of led to that. So I think all things being considered, I think the ball does still tip in Depp's favor.
All right, now, in terms of proving whether, in fact, it was the claims of Adam Waldman, who was Depp's attorney, I think that's a big problem for Amber Heard in her lawsuit, her $100 million lawsuit, because clearly it showed, I think one of the things that went well on rebuttal was this idea that it really wasn't Adam Waldman's comments that caused her decline.
Exactly. Again, so it was her own actions, her own relationships on sets with other stars is what led to the decline. What hurts her is that she also had witnesses that said, hey, she should have been a bigger star after Aquaman. And so now, here you go, you're not the bigger star, but not because of what Johnny Depp did or his attorney did, it's because of your own actions.
Do you think she has a career after this at all?
Maybe not here, maybe abroad. I think maybe on the smaller screen, but I don't. It's going to take her a while to recover from this.
Yeah, I would have to say so. But Johnny Depp now, on the other hand, with all the support he's seeing, I think he has a perfect chance to sort of revive his career.
Absolutely, and he's a bigger star. He has better longevity. She was very new and up and coming, so it's easier for her to kind of fall back into like TV roles and lesser known roles. But historically, he's been a star.
Yeah, and you know, they're coming down to those pivotal moments, so we'll have to see how it all shakes out over the next day or so. Erica Wilson, thank you so much for joining me. Truly appreciate it. We'll have you back again soon. Now, after the break, we're going to continue to break down the defamation trial of Johnny Depp and Amber Heard right here on Court TV, your front row seat to justice. Hello and welcome back to Court TV Live. I'm Michael Ayala. Thank you so much for being with me this evening. And it is day 21 in the dueling defamation trial between ex-spouses Johnny Depp and Amber Heard.
Good morning. All right, it's my understanding that defense is resting. Is that correct?
Amber Heard rested her case this morning, and Team Depp is back at the helm presenting their rebuttal case. They started off strong by presenting witnesses that contradicted Heard's final witness regarding the reason for the decline in Heard's career. They claim Depp's attorney's words had no bearing in her minimized role in Aquaman 2. We left off with a representative for the Children's Hospital of Los Angeles on the stand. Let's get back into the courtroom for her continued direct examination.
Send this letter to Ms. Heard and Ms. Gottlieb.
I was trying to see if the pledge was going to be fulfilled or not.
In your experience, is it common practice for anonymous donors when making donations to, in one paragraph, state that they wish to remain anonymous, and in the very next paragraph, identify themselves?
Yes,
That is common?
it is common for donors to want to remain anonymous publicly, but allow the charity to know who they are.
Between June 2018 and the dates on which you sent the letters to Ms. Heard and Mr. White in June of 2019, were any additional funds received from Ms. Heard?
No.
Okay, so as of June 2018, a total of $250,000 had been received as far as the Children's Hospital is concerned from Ms. Heard. And that was the same amount that had been donated a year later in June of 2019. Is that accurate?
Correct.
As of the date of this deposition, March 30th, 2021, how much in total has Ms. Heard donated to the Children's Hospital?
For this particular gift? I mean, in her lifetime?
From 2016 to present.
$250,000.
Ms. Goldbrun, do you recall we were speaking about this letter a few minutes ago?
Correct.
All right, and this was a letter that you sent to Ms. Heard, correct?
Correct.
Did you ever get a response to this letter?
No.
As of October of 2018, how much money had Ms. Heard directly donated to the Children's Hospital?
$250,000.
As of March 30th.
I'm sorry, I didn't hear the end of that.
Sorry, I just realized. You said October 2018?
Correct.
Okay, yeah. $250,000.
Okay. As of March 30th, 2019, how much money had Ms. Heard directly donated to the Children's Hospital?
$250,000.
What is your understanding of the length of time over which Ms. Heard pledged the gift of $3.5 million to Children's Hospital?
There was no date arrangement with Ms. Heard to have this pledge paid off in a particular time.
If Ms. Heard were to pay this, the rest of the $3.5 million in 2 years or 5 years, would the Children's Hospital welcome that?
CHLA welcomes every and any donation that comes its way.
Has Amber Heard's pledge of the $3.5 million to Children's Hospital expired, to your knowledge?
Not that I'm aware of, no. It has not expired.
All right, thank you. Your next witness, or?
Your Honor, I think we've concluded our witnesses for today. We will have more live witnesses tomorrow.
Okay, all right, ladies and gentlemen, that'll be the end of your day for today. Again, do not do any outside research, do not discuss the case with anybody, and we'll see you tomorrow morning at 9 a.m., okay? Thank you.
All right, looks like they're wrapping up for the day there. And again, this happened a little while earlier. We hit the pause button throughout the day, so it puts us behind a little bit so you guys don't miss anything. But anyway, let me bring in my guest for this hour. Criminal defense attorney Mark O'Mara is back. Mark represented George Zimmerman in the Trayvon Martin shooting trial. Also joining us is from Hampton, Virginia, is prosecutor and Commonwealth attorney Anton Bell. Gentlemen, thank you so much for being with me this evening.
Great to be here. Great to be back.
Thank you for having me.
Yeah, great to be back, Mark. It's been a while. Great to see you again. I know you're a busy man.
I've been in jail or something. I haven't seen you in way too long.
No, well, you've been busy. You've been doing your thing and back on the show, so it's great to have you. Actually, both you guys. All right, I want to start off by just getting an opinion from both you guys as to how this case is going. I haven't had either one of you as a guest on this particular case, so let me start off with you, Mark. Just general thoughts on this whole dueling defamation suit trial.
Well, unfortunately, we've now gotten to the point that something like this is now playing out and constantly in every little nuance of a relationship and a divorce and everything else over, and it's now playing out, with us on Court TV and other channels that's covering it. And it's almost a little bit sad, quite honestly, because every little nuance of everything they did and every yell and every scream and maybe some domestic violence one way or the other or both ways, there's just a sadness in my heart that the system that I've given my life to almost feels like it's being, I don't know, minimized, ridiculed, something unsavory is in the back of my brain as to the way this thing is being sort of handled by the parties. The lawyers are doing a great job, the judge is doing a great job, the media is doing a great job of covering it, but the parties I'm just not all that thrilled with, I guess.
That's an interesting point, because you got to wonder if the jury's feeling the same way. Anton Bell, your general thoughts on this case?
So basically what we have is the unveiling of a very toxic relationship, and they are holding nothing back and revealing some of the more intimate details of this relationship, how it occurred, what it was like while they were in it, and how it began to deteriorate. The unfortunate part about it, I think really for Ms. Heard, is Johnny Depp has more of a celebrity status than she does. So when he came into this courtroom, he already had, I think, an advantage and an edge. And after presenting his case, I think she had some things that she had to make up. Even though he admitted that he was a drug addict and he was an alcoholic and that he may have had some unsavory moments and even characteristics. Nonetheless, one of the things that he continually denied was he never physically or sexually abused her. The bad part about Ms. Heard's case is there's been some things that have come out that made you want to question her credibility. And now, even with this last witness that you just showed, where she was supposed to give $3.5 million to this children's hospital as a result of the divorce negotiations, and she's only given $250,000 to date, and it's been quite some time has elapsed, you have to now begin to question how much do they believe the things that she has shared, because little by little they are picking apart her character for truthfulness. And I can't wait till Kate Moss testify tomorrow, because I think it's going to just blow everything out the water.
Now, Kate Moss is an interesting study for me because, Mark, she's going to come in and testify that something that Amber had thought happened didn't really happen. So she said that when the situation happened around the stairs, which is turning out to be a pivotal situation in this trial. We'll get to that in just a minute. But that whole situation, she acted very aggressively and hit Johnny Depp because she was thinking of something that might have happened with Kate Moss. The general knowledge in the media, the way it sort of was portrayed, was that he did something to her. She's going to come in and say he didn't actually do it, but I'm not sure how much effect that's going to have on her and her state of mind, because at the time, she believed that something like that had happened.
Sure. If we look at it from a pure evidentiary standpoint, as lawyers, tend to do, it's like, well, okay, if Ms. Heard believes something happened, even if it didn't happen, then her response to that perception we should consider. And that's great if lawyers are talking about it around a table or on a show like this with you, Michael. But the jury and the public, which is the secondary jury in this case, are going to look at this and say, wait a minute, Amber Heard said she did this because Johnny did this to Kate. And it never really happened. So, as again, I was just stated by Anton, you know, when we have a case, we're looking at it going, who do we believe? And credibility is paramount in most trials, certainly in this one. When we look at this and say, who do we believe? And unfortunately, who do we like better? Both of those seem to go in favor of Johnny Depp as opposed to Ms. Heard. And the reason why is things like this. It's the $250,000, which, by the way, is an extraordinary amount of money to give to a charity, but not when you say I'm going to give him 3.5. And when you say I reacted this way to Johnny Depp because Johnny did this to Kate Moss, and it's like, no, he didn't, then again, it's that chipping away at the credibility that's going to undermine Amber Heard's general credibility and therefore, you know, desire for the winning of the lawsuit in front of this jury's minds.
Yeah, and Anton Bell, I think Mark is exactly right, and that gets me back to that staircase incident. We saw someone testify today where there was an email exchange. They didn't get to read that email exchange on their videotape deposition, but we know in that email exchange, basically, she states that Whitney was doing something really bad, and that really bad thing was perhaps lying on the stand because she had told Hallwell, that the whole staircase incident happened very differently than the way she testified to it on the stand. If the jury is able to read that email exchange and see that Hallwell says, she told me something very, very different, and that it didn't happen the way she did, and the credibility of Amber Heard is sort of beaten down on this major incident, this staircase incident that had injuries and all these other things, I think the case really, it falls right there.
It's over. At that point, it's absolutely over because, again, they have been systematically chipping away at Amber Heard's credibility. And so if that email comes in, or if the contents of that email comes in and it directly contradicts what Amber Heard said occurred, on top of the fact that we have all these other smaller incidents where they have been chipping away at her credibility for truthfulness, in addition to Kate Moss coming in and testifying that what she alleged had occurred in Kate Moss' relationship with Johnny Depp absolutely did not occur, I think it's ball game.
Yeah, it has to be ball game. Let's take a quick listen to Whitney on the stand talking about that staircase incident.
Please continue. They're saying horrible things to one another. You know, he's calling her a used up trash bag, you know, whatever. They were saying horrible things to one another. She was calling him old and fat. It was a fight. They were saying really nasty things to one another. I leave them in the kitchen to go up the stairs. I was trying to calm Amber down, hopefully get her back into my apartment. And Debbie had come up with me.
And Debbie, who's Debbie?
Debbie was his nurse at the time.
Debbie Lloyd?
Yes, I believe that was her name.
Okay.
So we're with Amber on the mezzanine level.
I'm sorry, just so we know who where is. Is it you and Debbie that are with Amber, or is it?
Yes, Debbie, Amber, and I are all in the little mezzanine area. And as I mentioned, the mezzanine overlooks the kitchen and the living room. So Johnny then hurls a Red Bull can and it hits Debbie in the back. She didn't even react. She didn't really seem to notice. But I'm standing up there talking, I'm at the top of the stairs with my back to the stairs. And that's when Johnny runs up the stairs. And again, I'm facing Amber. He comes up behind me, strikes me in the back, kind of just somewhere over here. He strikes me in the back. I hear Amber shout, "Don't hit my sister." She smacks him, lands one. And then he grabs, at that point, that's when Travis runs up the stairs after Amber landed one. But by that time, Johnny had already grabbed Amber by the hair with one hand and was whacking her repeatedly in the face with the other as I was standing there. Travis pulls them apart. I get Amber into mine. I close the doors behind me and lock them. I then hear Johnny's voice shouting.
Never mind, withdraw. Okay, sorry.
I hear Johnny's voice shouting, I hate you. I hate you both. and I hear crashing. I hear crashing and banging and smashing, and he starts screaming like an animal. And I then just moved Amber into the next room, and I just kept her there all night. The next day, I go, and I see her closet has been completely destroyed.
Now, of course, there's two separate stories there. Johnny tells a very different story, that Amber was the aggressor trying to get at him through a Red Bull bottle, a Red Bull can at him. So ultimately, Mark, if a trial is a search for the truth, whether it's criminal or civil, what's the fundamental truth that we're trying to get to in this trial? Did Amber lie? Is it who was abused? Who was the aggressor? What's the fundamental truth that we're trying to get to in this trial?
And, you know, and the question is such a perfect one, Michael, because that is what this jury has to be struggling with. If you look at the pleadings, as we all have, we know what the lawsuit is about. You defamed me and that cost me money and I want money back. No, you defamed me and cost me money and I want money from you because of what you did to me. Based upon the allegation by Johnny Depp suggesting his false allegation of domestic violence and all of that. So to get to all of that, this jury has got to wade through an enormous amount of this information, some of it incredible on both sides, some of it completely disparate, doesn't seem to make much sense, and some of it very, very conflicting. So we know if this was a criminal case, we'd all be sitting back going, there's no way this guy's getting convicted of anything because there's reasonable doubt all over the place. Different standard in the civil context, this jury almost has to wade through and say, you know what? Did somebody win by 50% plus a feather, right? Plus a little bit more than 50%. But I got to tell you, by the time this is done, this jury may sit back and go, we're done and we're out of here. Nobody's getting anything. We're done with the sideshows. We're done with the drama. Nobody's proved enough of anything to allow us to give a verdict, and may just decide that.
You know, everyone seems to feel that way. I think the general consensus across most of my guests during the length of this trial thinks that's the way exactly this jury is going to go. We'll see. It's coming to an end by the end of this week. All right, guys, stand by. We do have to take a break. But before we go, here's a quick reminder. Join me as I bring you a special edition of Testimony of the Day. We're going to get you caught up on the best moments from today's testimony. That's right here, starting at 7 p.m. Eastern, so be here for that. Still to come on Court TV Live, we're going to take a look back at Dr. Spiegel's testimony with our own doctor's opinion. And then, later in our Talk Back segment, who are you most looking forward to testifying during this last week of the Depp v. Heard trial? Let us know what you think, and we'll share some of your comments later on in the show.